Hi, guys. Good morning, everybody, or good afternoon, good evening, wherever you are. It is day 163 of the YSL trial, and I think we have a lot more cross-examination of investigator Marissa Viverito. We have some non-jury arguments today, so we're going to check those out. We'll catch up because they have breaks. We'll be caught up in no time. So good morning to everybody. Let's get into it.
Lyrics on top that makes, and just to put in context, I believe that investigator Viverito said she collected off the internet a day or two after the Chamel Drinks shooting, and it says essentially I ride or roll with some real life killers. Right. Something I'm paraphrasing. And obviously that is, as they're saying, that Mr. Nichols was in the car next to Mr. Stillwell at the time that Mr. Drinks was shot. That's a big piece of evidence. That's not exactly how it appeared on the internet. And I'm going to go back to about a week ago, 2 weeks ago, where I kept saying we're on the 98-yard or we're on the 2-yard line. And I just have all these things that are dumped in this folder, and I don't know what they are. I don't know when they were collected. I don't know the circumstances. It turns out that there was a collage on my story, which is a thing on Instagram. I'm not big on social media, but this is how it's been explained to me. There's my story. There was a collage of different, different random thoughts, like Mr. Nichols is on a roller coaster. Mr. Nichols is saying that he's not feeling well. And it's just a bunch of different things that are kind of one after each other, lasts a minute and a half. Within that collage, I'm to keep saying, there's a post where this song is playing, and Mr. Nichols is there, bobbing his head to it. It's Young Boy Never Broke Again. The song is Villains. In the collage, and we can play it, it's a minute and a half. In the collage, there are lyrics from Young Boy Never Broke Again, that song, because when you put on Instagram, it displays the lyrics as the song plays. It appears to me that Mr. Nichols didn't choose those lyrics. He chose the lyrics directly afterwards. But before those are displayed, the I ride with some real killers or whatever is displayed for a millisecond. You'd have to rewind. You'd have to go through it and pause it at an exact point to even be able to read it. Okay, so and of course, Investigator Viverito doesn't write any reports, so I had no concept that the still picture of I ride with some real killers and this collage were correlated in any way, or that one came from the other. So then we were doing the pretrial litigation about what we object to. I objected to the collage on relevance grounds and hearsay, and quite honestly, I didn't see what the relevance was because it was just random thoughts of Mr. Nichols. And then I objected to the still photo based on hearsay. Prior to the litigation, I'm not suggesting that the state did this intentionally at all. They took out the collage before we litigated them. They took out the collage but kept in the still. So when it was time for us to litigate, the only thing that was in the folder, in the updated folder, was the still, and no one had made it clear to me that these two things were correlated. Mm-hmm. So then I argue against the admissibility of the still, saying it's hearsay, and Your Honor said no, it's a statement in furtherance of a conspiracy, so you let it in, but we never even talked about the collage anymore. So then we get to trial, and the state puts in the still with these very problematic lyrics just displayed without any context or explanation of how Investigator Viverito obtained that. Now, and here's the other thing. The collage was collected on the 10th, or excuse me, the 16th, 15th or 16th, the day or two after the Shamel Drinks murder. There's no indication from what I can tell that the individual pieces from the collage were not posted earlier. So the individual pieces from the collage may have been posted before the Shamel Drinks murder, which of course is, you know, very relevant. I'm not going to lie. I was prepared to go up there and hammer these points home and say that Investigator Viverito selectively paused this and didn't provide any explanation to the jury, and I was going to go after it. The state and Mr. Abadi, and we've had discussions, and I can see from their perspective that they took it out based on my email, and they took out the collage video, and there was probably some miscommunication between the two sides about, again, I never even knew that they were correlated. So I do acknowledge, you know, I take, you know, I do believe what they're saying, and they're saying, well, we kept it out because you objected to it.
Right.
So just like earlier in the trial where I put something in the evidence that had a blank bubble for the date, and then it turned out, well, that was based on rulings. It wasn't me trying to deceive. I just want the truth out at this point. So my suggestion is I'm going to leave it alone on cross, and then the state on redirect, if they don't want me to go into it and create an impression, if that's what they want, I'll leave it alone on cross, and on redirect, they can have Investigator Viverito explain how this came to be and clear it up that it wasn't actually a post that looked like that, but it was part of a bigger post and all that. That's my proposal.
And that's fine, Your Honor. We can bring in, of course, okay. Sorry, we can bring in the video during our redirect of Investigator Viverito, and we'll bring in the entirety of and I want to be clear, Your Honor, this is, I know Mr. Schardt is calling it a collage, but it is the Instagram stories that we've referenced multiple times, that these stores are only kept up for 24 hours. And so on the top of the video, you'll see 18 hours, 1 hour. That is how long the posts have been up. And at the time Investigator Viverito screenshotted or video recorded the video, the post would have been within 1 hour of her actual screen grab of the video. So for example, she screen grabbed this video on March 16, 2022 at 9:53:19 p.m. The specific video that we are talking about was posted 1 hour before. So it would have been posted around 8:53:19 p.m. on March 16th.
The story.
The story would have been posted.
Right. Do you have any way to know when the individual pieces of the story were originally posted?
So that is when it would have been posted, because they only run in 24-hour increments. So when it says 1 hour, the post had already only been up for 1 hour when she screen grabbed.
So the whole story, I understand you're saying, was posted within 24 hours of the screen grab. What about the individual pieces of it?
So it tells you. So
do you understand what I'm asking?
I am.
Okay.
Let me share with you, because I think it's better if I show you and then I can describe it for you.
And big shout out to FFS out here sniping to get us started off with 3 gifted memberships before we even started the stream. Super nice of FFS. Make sure you guys are saying thank you if you got a gifted membership. And then Squirrel Brain Gang popping in here, dropping 5 more. Good to see you this morning. And I feel like I'm speaking to a plural when I speak to Squirrel Brain Gang. So thank you so much for gifting.
Are you able to see this, Sharon?
Yeah.
So if you see right here, Your Honor, it says 18 hours. If I- you can't see it. Okay, at the top, do you see where it says 18 hours? Would you see where it says, bitch, it's lizard?
The white, yeah.
So when it says 18H,
Yeah. Uh-huh.
that is 18.
Uh-oh.
Wake up.
That is 18 hours before she screen grabbed it. So here was this video, March 16, 2022.
Right, that had been up for 18 hours in my stories.
In his story. So when you go to the specific post that he is posting,
Oh, they're trying to get me early. Is this only one? It doesn't look like there's an additional story. So she's only showing a story with one thing. Oh, no, there are. Okay. It's just really hard to see.
so then 2 hours later, he posted this picture, which says 16H. And then 11 hours later, he posted this pic. So
I'm a bloody man on.
So then 10 hours later, so he kept posting on his story as time passed. And so this is 8 hours later.
Okay.
And this is what they want me to do on Steller Heights. I might die. Never get on another freaking roller coaster day in my life. Oh, you talking about?
Oh my gosh. There's a music every other clip. But that shows like you play like multiple songs. Dang. I get why Schardt wanted this out because it's just it's prejudicial to keep showing all these lyrics over and over and over, especially if someone on the jury like looks down on a certain type of music. And I get it, but at the same time, it would show that Viverito's dumb as rocks for screenshotting one still frame out of all of this. This is just one day of posts.
Stories that he had posted when she was grabbed. The video grab of all of the stories that he had posted when she was grabbing the Instagram.
Okay, and so I'm woefully ignorant about Instagram, but does a human being have to select what gets posted, or is it Instagram doing it?
So he's posted a picture, and then say if he wants that particular song, he can add the song, and then you have options when you add the song. You can either add the song with words, you can add the song without words. That is his choice, his or her choice, to add whatever content to put on the picture
Okay.
that they're posting.
Okay, and
Look at
so
Shannon.
at that time, it's not like it just pulls something that you posted, 3 years ago and says, oh, would you like to look at this today? Okay.
Then why did Viverito insist that he chose those words? That's not the same as having lyric captions on the screen. So she's either dumb for not knowing the difference, or it was intentional that she screenshotted something with specific words on the screen at that moment.
All right, so if y'all are resolved to handle it the way Mr. Schardt suggested, that,
Yes, we'll play the entirety of the video in regards.
okay.
And Judge, we want to make the record clear, we would have played it regardless, but it was objected to, and to be conciliatory and not waste the court's time and everybody else's time.
Yeah, I understand. And Mr. Schardt understands too. He just didn't understand that that's where the screenshot came from to begin with.
That's why law enforcement writes reports.
Why
Or
defense
not.
counsel watches all the posts.
Okay. Okay, so back to the charges.
I don't know. I still think the jury got what Schardt was getting at yesterday. I think she looked stupid the way she was.
I think we were on.
Doubling down.
Around page 18, bottom of 18, with parties to a crime. And I'd stated I was going to give it without limiting it to particular crimes. I just want to make sure that we don't have subsection D at all.
You're right, are you on knowledge?
I'm on parties to a crime on the page, for me, it's page 18, 19. One 1.42.10.
Yes, I don't think we need either.
Okay. Anybody disagree? We don't, D's not applicable? Okay. All right. So the next is 1.42.11. Defense objects to that. You want to voice the reasoning for objecting? Y'all need a minute to get there.
I'm here, I just have some reason
Here.
missing pages.
Look here.
Do you think the state's happy about
The principle.
Young boy's plea?
I don't think that's applicable to this case. I don't think that it fits the evidence in this case. I don't believe that there's even slight evidence that the principal has not been prosecuted.
So we've got a, number of different crimes. Including RICO, 2 murders. Let's see. And then I guess gang counts and gun counts for Mr. Stillwell. And then for Mr. Kendrick, RICO, 1 murder count. A gang count, and then several drug counts and a gun count.
I just don't know, in all those cases, I don't know of any principle, the murders, who they're saying were involved, everyone's being prosecuted, as far as, Mr. Kendrick in the house, in Mr. Williams' house, Mr. Williams was prosecuted, so I don't see any.
They don't know that. They don't know what happened to him.
They don't know what ultimately happened to him, but they do know he was charged, and my understanding, the way I read this instruction is just, if a principal's not charged.
Well, that's not what it says. May not have been prosecuted or convicted, may have been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. It's like any of those options.
But he has been prosecuted.
It's not, and all of these have to apply. It's in any of these. And with regard to the Donovan Thomas murder, I mean, who knows what the jury is going to think, but it certainly could be applicable to that.
It could be acting in the RICO count, but can I fill in?
I think it's applicable. I'm going to give it over objection. All right, knowledge. What would this apply to? Because we're supposed to fill in the blank.
No, I don't think we need the knowledge charge. Or we, I should say.
I mean, it kind of seems to pair with parties to a crime.
In RICO, you know, if the jury believes that, I'm not saying that the evidence has shown this, but I don't know what the jury's going to, the way that the jury's going to analyze the evidence, but if the jury believes that if they believe that Mr. Kendrick or Mr. Stillwell, you know, had knowledge of an organization called YSL, but were not actively involved themselves, were not actively doing things in furtherance of the RICO organization, I believe that that would apply.
Okay. Any others besides RICO?
Potentially, you know,
If it's everything, I'll just say the crimes, you know, that the defendants are charged with, but
for instance, with the murder of Donovan Thomas, they've shown Mr. Kendrick at the Texaco, a video of who they say is Mr. Kendrick at the Texaco. I know it's a lot of debate whether he was actually in the Infinity or not, but I could see it applying there as well. You know, Mr. Kendrick is quote unquote in the mix at the Texaco, but not actively participating in any crime that happens 5-10 minutes later. You know, and I don't know how the jury is going to analyze Mr. Stillwell on Windsor Street, but obviously he's in the area, and obviously I'm going to be arguing that he was not the shooter. So I think that it would apply there as well.
all right, how about to the drug counts for Mr. Kendrick?
Yeah, potentially there as well, Your Honor, if there's some theory that Mr. Kendrick had knowledge of the drugs and guns in Mr. Williams' house.
All right, the gun charge, is that based? He's got the one gun charge, right? Or does he have two?
Let me look at the indictment again. There are multiple
57.
charges related to the guns.
Okay, so he's got
He
the,
has two.
Well,
He has three guns.
yeah, he has a bunch of them. So
his is based on, okay, the machine gun that's found during the raid, if you will. And then,
there's firearm during commission of a felony in 61.
right, but all of that is if they find that he, you know, was guilty of possession of the machine gun and the drugs, whatever, then he's also,
Right, that's like a foundational thing they have to initially
right.
find.
So I would think it would honestly even kind of apply to that, although I don't know. Like the firearm he's alleged to have possessed is the firearms that are found during the search?
Yes,
Is that right?
that's correct.
Okay. All right, so with regard to giving this as to the RICO count, I'm not sure it's an accurate statement of the law for what RICO is, because if you're found guilty, or you can be found guilty of conspiracy to violate RICO, even if you don't know exactly what your co-conspirators might do in furtherance of the RICO conspiracy.
But you do have to intentionally join in on
Yeah,
that
but
conspiracy.
we're going to give specific separate charges about, you have to, about what you have to know to be found guilty of RICO, but it's not, this is not exactly true for RICO.
Not for the individual acts, each individual act.
Right.
I agree with that.
The state agrees as well.
But they're, well,
So it certainly applies to the murder counts, I would think.
and the guns and the drugs as well, I believe.
And the drugs, the guns, it's really like if they're found guilty of, like for instance, with Mr. Kendrick, if he's found guilty of the drugs and the machine gun, then he's also guilty of possession of a firearm by a convicted felon. But if he's not found guilty of either of those things, they can't be found guilty of possession of a firearm by a convicted felon.
Right, that would be an inconsistent verdict for sure if that happened, but
What are,
let me see.
for Mr. Kendrick, it's
It's all the weaponry. It's
it's
all-
all of
it's
the firearms that were in
Yeah.
Mr. Williams' house. But is he charged separately with possession of those guns, or it's just that?
Just.
Okay,
only
so,
thing charged separately is the machine gun.
okay, so, all right, then I guess if he's found guilty of possessing them, then he's found guilty of possessing them as a convicted felon.
So I'm trying to understand where the court has come out on whether that knowledge instruction applies to the gun and drug charges against Mr. Kendrick from what's at Williams' home.
I mean, there's the whole constructive possession.
Right, there is,
Law.
I understand that, and there's an instruction, I think there's an instruction on that.
There should be.
Um,
If there's not, we need to put one in.
I believe there is. But there's an intentionality in the constructive
Yeah.
possession as well.
Why don't we put a pin in this one and come back to it? So I don't think it can apply to RICO. I do think it applies to murder. Gangs? I don't
Well, the
think it could apply to gangs. They either,
the gang charge against Mr. Kendrick, let me make sure I'm saying this correctly. With this 57, it's count 57. It's based on the,
possession
it's
of
based on
the
the drugs
guns
and
and
the
the
guns.
drugs.
Yes. Everything comes back, everything is founded on the drugs and the guns, or based upon
Okay,
that.
so, right. I mean, the same for Mr. Stillwell. It's gang activity if he's found guilty of these crimes that would constitute gang predicates. Okay, so we'll just come back to that after we look at the kind of constructive possession charges. Okay. But it'll at least say, at the least, murder. All right, and so part of this knowledge charge includes a parenthetical that, if you weren't knowingly and intentionally committing, participating, or helping in the commission of, or were not a conspirator in, then it would be your duty to acquit the defendant. So the state's certainly alleging that everybody is a conspirator in everything if they are in the RICO conspiracy.
And I think the court asked the question, we need to define it here.
Yeah.
I don't think you need to define
I
it.
think as long as we define it somewhere. Okay. All right, and then mere presence, everybody agrees. Mere association, everybody agrees. Multiple ways of committing a crime. It was requested by the state. Is there any opposition?
Well, we were talking about this on a call on Sunday. As I always understood this charge, it was like for aggravated assault, like 2 different ways you can commit assault and it's charged. I don't know.
We have it here in RICO because we've got RICO subsection A conspiracy and RICO subsection B conspiracy. I think that's the only place we have it. And so I would think this should come, within the explanation of RICO. Does everybody agree that's the only place it is here? Okay. So we'll give this charge, but it'll be within the RICO. And let's just skip over RICO for now. So we'll have to come back to that. All right. Attempt.
Which page is that, Your Honor?
I'm page 24, 2.01.11. So y'all had mentioned at some point needing to give some sort of a charge on every charge, or, a definition for every charge that is an overt act, but also a crime. Y'all still thinking that? Because I guess that's where attempt would fall.
Yes, Your Honor.
I don't see how else the jury makes the determinations of whether the overt or predicate acts were committed.
All right,
unless they
well,
have
I
the
don't think
definitions.
anybody has submitted what those charges should be, so y'all need to get those put together like today. All right, so attempt will go wherever attempt goes in the explanation of the various overt acts. Okay, down to 2.0210, conspiracy, and then conspiracy additional instructions. Everybody agrees on those. Conduct and presence of the party, everybody agrees. Okay, criminal gang activity. I have now made some suggestions. Y'all can see where things are rephrased. I don't think we have, on 2.0225, we don't have any allegation that anybody is employed by the alleged gang, right? It's just associated with, so I've stricken through employed by. Everybody okay with that?
Yes.
All right, and then instead of, everybody okay with commits crime that constitutes criminal gang activity instead of the mumbo jumbo that is the pattern?
Yeah, I agree with the move to plain English there.
Okay.
Is that the highlighted portion?
So instead of participates in criminal gang activity through the commission of any criminal offense in the state of Georgia or any other state of the United States that constitutes criminal gang activity under OCGA 1615.3, just say, commits a crime that constitutes criminal gang activity, since we're going to define that in a minute anyway. All right, and then next thing we do is criminal gang activity means. The commission, attempted commission, conspiracy to commit, and then there are also possibilities for solicitation, coercion, or intimidation of another to commit. Do we have that solicitation, coercion, or intimidation alleged in this case? Okay, so I'm striking that. And then are y'all all right with the way that it's proposed there to just do kind of bullet points of to prove a violation of subsection A is alleged in 50 and 57?
Yes, Your Honor.
All right, and then element 4 would be a nexus between that crime and the gang. I'm not sure, most people might know what nexus means, but it's not like a word everybody uses. So I would kind of think it would be more helpful to the jury to include a little bit more than that. So what I did some research and found in 2 cases, Dixon and Rooks, where nexus was explained to be a connection between the crime committed and the gang, which we could say that way, or a nexus, a connection. We could also add that the crime was committed to further the interest of the gang. Now, Mr. Weinstein, I noticed that you had objected to the pattern on that, which, oh, okay, I'm sorry.
I was taking
Mr.
notes,
Schardt,
both of us. Your Honor.
the pattern says a nexus between the crime committed and the gang, that the crime was committed to further the interests of the gang, meaning proof that the crime committed was the sort of crime that the gang does. Are you just objecting to that last clause or also that the crime was committed to further the interests of the gang?
I'm objecting to the last clause. It
I
does-
couldn't find it anywhere in the case law that that's what it
Okay.
meant, so I agree with you. That should not be pattern.
So we're gonna
Goes back
strike
to
was the
Kimberly
sort of
Underwood's
crime the gang does,
lifestyle
Your Honor.
quote.
Yeah, so the choice at this point is a nexus between that crime and the gang. I could say a nexus that is a connection between that crime and the gang, or I could just say, or a nexus that is a connection between the crime and the gang. In other words, that the crime was committed, or that the crime was committed to further the interests of the gang. I mean, like basically any of those, any combination of those. What is the preference of the parties?
Can we write that? So I
It's in front of you. It's on the bottom of page 29.
She is on one today.
If you have the electronic copy up that Ms. Percifield sent y'all I don't
The
know,
language,
yesterday
the
morning.
language you have now is a nexus, comma, that is a connection, comma, between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Yeah, that's just some language I pulled from Dixon and Rooks explaining what nexus meant. So I'm just saying we could use any of that and it would be.
That language is acceptable to
Okay,
Mr.
so
Kendrick.
you want me to just say it all?
Just exactly like it's written is
Okay,
fine with Mr.
so I'll
Kendrick.
just bullet point or whatever, element 5 will now be that. All right,
Yes, Your Honor.
Yes.
okay, you got it, Laura. Okay. All right, definition of participate, I'm kind of thinking, unless somebody on the jury says, what does it mean by participate? That they know what it means by participate. Okay.
Yes.
All right, and then criminals, definition of criminal street gang. Are y'all okay with the strike throughs?
Lifestyle, they just need one person on the jury to say not guilty.
I'm not gonna
But
say
that would
it all,
be-
but-
If it's not unanimous, it'd be hung and there could be a retrial.
I'm fine with you. Say fine with you.
Okay.
Yeah, okay.
So I would, can you see it on his?
Your Honor, could you tell me the page again?
Page 30, bottom of page 30, definition of criminal street gang.
I think,
Okay, well,
Uh,
so
going on?
the
Okay.
criminal street gang means any, this is the pattern, organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal activity. And I'm suggesting that the same concept is conveyed by saying criminal street gang means any group of 3 or more persons associated together, which is engaged in criminal activity, criminal gang activity.
Okay. It's just formatted different on my page,
Okay,
but it's the
sorry.
same thing. No, it's okay, Your Honor. I'm fine with that change.
Can I just make one?
Yeah.
Which engages in criminal gang activity, which is
Uh,
already been defined for you. Because I don't want the jury.
Criminal
to
gang
take a-
activity as defined, have I already defined it by then? Yes,
In 25.
sure, as defined,
To take a layman's view of what.
as I just defined. Can you stick that in there? All right.
Or maybe as defined in 225 to be more specific. But
No, because
take
they're
it.
not going to have those numbers
Oh,
when they
okay,
get the
that's right.
instructions. They won't have the headings. They'll just have the
Thank
law.
you.
And then, you know, it'll continue with the existence of the gang maybe established by. And then the pattern suggests as charged in this case, criminal gang activity is, and then I'm supposed to list the crimes in the indictment that would constitute criminal gang activity, although I would only do the ones that they're alleged. So it would be whatever set forth in, I guess, 57, 50, 51, and 57, right?
Yes.
So as charged in this case, criminal gang activity, I think it's charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. 'Cause I think you're getting into
So
those
that would be
definitions.
murder. And 57. So it would be murder and then everything listed in count 57, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So question here, do you want me to say murder charged in counts whatever, or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence? No. Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation, y'all are in agreement, motive, agreement. Possession of a firearm during the commission of a felony. Y'all said you're going to tailor it. Let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged it both ways.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply?
Yes, Your Honor.
Right.
Okay. And then the drug stuff, as I so aptly put it, would be possession or possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute, possession of marijuana or codeine with intent to distribute, or possession of cocaine.
Yes.
All right.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing a felony, which is a crime involving another person or a crime involving possession with intent to distribute or possession of those particular drugs, and then say, I charge you that certain of those drugs are a controlled substance, or just say, just get to the heart of the matter, which is if you find he did these things, then that would be possession of firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs?
I think the latter, Your Honor, is
Yeah,
cleaner.
it is
Yes,
cleaner.
I think so
It's
too.
simpler.
Everybody agrees?
Yeah, I agree with Ms.
Okay. So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No.
Not for these two counts.
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count, for the two counts, count 63 and count 52, while we did charge 133,
Yeah.
it is missing an element. And-
It's missing the indictment is missing an element?
Yes, Your Honor.
That was going to be subject to motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 133.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence established has the elements
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you one more.
Glanville
So,
would not
either
have
it's
done
gonna
this.
be,
Whew.
in my view, 133.
Look
or
at Schardt.
nothing, unless y'all have law to change my mind. But assuming it's 133, I think it's possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm. But we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all drop the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like, the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. Tell Laura, just write me a note to rewrite it like the other ones are. Okay, 2.70.10. Y'all agree? So it's possession, right, of marijuana or, no, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay,
Um,
so it's possession of cocaine. The state must prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the state must prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance, it would say to distribute codeine, which is a controlled substance.
Yes.
Okay.
Yes.
And I'm sorry, I was typing. Can we go back to possession of machine gun?
Yes.
If you did not say, and I apologize if you did, I think we need to define machine gun, which would be 1611-121.
Let me see what 1611-121 says. Does it give me a definition of,
Yes, it does, Your Honor.
well, that's very helpful. And obviously, I'll let y'all look at it again after. We put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611-121. It's part of element 1. Yeah. And then definition of marijuana, everybody's good with that. Did we have testimony that whatever was found was marijuana?
I don't believe y'all introduced any of the lab reports, did you?
Detective Storno testified that it was marijuana. Now, there's no lab test, that's correct.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor,
Mm-hmm.
I apologize for not, the GBI analyst who testified about all the pills, she also talked about she tested the marijuana.
Okay. So my state must prove that defendant possessed the marijuana controlled substance or gun, right? Or gun at issue in this case.
I'm sorry, could you give that list again, Your Honor?
I mean, I would think it would be the marijuana, I can just say codeine,
Codeine.
cocaine, and guns, firearms, because it's a machine gun too, guns.
Yeah, firearm, there's a half a dozen roughly, so.
Okay, on equal access. I would think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
I mean, I'm fine with just possess, Your Honor, but
All right, well, since it's your client that's facing those charges, although not with the guns. Just possess and not put the items where they were found. That's an interesting one.
I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting. Or possessing, but that's neither here nor
Okay,
there.
if, moving down to 276.30, if you find that the defendant owned or leased the, where would,
What's the second
Mr.
paragraph?
Kendrick's is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio? Yes, no?
No.
What did I say?
Stillwell
Is it the reverse of that?
Yeah, he's not charged with it.
Isn't he charged with possession of a, oh, that possession of a firearm is if he committed murder with a firearm.
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 276.30 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know if.
It may not even be applicable.
Well,
I think
it-
it would be. I'll let Mr.
No, I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that,
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it or I can just not read that because it's not applicable.
yeah, okay, now I see what you're saying. Your
We
Honor.
could just say,
Yeah, I read it. So it probably isn't,
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
yeah.
where the, all
Drugs,
of that
guns.
stuff was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then that individual, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You may,
Okay,
I don't object
so
to
we
it
won't
being
give that
removed.
one at all. All right, affirmative defenses. The note is, defense believes this must remain. So I need some evidence
Go back.
to,
Mr. Stillwell keeps trying to trip me. So,
He has no proof of that.
Your Honor, I am taking a stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge. We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself. People are shooting at Woody. It's okay if he has a gun. And my stance is that we've heard testimony that people are repeatedly trying to murder Mr. Stillwell. Mr. Stillwell is charged with possession of the FN 5.7, and he's charged with that. And our stance is, while it doesn't, it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated
And
in
can
this
you
charge.
give me a second to find where that's his count, what, 52?
52 and 64.
No, he's not even. 52 and 64?
Yes, Your Honor.
Well, 52, 54, that one doesn't chart, that just is the murder. 64.
It really applies, if he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be, fall under instances of reason and justice. But for 64, when it's the standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you need to.
Hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the Drinks murder, right?
Yes.
Count 64 charges he possessed a gun on the 17th of March,
Yes. And that was on Meadowlark Drive. The
when
gun
he
that
was arrested?
right. The gun that the state is saying was thrown out the car.
Oh, which you've,
Registered to Miss Alexander.
okay.
And my argument is, if the jury finds that Mr. Stillwell was in fact carrying that gun around, and either he or Mr. Nichols discarded it out the window, 30110 F would apply. And the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that F is a reference to A through E. So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you know what, you're right, Your Honor, I'm sorry, you're right. It would just be F.
Okay, but here's the thing with the law, is that if he had been possessing a gun despite being a convicted felon, and somebody came up to his window and held up a gun to his temple and said, you know, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. You know what I'm saying? Because it's a specific reference to 16(3), 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's a Johnson case. It's the one that the Hogues argued, and was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense, even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. The difference that here, from my perspective, is person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun, then something unexpected happens and they use the gun.
Okay,
My
well, he
scenario-
knows somebody's after him.
Right,
Do
that's
you
the
have any
difference.
case law to support your
There's no
argument?
case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that, I mean, especially if Johnson is a case that says, unless, if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is in
Oh.
fact what Johnson says to
Okay,
my understanding.
well, I mean, unfortunately, potentially, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life, can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's
Well-
just not what the law is.
Of course, I'm going with the court and I respect the court. I would argue that that's what F is. That's why F is there. Because it says in all instances based on similar reason and justice. And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good legal argument. It's clever. State want to be heard?
That's just frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before and knowing that he had it after if he left with a gun, but he could be found immune from possessing the gun during the alleged whatever act he was justified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right, I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Sean.
All right, so we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all candid to court, then we probably don't need 30000.
Okay, or 31010.
Correct.
All right. And we clearly don't need 31011 because it doesn't even exist anymore.
I don't think we need any of these
All right.
justifications.
I don't either because they all are like basically if they're, so no 1-2 and no 1-3. All right, then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for RICO, y'all are both in agreement that the one that's listed is fine?
Yes, Your Honor.
Okay. Venue for conspiracy to commit a crime? Other than RICO, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So, do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms for 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want that at all. Because I believe that is, I think that's covered in the next.
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
And I don't believe that this is necessary.
Okay.
I'm sorry, now, which part is not necessary?
1.60.12. Do we need that? It's way too hot in here. The defense is no longer requesting it if they ever did. Is the state still requesting that?
You said 1.60.12.
Yeah.
Multiple defendants.
Right. given that we're given the charge below about assessing the evidence against each defendant that the state requested.
We don't need 1.6.
All right. All right, assessing the evidence. It appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it.
Yes, ma'am.
Okay. Court has no interest, no sympathy. Sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely a conviction.
well,
Come from the court.
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is, that's typically what the request.
People think they know what the penalty is.
Right, but I guess because the people think they may know what the sentencing range is or what the penalty is, which is a life sentence, a lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making, which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that for them to then think about. All right, and nobody has any issue with deliberations or unanimous verdict. State, there's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it, okay,
It can be argued, but it can't.
okay.
Of course not do a charge on it unless the defense requests it.
All right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah, page
you.
14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think? Anyone?
Our preference would still be to keep that knowledge charge in, especially, I understand that you,
I'm asking which crimes do I say it applies to?
the murder, the drugs, and the guns. Did I leave anything out?
I think D, all of the above.
No, I left out the RICO.
And the gang, which.
Well, the gang is,
It wouldn't even make sense for the gang.
no, so the murder of the drugs and the
Okay,
guns.
so knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count whatever, murder in count whatever, possession of whatever it was, drugs in count whatever. Do y'all think? Was being committed and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of, list them again, and that the defendant knowingly helped or participated, then you would be authorized to convict the defendant of that count, I'm going to add that.
Yes,
Okay.
thank you.
All right, anything else we said we were coming back to? Obviously RICO, but anything else?
I sent a proposed charge to Ms. Percival and council as it relates to count 51. Mr. Stillwell is charged with 1615-4 subsection B. And I've sent a proposed charge as it relates to that count. It's not covered by the pattern.
That being gang?
So the pattern covers 1615-4A. It doesn't cover B.
Isn't that in our gang? It's, if you look at what's there.
It's already in there.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus, in order to, there's an additional element number 4 in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right?
I completely.
Okay, it's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes, I
Thank
mean,
you.
we've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anyway. So yes, you can have until they get here.
Thank you.
All right, and we are caught up in real time. Schardt is taking the jacket off to get ready for the rest of this cross. I do want to, I try to, in the background over here, put together what was going on with this count 52 and count 63, as Hylton mentioned. I'm not sure if this error in the indictment applies to both counts. It's just Hylton listed off where 16-11-133 were charged in the indictment. But I did try to compile it. So what was happening there, where Whitaker was like, yeah, you're missing an element. So the state charged 16-11-33. And let's look at count 52, because this one definitely seems like it's missing to me, a layperson. I'm not a lawyer. So Shannon Stillwell, with the offense of possession of a firearm by a convicted felon, previously convicted of felony involving the use or possession of a firearm for the said accused. And notice here they're charging OCGA 16-11-133. For the said accused in the county of Fulton and state of Georgia on the 14th day of March 2022, did possess a firearm after having been convicted of felonies involving the use or possession of a firearm in a previous indictment. So this is a different indictment. Now, this is in Superior Court of Fulton County, Georgia, for the offense of possession of a firearm by a convicted felon on the 10th day of March 2016. And then this other indictment also possession of a firearm by convicted felon. So now we're missing, and Hylton agreed that it was missing, and judge was like, yeah, that's missing an element. There's missing this element of what exactly, while this is all going down, what crime was being committed while this individual was in the possession of the firearm. So I see that that's missing here. And This is kind of a huge deal. This is a huge deal. Because remember I was saying yesterday, right? What if the jury are humans, right? Juries are inclined to want a resolution, right? They want to follow the instructions. And the state has done a very confusing, messy job of showing, hey, guns everywhere. There's guns everywhere, right? So if the jurors were like, well, we are not convinced at all that Shannon Stillwell is responsible for the murder of Shamel Drinks. Again, this count is relating to March 14th, 2022, the day of the Shamel Drinks murder. We don't think he did that, but we do think he had a firearm. He was like throwing them out the windows when he was chased later on, blah, 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 blah. They had pictures of it on the table that Viverito ID'd from that screenshot of a video still on Instagram. Well, but you're missing the crime he was committing that's supposed to underlie this. So this is a huge, huge, huge problem for the state, because it is possible that if they put this in front of the jury could say, we don't think he murdered Shamel Drinks, but we think he had a firearm. Well, that's not how this is charged. So there's that there. It's over on X. And I also saw Jim R. say, look at the original indictment. And guys, this would carry a ton of time for Shannon Stillwell, just this alone. So it's not just, okay, a count that he could be convicted on because jury thinks gun, yes, check the box. It would have been many, many years because he's a recidivist. This carries time. Like, this is not a joke. Okay, hold on. Okay, let's look at the original indictment. Let's see. I think this is the original. So, saying it out loud, we are looking at the old indictment. Let's go down to 52. Old indictment, old indictment, old indictment. Because that's been very confusing in this trial. Okay, so let's see. You know, if I take a screenshot real quick, I can probably put this side by side for comparison. Well, let's just see. Let me pull it separately. It's definitely a longer paragraph. So, in count 52, Shannon Stillwell is charged with the possession of a firearm by a convicted felon, previously convicted of felony involving the use or possession of a firearm. Again, it's 133 for the said accused in the county of Fulton and the state of Georgia on the 14th day of March. And this is where we get a change. Go Jim R. Did possess was the original language. This is the new language. The original indictment says, after having been convicted of felonies involving the use or possession of a firearm in an indictment that was mentioned, they actually include here, in the Superior Court of Fulton County, Georgia, for the offense of possession of marijuana with intent to distribute and possession of a firearm by a convicted felon. So here we have this difference here. Here we have this difference. They actually list this out from the 10th day of March in 2016. And then this was the second indictment. Second indictment mentioned in the current indictment that we just looked at. And this is different too. So the current one just says possession of a firearm by convicted felon, contrary to the laws of said state, the good order, peace, and dignity thereof. But the original YSL indictment says did possess or have within arm's reach of his person a firearm during the commission of a crime against or involving the person of another, to wit, the murder of Shamel Drinks, a rival gang member, as alleged in count 49 of this indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Now, interesting, because this has never actually been tried separately. So, Jim, it looks like there was problems with the old one and they tried to fix it and still left it messy. Like, there's a problem here in this old indictment. This is the old indictment on the screen. But then there's also a problem in the current indictment because now we don't have the underlying felony that was being committed that's necessary and a necessary element for 133. So let's go back, and this is now I'm pulling back up the current indictment, and I'll link both of these because I know it's, you know, it could be easier for you guys to pull up and look at on your own instead of on a screen. But holy moly. So here is the original language there. And I'll also put it over on X, a little easier to find. Okay, so that's on X if you want to grab it anytime. I think it's like a bit easier to read stuff over there than in a YouTube description. And then for in the chat, I'm pasting current link, current indictment. And an old indictment. There you go. Yep. See, look how simple Jim lays it out. 133 requires that you possess a gun in the commission of a felony while also having been convicted of a felony in the past. So, yeah, there was definitely a big and apparent change there between the two. A whole mess. What else is new? What else is new with this trial, though? It's every day it's something new. And the thing is, like, there were several times I know Brian Steele really raised hell about this indictment being fatally flawed because there's no element of mens rea, right? There's nothing spelled out about that element in the indictment, about them knowingly doing something in furtherance of the conspiracy and of the gang. But Schardt mentioned, you know, that this was subject to emotion, the same issue with at least count 52. Now, yep, Jim R. And Jim R, we got to find that stuff again. Guys, if you are not following, and again, we say Jim R here, but it's Happily Angry Lawyer over on X. We've looked at his analysis of the Mungtung plea deal and why there's an issue between the 16-11-131 and 133 for Mungtung, right? But he's found continuing issues with the Mungtung saga, including during the revocation hearing that we looked at, I don't know, that was like 4 weeks ago now, when the PO was reading his priors, she was reading stuff that a totally different Anthony Sledge did. So just a whole mess for several reasons. And just a ton, honestly, of research and advocacy here from Jim R. that I wish Fulton County would take note of. So one of those things, if you can not just go and check that out of curiosity, but if you're on X, if you use X and support and like that content, get it in front of more eyes, can make a big deal. So, and I promise you, Jim R. writes in a very entertaining way. You won't be bored. Explains things a lot better than me. So there's that, you guys. Again, I am a layperson. I am not a lawyer, but Count 52 looks super sus to me, just from what I've become familiar with understanding the difference between the statutes 131 and 133, largely in part because of reading what Jim has done for Antonio Sledge. So, and that's the thing, right? They're trying to cram everything in this RICO, but then rely on past charges, and now it doesn't look good that they had a chance to change the indictment. It's not like there was an error and they carried it forward and left it sitting there, which I'd argue is problematic because you hold defendants, you hold the convicted accountable when they don't notice an error, right? They did that with Mungtung. So even if it was accidental and they just copied and pasted and moved the same language forward and it was flawed, it would still be a fatal flaw in the indictment, right? But you had the time to change it. And it's still problematic. So what's the excuse? What's the excuse? So Judge Whitaker is going to take the, and I don't know if she was also talking about 63 or just mentioning, and maybe we can pull that up on the screen. We'll make use of Jim R's free billable hours here in the chat. Big appreciation to Jim R. Let's go to, which window did I have the current indictment in? Okay, this is the current indictment. The second one mentioned was 63, and I don't know if this is the same issue because they do say that previously, and this one applies to Diamante Kendrick, but it does say possession of firearm or knife during the commission or attempt to commit certain felonies, right? So I don't know if this flaw exists for count 63, but I don't know. I don't know. I still think there's an issue here with, was he knowingly, was he in possession, was he within arm's reach of these things when he wasn't in the house? So, I don't know. I think there might be a separate issue here. Not sure if the same one that applies to 52 counts. Oh, 64. So did Hylton speak wrong? Because she said 63 and 52. So yeah, this actually looks like the same problem, right? Maybe? Yeah, all right. So let me update on X quick because I was really confused. Like that whole time I was like staring off onto the side of the screen. I was trying to figure out what Hylton was talking about. Just piling on to the mess. Because she was shuffling through the papers when she was looking at the examples. I went back and replayed it to hear it twice because I was a little confused. So yeah. Yep, okay, Jim R, thank you. 64 is 100% flawed. It looks the same as 52, not during a commission of a felony. If anything, that's supposed to be charged as 131. So I think Hylton misspoke when she said 63 was that issue. So, and I think there's separate issues for 63, but maybe it's within the kin of the jury to decide and not just a fatal flaw in the indictment. Oh, man. This is just wild. Like, think about the resources that went into this trial and there's errors like this, right? I'm not saying it's okay that, like, someone's possession charge that impacts their life. If there's a fatal flaw in that, I'm not trying to minimize that that's not, I'm not trying to say that that's not okay. But when you put additional effort to the scale of additional millions, entire teams, carts and carts and carts and carts and carts of paperwork, and you still have issues like this? Hello? Hello? And they're waiting on the jury. The jury wasn't all present at 10. And my bad. Big thank you to everyone in the chat today. Shout out to Anthony Samora hanging out with us today and also gifting 5 memberships. That was super nice. Big thank you. But the likes didn't come entirely for free. He says the likes are pretty low. The likes are pretty low, you guys. Thank you guys in the chat for always remembering to hit that like button. Really nice of you guys to do. I know it helps, and you know I do marketing as my client work, my real day job. So I should be telling people to hit the like button. I just don't. So big thank you to you guys that are out there putting the reminders out there and taking the time to click the thumbs up. Big thank you here to Anthony Samora. Sweetie88 says, good morning, Cat, Chat, and the mods. Working as always. Stream will be playing in the background. Have a great day, Slots. And she worked in a cap and burrito emoji. So I'm loving Max Schardt using the word cap as often as possible. And Viverito hating it because she'd rather use the word inconsistent or whatever. Sweetie, we love our workers in the bushes here that hang out and lurk. You guys have a separate bush from Viverito. Our workers and lurkers are not in the same bush there. We've got our own designated bush for Viverito. Thanks so much for being here and for your support. Tracy with an I but with a Y is a new member. Thank you so much for becoming a member, Tracy with a Y. Angelique Womack, thanks for being a member for 2 months. You had me dying laughing in the chat earlier. That was hilarious. It says, yay, woot woot. So today's going to be a day. And I think the icing on the cake is Whitaker is like, I can't snap my fingers, guys. So you probably can't hear it. But she's like, let's go. She's like, come on. So if she carries that energy through this cross-examination of Viverito, when she was already, in my view, bordering on lashing out at Viverito, it's going to be a day. It's going to be a day. Oh, boy. Speaking of Viverito, Casey Dog, thanks for the 2, says, Burrito's not dumb, Cat. She's V for vindictive. You know, I think there's a mad scientist thing about her. Just too determined, too set on her ways, stuck on a linear path, can't see anything on the outside, won't consider anything on the outside. And Schart's actually laying down exactly how that is. Who chooses what goes in the folder that you sent over to us? Who chooses what's relevant? Oh, we have a whole team. No, but who chooses it? You're the one doing this case, right? Yeah, well, it's me. I don't want to say it's me, but I choose what's relevant. So I curate my entire approach to what I investigate. Tunnel vision all the way. So I agree, Casey Dog. There's a difference about her. And I think this difference, I think vindictiveness, determination, pride, I think they're all very dangerous traits. So not good. And I'll pull the link. Kayla had talked about a case that was overturned. Let's see. And it's not mentioned here. I have to do a deeper dive. But apparently Viverito was the lead investigator of a case that was overturned and retried. I have to go and find it. I don't think this was the one. There are a few readings in that had high-profile cases in Georgia, so I got to find the right one. But there was apparently a major case overturned with a 30 deep member, and Viverito was part of the testimony at the trial. So definitely want to look into that, and I'll get that out to you guys when I find it. But again, it's one of those things, like, it's not just a problem here in this one case. Oh, love this. Peter Ortiz. Shout out to Peter Ortiz. Guys, if you're looking at your screen, we have a new pet picture reveal. So Peter says, I'm introducing my Christmas slime partner, Lucy. Love Lucy already. Love the Santa hat. Yeah, 'tis the season, you guys. Rolled around quickly. I gotta start preparing to write 2025 on things. So, you know, if you come back to this channel after this case is over and it's like January, February of 2025 and my thumbnails say 2024, because I like to put the dates in the thumbnails, my bad in advance. I'm really bad at changing years. Love Lucy here. Thank you, Peter. Let's get some cross. Let's get some cross.
We can go ahead and get the jury in. Thank you.
Y Turner says Hylton needs to just invest in a fashion designer because she's going to use all the curtains, beddings, and rugs in her house. Don't forget about the billiards felt. Shaking my head. Oh boy. And I didn't pay attention to what she was wearing today, so I gotta look. Gotta look.
Good morning.
Henry Johnson, thanks for becoming a member. Lifestyle, I do want to reiterate this again. How many not guilties are needed? One not guilty could hang the jury, but for an acquittal, they need unanimous. STS is out here sniping. Thank you so much for the gifted membership, STS. Great to see you today. Yeah, Leah's dad, definitely agree. Ooh, Whitty is annoyed now that she sees the mess. It's about time, right? It's about time. Oh, I'm in the bush. It is about time. 163 days in, we're seeing a flaw in the indictment.
Thank you. Everybody can be seated. Go ahead, Mr. Schardt.
Thank you, Your Honor. May it please the court. Good morning. Good morning.
Good morning.
Investigator Viverito.
Good morning.
Are both those mics being used?
This one is.
Oh, it's fixed.
Yeah.
Okay. All right. Thank you. So, Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
Correct.
Okay. We are going to get back to that later.
Sure.
Okay. So we're going to switch to another topic right now. But it is about the posts from March 2022 that you collected.
Okay.
Okay. The reality is in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
Correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' death. Is
Correct.
that correct? Okay. And let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Investigator Viverito, this is a post posted by one ABG _ Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected, would have been around 8:20 on March 11th.
March 11th, okay. So this is the morning after Christian McMiller and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay, the evening after.
Correct.
About 20 hours after, 21 hours, or 19 hours after.
Somewhere around there.
Okay. And this post includes a, says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMiller being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he is associated with Atlanta Blood Gang. Or,
He's documented as a member, and he's also a fixture at 12 Atlanta daily.
okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for the murders of Christian McMiller and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we'd take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation involving Mr. Drinks when I get to it, okay? But I'm asking you specifically about posts. Posts that is not a confession to killing Darius Ford or Christian McMiller, is it?
Absolutely not. But as an investigator, you need to look at things as a whole to piece things together, leading you towards suspects.
Okay, and that's why you collected this?
Correct.
Okay. Ms. Knight, I'm going to ask you to publish 462 VV. Okay. 462 VV is two posts that showed up on this page labeled Joey _Hurst 24, correct?
Correct.
All right.
Joey
and
Hurst.
on the left is Christian McMiller,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMiller and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMiller and Darius Ford?
Yes.
Okay. Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page, yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was,
No.
the government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is, you
In
did
2
not view
days?
these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay.
2 days?
456 VV. Please, Ms. Knight. Thank you. Okay, this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct?
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought new op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason again is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay.
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
He has not.
Okay. And this has all happened 2 years ago at
Correct.
this point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me? Okay, in 473 VV, that's posted by Shellkel Nutlife, correct?
Correct.
And you know that to be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford?
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think in days following.
Okay, Ms. Knight, could you please publish 461 VV? Okay, and here's another picture of Shellkel or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct.
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's 2 little shells under his left eye.
Correct.
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct.
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed, yes.
And this is on Kelvin Watts' page.
Yes,
And again, we see the 2 shells,
correct?
okay, and that had significance to you because there was 2 dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
And we have 2 shells, right?
Correct.
And we have a smiley face, except the lips are zip tied or zipped up, I guess,
Correct.
and a black heart.
Correct.
Okay, and this was on Mr. Kelvin Watts' page.
Correct.
All right. Also, and Ms. Knight, thank you. Also, you're aware that Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Cal and Third World?
Another one.
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to 2 snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast car. It's Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Speculation.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
They were in a gray and color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me. So.
Okay, that's fine.
But
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still open active investigation.
Right, and you've had you collected these postings that Mr. Watts made way back in March of 2022.
Correct, but so investigations, just the social media posts aren't enough to arrive at probable cause. You need him maybe on video at the crime scene, before that murder, things of that nature. So if social media was enough for probable cause, a lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene or there.
Unfortunately, she
there's-
didn't want to say
there was
that.
no knife.
Agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras, I promise you. Absolutely talk about the security cameras, I promise you.
Commentary and.
Well,
I'm
there's commentary going on both sides. Answer the question that's asked.
Okay, I want to clean up some.
I don't know why it's
I'm
refreshing.
going to shift off of social media. and
It
we're
keeps
gonna get
putting
to
the captions at the bottom.
Okay, I want to clear up some issues, or not issues. I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. I'm talking about Demarco Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair to
Probably
say?
in the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct?
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay, because that would defeat the purpose of the wiretap,
Correct.
right? And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes.
Okay. So it wasn't a random sampling, it was calls that the state chose to focus on.
It's my understanding that the prosecution and the defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the case.
Right. Yeah, right. I'm just saying it just wasn't some random sampling.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. When you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
It was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demarco Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about Demarco Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He
at
was
the
in
time.
custody. So he wasn't involved with any of those things that Demarco was talking about, running into Blizzy in Cobb County.
Correct.
All right. And then we also heard a call between, I believe, Demarco Garlington and Antonio Sumlin, and it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekion Garlington and a gentleman named Demarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many, 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay. Now, based on your investigation, you said Boyer was at the gas station.
Correct.
And you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing on the fact that Miles Farley in that video, when he goes back to the car, gets into the back seat at the BP.
That and there are calls from the wire that
Okay.
say that he's in the car. Yes.
Fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi.
Correct.
And Mr. Boyer, who's not charged in
Correct.
this case, is a passenger in Mr. Nichols' Ford Fusion.
Correct.
Okay, white Ford Fusion.
Correct.
Okay. Your investigation based on the time on the surveillance video from the FedEx surveillance is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off shortly thereafter. Within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made where eventually Garlington tells Boyer to go to video. That 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time,
Correct.
right? Okay, so that's based on the wiretap time. Okay. So, and then of course, after they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through
Okay, and do you know how long that call was or when exactly when it took place?
immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct?
we have the FedEx video time,
Correct?
and we have a BP video time.
Correct?
Okay. Are any of those, to your knowledge, are any of those three separate surveillance systems synced up?
They're not. So typically what you would have to do is go back and sync them because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I'd have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data.
Right, exactly.
Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when this call was made, because those two timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay, and the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those two cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap time?
Correct.
Awesome. Okay. Mr. Atkins or Ms. Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask some questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes. Okay. So we listened to another call at 2:01 a.m. between, do you know who that call was between?
I'd have to hear it.
Okay, well, I'm gonna cut to the chase. You said in court that you heard someone say, riding by the scene.
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said, but you said the scene.
Neither.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you, and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish. Right, and whatever, okay. Yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? Nah, the nigga Ray got it, not Dan said got it.
Okay, could you pause it?
Oh, for real?
All right, now, Miss Investigator Viverito, do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was kind of muffled.
That's fair. All right, Miss Hylton, if you could. Yep.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his change? That who changed little J5 to Jason. Oh, for real? Yeah, the YP Ray nigga. Oh, I didn't even know that. Yeah, that little PLK nigga. Oh, yeah, I had a J5 with me last night. That's probably what it was. I put him on. Yeah, that who changed it. Oh, damn, what I say, yeah. Buddy came and followed me. I followed his ass back. Hey, talking about fuck wrong with him. What you talking about? I'm trying to get the other care data address right quick and care address. He testing the young crew. Somebody he finna send a bit. For real? Somebody he gonna send a bit somewhere late where the spot at.
Okay.
Yeah. He told LJ you got liquor last
20 seconds. And my notes might be wrong, but I don't think they are.
document page 350.
Yeah, 20 seconds, please. Could you just tell me when you hear anything about the scene?
Okay, go
Oh,
ahead.
for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh, yeah, I had a J5 with me last night. That's probably what it was. I put him on. Yeah, that was J5.
Oh, no, I'm sorry. Yep, okay, I'm sorry. You're going by the different number. 2:01 a.m.
This happens so many times in this trial.
Right, it's the call 350. All right, here we go. This is the one I meant to pull up for you, Investigator Viverito.
Yo. All right, man. There was all kinds of shit going on. I just jumped in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense. Yeah. The fuck you getting dropped off for a nigga ride with the nigga who wrote you? Yeah. That's stupid as fuck. So you need to be on the damn head, so. What the hell? What's on with you? We right here down here. Y'all what? Ride past around the sea.
Okay, stop. Did you not just hear him say riding past through the city?
He said riding past trying to see.
Well, where's the scene?
You're saying it says something
I
different.
said,
You said scene
Yes.
before, now you're saying trying to see, and I'm saying city.
you may have misunderstood what I was saying. Or you got to understand when these calls come in, when you click on the call, it will also provide a map of where they are, and the next call may show where they traveled to after that. It's my understanding that he traveled back towards that area.
Okay, towards the area.
No, we're talking about what you said on the witness stand.
You mean the city? It's in the city,
They never
right?
left the city.
Okay. Investigator Viverito, you previously testified that he said going to the scene, and now you're saying to this jury that he didn't say scene, he said see. Is that correct?
I don't know if I said he said, I don't believe I said he said he's riding through the scene. He may have rode back. I believe he was traveling back towards the scene.
And I know you're an expert, but if the jury listens to this and hears city, is that okay with you?
But that's not what's said, so I would clarify for them.
I understand that you want to tell everyone what's said here, but you've already given two different stories. You said see, and then you said
What's your
see.
objection?
Argumentative.
Overruled.
It's,
Can we just go by what we hear? Is that okay?
sure.
Thank you.
Beautiful.
Okay, call 416, and I don't need this published. Thank y'all. It's from the early morning hours of March 16th, 2022. Okay, there was actually two calls that were played. Do you recall?
Correct.
Okay, one is Mr. Garlington and someone that you say is my client, and the person's whispering. I'm not even going to dispute it, okay?
Okay.
We'll just say it's my client.
Okay.
Whispering about hiding in the crawl space.
Correct.
Okay. And then the second call is Mr. Garlington and my client talking about what just happened.
Correct.
And of course, what just happened was the house was shot up, and then a bunch of police officers showed up, and no one was arrested.
Correct.
Right. Okay. So, and that was the same day, of course, that you spoke to Shannon Stillwell. You put him in the back of the police car, or someone put him in the back of the police car, and you spoke to him, and he told you he was, in fact, driving the white Audi.
Correct.
All right. So, that call, let's just review some things that were discussed by Mr. Garlington and Mr. Stillwell. They talked about their amazement about not being hit by any of the bullets that were fired into 2830 Waters Road, correct?
Correct.
They talked about their amazement that the police let them go from that location.
Correct.
They talked about how they hid from the police.
Correct.
Mr. Stillwell talked about being placed in the police car.
Correct.
Mr. Stillwell said that he denied knowing McMain when asked and said he was from Thomasville.
Correct.
Okay? That was misleading, right?
Correct.
Because he does in fact know McMain.
He does.
All right, and McMain, just so we're clear, is Christian McMiller.
He is.
Yeah. And he talks about getting out of there as soon as possible. Like speeding away because he couldn't believe that y'all, the police, let him go.
He does, but he says prior to leaving, he collected his FN and his rifle or stick and he left.
I'm going to get there. Okay. And they talked about seeing you too, right?
They did.
All right. So let's talk about, I know he, in that call, and clearly I'm getting there, he talked about sneaking his FN away from the scene, right?
Correct.
And about sneaking his stick out of one of the cars. I think the gray car.
Correct.
All right. Okay. Now, the FN, you've testified, you know that an FN 57 is registered in Miss Tyesha Alexander's name, correct?
Yes.
Okay, and that gun was located at Meadowlark Drive on March 17, 2022.
Correct.
Correct? The next day after this call.
Correct.
All right. Does that FN shoot .40 caliber bullets?
Does not.
That could not have been the murder weapon for Shamel Drinks.
No.
Could it? Okay. He talks about taking a stick from a car on the scene, right?
Correct.
And you know the stick to be an AK-47 type assault rifle, correct?
Could be an AK-47. It could be an AR-15. It could be, it's a rifle.
Typically shoot 7.62 caliber bullets.
Correct.
Okay, not .40 caliber.
Nope.
Okay, so you would know that that stick that he talks about taking from the scene once you guys let him go is, in fact, not the weapon used to shoot Mr. Drinks.
Correct.
All right. And in this call, where, again, you don't have any reason to believe Mr. Stillwell knew he was being recorded,
Correct.
or Mr. Garlington knew he was being recorded. In this call, he never talks about taking any other guns from the scene.
Correct.
Okay.
Beautiful. All of this listening you did for what?
Call 2119 is another call that was played. It's from April 1st, 2022 at 12:29 a.m. It was a call between Demarco Garlington, who's on the wiretap, and Shannon Stillwell, who's in jail at this point, correct?
Correct.
Okay. And Demarco is on his normal phone, and you testified that Shannon Stillwell, when you're in the jail, you said there's wall phones, right?
Correct.
Okay, and that's, the jury has heard those recordings where they talk about Securus, and this phone will be recorded, and they are in fact recorded.
Correct.
Okay. Mr. Stillwell was not on a recorded line.
Correct.
He was on a cell phone from the jail.
Correct.
Okay, so he, in common sense, he doesn't know that Demarco Garlington is being wiretapped.
Correct.
Okay, and he has no reason to believe that the cell phone he's using from the jail is being recorded.
Correct.
It's fair to say that they believe that they're having a private communication that is not being recorded.
Correct.
All right. Mr. Atkins, could you do me a favor? This call, 2119, and I'm talking about at 12:29 a.m. Could you play on April 1st, 12:29 a.m.? I'm just adding. Okay, yes. You know how to man consult with the.
Yes.
240 to 315 is what I want. And we're just going to cue that call up, okay? And I'm going to ask you some questions about it.
Sure.
Thank you, Mr. Atkins. And if you could cue it up to 2 minutes and 40 seconds. $240.
I'm telling folks, I'm like, shit, what the hell they locked up for? Like, they just saying about the camera. I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. They gonna assume that, like, oh, like, y'all ain't did nothing, you feel me? So,
That's what I keep telling goddamn look, I'm keep telling him like just chill. Like I know
yeah, cause they
this
saying he
ain't
panicked.
nothing. Yeah, I'm like, this ain't nothing, bro. Like they just doing that cut. They seen as a goddamn gas station. Like just chill. You see what I'm saying?
Yeah. Yeah, man. That's what I'm telling. I keep telling him all the time. Shit. I'm like, listen, bro. Just like you, like, bro. I'm telling probably in the cab. Listen, bro. No, just tell him before you don't want to talk, bro. Like,
Not one word.
yeah.
Don't give down on what they try to portray or what they say, man. Don't say shit.
Yeah. I ain't know that though. Like, so I didn't.
And you can keep that up because I'm going to ask you to play another part. But thank you, Mr. Atkins. So on that call, again, neither party has reason to believe they're being recorded. That's Demarco Garlington and Shannon Stillwell.
Correct.
And they talk about they going to assume shit.
Correct.
Mr. Garlington says, y'all didn't do nothing.
Correct.
And then Mr. Stillwell says, they just saying it because they seen us at the gas station.
Correct.
Okay. Mr. Atkins, if you could please play 11:20 at 11:28.
He just clicked like, did you guys hear the quiet clicking?
Yeah, man. What the hell swimming on? You still in the yo?
Yeah. Okay, what is that?
You know what I'm saying?
Yeah, see. Who?
Yo, folk.
Yeah. Okay, what is that for them?
We're going to come back to that one because I want to get the timing right.
Okay.
What's that?
Okay.
Okay. And that is Okay, and we're going to come back to that call. But let's talk about Mr. Stillwell's phone that was collected.
Sure.
Okay. Do you know you're able to view? So you collect the phones. Detective Leon Packer, he dumps the phones, and then you're able to view the phones, what the contents of the phones through a program called, what's it called, XRZ, is that correct?
XRY.
XRY, okay. And you get just a whole bunch of information that's in whoever's phone. Pictures.
The contents of the phone are organized by category.
Right, and we're talking about pictures, text, emails, instant message, call logs, location, data, internet searches,
Correct.
notes.
Correct.
Okay. And if you don't know, that's fine, but do you know how many texts or calls total were in this phone?
I don't know off the top of my head, but it would be listed on the extraction, on the front page of the extraction. When you open it up digitally, it'll give you what you're going to see initially is it's everything by category. So it'll say 20,000 texts, 100 calls, things of that nature.
Okay. Ms. Knight, if you would please display 227 VVA2. Oh, Ms. Knight, sorry. VVA2. Yes, VVA2. 227 VVA2. Thank you. A. Coming up? Okay. Okay, this is one of the text messages or one of the text conversations that was introduced on Friday, I believe, correct?
Correct.
Okay, and this is from Mr. Stillwell's phone.
Correct.
All right, and in his phone, Mr. Stillwell's talking to, is that D, do you know that number to be Demekion Garlington?
I believe so, yes.
Okay. Because there's a couple of D's in this case, but you believe this to be Demekion Garlington?
He did change his number right before the wiretap, so I believe that's the number before.
Okay. And if you could zoom out a little bit, Ms. Hylton, or Mr. Atkins, so we can see the whole conversation. Thank you. Thank you, Mr. Atkins. So in this conversation, to add context, Mr. Stillwell is indicating that one of his two phones is at Big House.
Correct.
Okay. Do you take that to be Darius Ford's house? And again, let's be clear, this conversation occurred December 24th, 2021.
Okay.
Okay, so we're talking about 3.5 months before any of this involving Christian McMiller's death or Darius Ford's death or Shamel Drink's death occurs.
Correct.
Okay? do you take that to be Big's phone? Is there another Big? Do you not know?
There is another big.
Okay, so, but in any event, Mr. Stillwell is saying he left his phone at someone else's house.
Correct.
Okay. And then D says, finna take it in where you at, indicating that he's taking Mr. Stillwell's phone, right?
I don't take that as taking the phone, like finna take it in, like I'm finna go to sleep or go home.
Fair enough.
Like take it in for the night.
Fair enough. Could you go down, Mr. Atkins? Okay, and this is the part that the state introduced. Okay. He says, if Polka asks, tell her I'm op hunting. Okay, he did not say I'm op hunting.
Correct.
He said, if Polka asks, tell her I'm out hunting.
Correct.
Okay, and Polka you know to be who?
Tyesha Alexander.
And that is Mr. Stillwell's girlfriend at the time.
I guess, yes, I don't, yes, at
Something
the time,
like- something like
sometimes, yes.
And you also know from your review of the calls that Mr. Stillwell was having some issues with fidelity.
Yes.
Okay. So he's just saying, if Polka asks, tell her I'm op hunting.
Correct.
All right, thank you, Mr. Atkins. Mr. Atkins, can we go back to that call? I think I finally got my stuff together here. Okay, remember that call that we were just talking about with, and just to review, it's Garlington and Mr. Stillwell, and they were talking about people were going to assume things, and they're just saying it because they saw us at the gas station.
Correct.
Okay, I want to play, Mr. Atkins, if you could start playing it. I guess we could start at 11:28. Yeah, 11:45. Yeah, that's fine.
I love this get the picture from KC Dog. It's a burrito with the cooking pan and a chef and a shark for the closed captions.
Yo, folk.
Yeah. I was there with him yesterday.
Yeah.
Yeah, he got out of town now. So he's gonna get ready to come back. I was just gonna lie with his ass.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Man, that be
I
crazy.
was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what not? She's like, what? You think you gonna tell on me? I'm like, man, hell nah.
Shit crazy. I don't even be texting that back no more.
I should be texting on, like, on the tablet and shit.
Yeah, I don't even be responding to that. That crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, man. I got you.
Love you.
I love you too.
All right.
All right, Will. Okay, let me just ask you this, and we're going to get it together, and we're going to get it played. Do you remember on that call, that same call, that unrecorded call? I mean, that these two gentlemen thought that they were talking to themselves without being recorded. Do you remember Mr. Stillwell saying, when they test for gunpowder, it's going to come back clean?
I do.
Okay, and that's on this call.
Correct.
All right. And he does not say the car has been cleaned.
Correct.
He's saying, don't worry about it, because when they test for gunpowder, it's going to come back clean.
Correct.
Okay. And that was on the private call between Mr. Stillwell and Mr. Garlington that they had no reason to believe was being recorded.
Correct.
That's one of the biggest things the
I'm
state
gonna go
tried
back
to
the
mislead with.
phone. You made note of 227 VVB11, and we don't need to display it, but it was basically something in Mr. Stillwell's notes that said, "Pop my shit. I really got options. Poor little ops. They be dropping."
Correct.
Okay, and that was in March 15th, 2022 at 12:52 a.m. The phone says that that's when it was entered.
It might say either modified or entered, yes.
Okay, and that was, and we're going to get to it, but you're aware that Mr. Stillwell's grandmother, Betty Jackson, texted him about the shooting, about seeing it on the news that night?
Objection, assuming facts not.
Well, it's going to be in evidence. I'm asking if she's aware. You're aware of that?
I was aware that Miss Alexander notified him about a shooting in Mechanicsville. I don't know if Miss Jackson did.
Okay, it was hours, this would have been hours after Miss Alexander alerted him as well, correct?
Okay.
Correct?
I'd have to
Okay.
see it. I'm not.
Okay. All right, well, we'll get to it, but this was at 12:52 a.m.,
Okay.
right?
I haven't seen it, so I just.
Okay, and we've already discussed ops,
Correct.
dropping ops. Those are common themes, common topics of drill music, correct?
Correct.
Okay. And at the time, your investigation, at the time that he entered this note into his phone, he was in fact at the studio, correct? At 12:52 a.m. on March 15th.
After leaving the gas station, they went to a studio. I did not have location data on Mr. Stillwell to say, but I believe they should have still been at the studio.
Still been at the studio creating music when he entered that note.
Creating music, hanging out. Like, yeah, that's what they do. Hang out at the
Okay.
studio.
All right, cool. And then you talked about search words, a search that you noted about a Windsor Street shooting, right? That was in Mr.
The whole word.
Stillwell's phone.
Skip the word
So he
under.
didn't, and I clarified that on direct. He
Right.
didn't search Windsor Street. He searched Fox 5
Okay.
and then
Well-
clicked on, and then within Fox 5, then searched the Fox 5 website.
I appreciate that. So on 3/17 at 2 in the morning, Mr. Stillwell clicked on the Fox 5 website to this article.
Correct.
Okay, didn't search, your testimony is he didn't search words like Windsor Street or anything, but he clicked on the article and that's what shows up in the phone.
I'd have to see the screen. I believe he searched Fox 5, traveled to the Fox, like say I open my phone and I want to go to whatever web, Amazon. I search Amazon, click on Amazon, and then on Amazon, I would then search. That's what
That's
happened.
not his question.
Searched for Fox 5, went to Fox 5. Then went on Fox 5, I believe searched Windsor Street shooting, and then clicked on the article, is what it looks like.
This
Okay,
is not
and
his question.
Ms. Knight, could you just display 227 VV88 so everyone knows what we're talking about?
He's making a distinction that he's not asking for. He asked if he did a search, and she's like, well, he didn't do a search. He went to a website and then did a search. Like, calm down with the over explanations. He just wants to ask you about the search terms, whether it was a Google search, a search engine search, or an internal platform search. Un poquito, Jason.
Okay, so this is what you're talking about, right? The search.
Correct.
Okay, and this is 3:17 at 2:31 and 56 seconds in the morning, correct?
Correct.
No, that's fine. I want to show you some documents, investigator.
Sure.
It's okay with you. I approach, Your Honor?
Yes.
Investigator Viverito, I am approaching you with what's been marked 57A, DS57A, DS57C, and DS58. Could you look at these and tell me if you recognize?
Sure. Okay, these are excerpts from Mr. Jackson's phone.
Right, and those are, well, and are those excerpts from, are those conversations from the data that was downloaded from Mr. Jackson's phone?
Sure, the first one is the one that I spoke about that I had seen of Miss Alexander informing him about the shooting.
It's not admitted yet.
Oh, sorry, yeah.
Are those accurate representations of the data that was in Mr. Stillwell's phone?
Yes.
Okay, Your Honor, at this point, I would move to admit DS57A, DS57C, and DS58 into evidence.
A, C, and E. Say that again, please, if you don't mind.
It's, and there is no DS57B. It's DS57A, DS57C, and DS58.
Oh, okay.
Yep.
Don't know where the E came from. Okay. Those are admitted.
Mr. Kokomo, could you please, oh, permission to publish, Your Honor.
You may.
Mr. Kokomo, could you please publish 57A first? So in this, in DS57A, investigator, this is a conversation between Tyesha Alexander, also known as Polka, correct?
Correct.
And Mr. Stillwell.
Correct.
Okay. At 3:14:22, at 11:01 p.m., Miss Alexander reaches out to, or texts Mr. Stillwell and says, "You okay? Somebody just got killed in the Ville. Ugh." Or ugh. Atlanta, too much right now, right?
Correct.
All right, and then they respond to each other with kisses. Mr. Stillwell asks who got killed, correct?
Correct.
And then Miss Alexander eventually says, "I don't know yet," but before that, she sends some sort of screen message, correct?
Correct.
Okay, and that's at this. The message is sent at 11:19:47 p.m. Correct?
Correct.
All right, and Mr. Kokomo, if you could publish 57C. And this is the screenshot that, or the picture that Miss Alexander sent to Mr. Stillwell at 11:19 p.m., correct?
Correct.
And it's a photo, and is that Windsor Street?
I believe so.
And it's captioned, "Somebody just got killed in Mechanicsville."
Correct.
And it's posted by someone named Bory Billions.
Correct.
And whenever Miss Alexander sent this picture or downloaded it, it already had 2,000 views, correct?
Correct.
All right. So by that night, just based on what we see in this phone, by that night at 11 o'clock or 11:15 or 19, the word had spread about a shooting, correct?
Correct.
In Mechanicsville,
Correct.
where someone was killed.
Correct.
Okay. And this was not a secret. It was being spread throughout social media.
Correct.
All right. Mr. Kokomo, if you could post DS58.
So how come she didn't talk about this? Put this in her folder. Talk about it on the stand. Why didn't the state introduce this?
Okay. this is a conversation, and I'm sorry, it's marked 58A, so, Your Honor, if we could just amend that to make 58A.
Sure.
Thank you. So, looking at DS 58A, this is a conversation between Mr. Stillwell and Boss Lady, correct?
Correct.
And you know Boss Lady to be Betty Jackson, correct?
Correct.
His grandma.
Correct.
His grandmother who raised him.
Correct.
At 11, Mr. Thank you. At 11:19 p.m., Shannon texts his grandmother, "I love you."
Correct.
Boss Lady or Betty Jackson responds, "Mama love you so much, heart, heart, kiss, 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 'cause you're my sweet thing."
Correct.
And Mr. Stillwell says, "Yeah." I don't know if I'm pronouncing that right, but yeah, right?
Sure.
And then Miss Jackson gives a thumbs up, right? And then at 11:26:57, Miss Jackson says to Mr. Stillwell, or texts Mr. Stillwell, "Hope you are not near Windsor Street shooting on the news," right?
Right.
And then she says, "Answer me, please."
Correct.
And eventually at 11:41, 15 minutes later, Mr. Stillwell responds, "I'm at the studio, Mom."
Correct.
Okay. So, at 11:26, according to this conversation, not only did Miss Alexander alert Mr. Stillwell about the shooting on Windsor Street, but Miss Jackson says there's a shooting on Windsor Street, right?
Correct.
And it's on the news.
Correct.
Was this information about the shooting on the news at that point?
I know that the article that Miss Alexander had, that's a female, I don't know her real name, in Atlanta, that wasn't like a ATL scoop or a news thing. And then I don't know how Miss Jackson saw it, so I'm not sure if you got word of mouth from Miss Alexander, worried about it. I don't
Maybe
know.
she saw it on the news. Maybe
I don't know when the news coverage began.
Okay. The bottom line is, by 11:26 that night, two different people had informed Mr. Stillwell about a shooting, a death, Windsor Street,
Correct.
and the word had spread throughout. It wasn't just Mr. Stillwell that was being informed. The word had spread throughout the Atlanta community that quickly.
Correct.
All right. And basically, the phone indicates on March 17th, 2 days later, Mr. Stillwell clicked on a news article about that shooting.
We sought out the news article and then clicked on it.
Okay.
Yeah.
He sought out and clicked on it.
Correct.
All right. Cool. All right. Right when you started testifying, you remember when you were going through a timeline, and I think it was from 2019 to 2020, different events that had occurred?
I do.
Okay. And we heard a lot of names, Tenquarius Mender, right?
Correct.
And you said he's a member of the Rolling Crips.
As well as YSL, yes.
Okay, and we heard about Stephen Harris,
Correct.
and he's a Crip. And we heard
No,
about,
I'm sorry, Stephen Harris is a member of YSL.
okay, he's a member of YSL. We heard about Marcus Sims.
Correct?
He's a Crip.
Yes.
Okay, we heard about Wayne Alford. And we heard about a bunch of other names in this
Correct.
timeline that you were going through. Well, first of all, let me just ask you this. When you were asked about all these events, you were referring to some sort of, you were refreshing your recollection with a sheet that was in front of you.
Correct.
Okay, that was highlighted, color-coded.
Correct.
Okay, did you create that sheet?
Mr. Abadi had created the sheet as a timeline.
Okay, so when you were testifying about those events, you were refreshing your recollection. You were being asked questions by the prosecutors, correct?
Correct?
And then you didn't have any reports of your own with you, did you, about any of these events?
No, I didn't. I was at the GBI at that time, and they were APD cases, so they wouldn't be my reports.
So you didn't investigate any of these events?
So the way it would work is gangs typically doesn't take an aggravated assault or a homicide or things of that nature. We will work with those units and provide them information and assist with their investigations. So the reports, I will help with the cases, but they would fall with those investigators.
Did you have any reports with you when you were your reports with you when you were discussing this?
No.
Okay. But you were refreshing your recollection off of a sheet of paper that was prepared by the prosecutor.
Well, this is something we had discussed. There's numerous incidents, so we needed a timeline to keep them correct.
All right, well, let me just ask you this. In all those things, 2019, 2020, that you discussed, all those events, Shannon Stillwell wasn't charged with any of those events, was he?
He was not.
Okay, cool. You remember when you talked about how I was asking you about your reports and you said you write them in search warrant applications?
Correct.
All right, I want to talk to you about that. You did a search warrant application for the house of Jeffrey Williams on 355 Allison Drive, correct?
Correct.
Not moving the evidence. I'm going to ask you some questions about that affidavit. Would having your affidavit that you wrote
Sure.
up there with you, would that be helpful?
Sure.
May I approach?
You may.
Okay. These affidavits that you fill out to take to a judge to try to get a search warrant, they're under oath?
Yes.
Okay. A judge relies on them, relies on the accuracy of them, correct?
Correct.
Relies on them to be complete.
Correct.
The intent of an affidavit is not to mislead a judge, is it?
No,
Okay. And you wouldn't
Uh-oh.
mislead a judge, would you?
I would not.
Uh-oh.
And you filled out this affidavit on May 9th, 2022, correct?
Following the presentation to the grand jury, yes.
Right, May 9th, 2022?
Correct.
Yeah. And that was also in the wake of these various attacks on Lucci, on Rashawn Bennett in the jail,
Correct.
okay? In fact, you were interested, you had that one with Jada Myrick, with Mr. Eppinger and Mr. Sumlin, and Mr. Eppinger was trying to get Mr. Sumlin to talk to someone to get payment, right? And you suspected that person to be Jeffrey Williams.
Suspected, and that was confirmed by Mr. Sumlin.
Okay, so you suspected that to be Jeffrey Williams.
Right, and was confirmed by Mr. Sumlin, yes.
Okay, again.
Yes,
just
I
please,
suspected,
just
yes.
Questions I ask, okay?
Doug.
So you saw a search warrant for Jeffrey Williams' home for evidence on these matters, correct?
No,
Okay. You saw the search warrant for Jeffrey Williams' home.
for his body, for his cellular devices, and for gang evidence.
Okay. Okay. So, in Mr. Williams' home.
Correct.
In your affidavit is what's used to develop PC or probable cause for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page, you reference a post that you saw on the internet about Jeffrey Williams posting YFN, and this is already in evidence, YFN, if ain't like what you do for your mother and kids, I would have been killed you, right?
Correct.
That's referenced in your affidavit.
Which
If-
page is not on 4?
Well, mine's not numbered, but I'm just gonna go by. Right, it's on the 5th page, I'm sorry. If we count, and again, they're not numbered, but I'm just going by the 5th page that I have.
So,
And it would be the first, it would have been the second full paragraph. So there's one sentence and then 2 paragraphs down.
1, 2, 3, 4, 5.
You can look at my, may I approach?
Yes.
Right.
Okay, that's different than what I have.
You reference seeing on XXL this magazine, you reference seeing this post that Mr. Williams supposedly made, correct?
Correct.
Okay, and that made your affidavit because you thought that was important to show Mr. Williams and his veiled threats to Mr. Bennett, correct?
Correct.
Okay, cool. Could I have that back? I'm just going to need,
Sure.
I'll bring it back to you. Now, you also, 2 pages after that, whatever page you have it, I have, in the beginning, it says details 4.
I'm going to have to see the page because these pages are, whatever I have is not the same as yours.
You can have
Okay, no, I see that one. Okay. I gotcha.
All right. Also in your affidavit, you include a text thread between Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And as part of this text thread, you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit, yes?
Well, there's one particular line that you put in a bigger font, and you also circled it, or it's circled, correct? On these,
It's circled, yes.
okay. And you circled it to draw attention to it, correct?
To what I was referring to, yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that
Holy
passage
moly.
said by Mr. Williams in the text thread, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts, yes.
Okay. What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
Well, he's referring to YSL ruling the world
Yeah,
as an organization, and it could be a play on words or a play on things that have happened, saying 24M on a racial expletive head.
okay, 24M on a racial expletive head. It sounds like Mr. Williams had money on someone's head.
It could be taken that way, yes?
It could be taken that way, and you
You
highlighted
circled
it
it.
and circled it for the judge, correct?
Correct.
Okay. And you believe that too. You wouldn't have misled the judge about what was being discussed, would you? You believed that to be a threat, didn't you?
I didn't say it was a threat. It's saying that he's willing to, that's how they talk. They'll talk
put it in
about,
a
they have the
PCA.
ability to put money on people's heads.
Okay. Mr. Kokomo, could you please publish Jeffrey Williams 3 and 4, is that correct?
Show Lil Uzi. This is crazy. She's
Okay.
still
Could you
doubling
please
down.
publish Jeffrey Williams 3.
She put this in a probable cause
Before you
affidavit.
do that, and this thread that you highlighted in your affidavit to the judge, this thread between Wooney Lee and Mr. Williams took place on February 7th, 2021?
Correct.
Okay. You just started over, Mr. Kokomo, with volume. All right.
We can put 24M on the front of your head. Y'all young hoe get in line. Slime rule the world. Believe it. Y'all niggas out this motherfucker spending 24 million on their heads. We can put 24M on the front of your head. Y'all young hoe get in line.
Okay, and could you please publish Jeffrey Williams 3A? You see, what's displayed is Jeffrey Williams 3A?
I do.
Okay, and it's a reaction, Jeffrey Williams reacting after Lil Uzi Vert put a $24 million diamond into his head.
Correct.
Okay. Did you know about Lil Uzi Vert and the $24 million diamond and that reference when you filled out this affidavit?
I did not, but I would still stand by what I put in the affidavit.
Okay, so
Wow.
you're telling me right now, on a sworn statement to a judge with knowledge,
You would do it again.
that Lil Uzi Vert just got a $24 million diamond put into his head the days before Mr. Williams typed that, you would still put that quote, YSL ruled the world, 24 million on an N head in that affidavit?
Objection. Vague, compounded, maybe mischaracterization.
Ruining my
of what
case.
The witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond in his head and that Mr. Williams was referring to that, would you still have put that in the affidavit?
Yes.
To mislead the judge?
Not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL, so I think it might be a new, like a term they're going to coin. Like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As
Forehead.
the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote say, Jeffrey Williams brags that YSL rules the world and has $24 million.
All right, and just so we're clear, as we sit here today, as someone, a law enforcement officer, even with knowledge of this, you would still put that in front of the judge?
There are different interpretations to everything as we've seen throughout this whole trial.
Yes, you have many
I
yourself.
agree. Can we make our determinations, or are you going to make the determinations for us?
Objection. Argument is
Sustained.
Worth it.
Do you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've seen.
So your answer is no, your interpretation is perfect, pristine.
My interpretation was YSL rules the world, and they have $24 million. That's what I wrote in my words in the affidavit. I didn't say Mr. Williams has $24 million on YF and Lucci's head. I didn't say that. I said YSL rules, he claims that YSL rules the world and has $24 million.
Now, you didn't say it, you just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same font as the date and time, the same size as the date and time as the name, the Instagram handle.
In the circle?
It's circled, correct.
Let's talk about you, Ms. Knight, could you pull up 227 VV A6B? Thank you, Ms. Knight.
Is this the Glock ID picture? Are we getting the Glock ID picture? Heck yeah.
Yesterday, you indicated that, now this is from a video.
Correct.
With Mr. Nichols.
Correct.
Rolling a blunt.
Correct.
Okay. And then there's other individuals there, correct? There's other individuals in the room?
Correct.
Okay. And then it's on Mr. Stillwell's phone, so you're presuming that Mr. Stillwell was filming the video?
It was filmed from his device. So
Right,
yes.
right. Okay. So yesterday, you made a claim that a gun, well, what did you say? A gun is, I don't want to jumble your words. What are you claiming about the guns on this table?
A gun is what?
You identified or thought a gun was consistent with something?
It could be consistent with a Glock 27.
Could be consistent.
Correct.
Okay. And which gun is this?
The one towards the back right here.
Okay. Could be consistent with a Glock 27. All right. It could also, well, first of all, are you a firearms expert?
I'm not.
Okay. You're just someone who's owned a Glock before.
Several, yes.
Okay. And before yesterday, had you ever made the claim that, oh, I reviewed this video and this appears to be a Glock 27?
That was my first time testifying yesterday, so where else would I make?
What about reports? Did you ever write a report and said, I reviewed this is very important. I reviewed this video that was in Mr. Stillwell's phone, and I believe that that could be consistent with a Glock 27.
Well, while reviewing the evidence in preparation for trial, when I took a better look at this video and found it, it was probably 2 or 3 days before I testified. And that's when I first had to really research through and look at photos and kind of isolate what kind of gun that was.
So the answer is no, you didn't write a report.
No.
Okay. And certainly the first time saying it to me or anyone on this side was yesterday in court.
Correct.
Okay. You say it looks like it could be consistent consistent with a Glock 27 based on the shape of the bottom of the grip. Is that correct?
Correct.
Okay. It could also be consistent with a Springfield firearm, correct?
I'm not familiar with a Springfield, but from how the magazine looks, also it could be consistent with a Glock.
Okay. It could also be consistent with a Sig Sauer. Could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a firearms expert.
I
You're
never-
only familiar with these Glocks.
I never claimed to be, Mr. Schardt.
Okay, well, you start identifying guns in court, kind of making yourself an expert, but you're not an expert, are you?
I'm not.
Okay. And you don't even know, whatever this gun is, if Mr. Stillwell left with that gun or didn't leave with that gun. You don't know if anyone left with that gun. You don't know whose gun that is.
Correct, but we don't know that they didn't.
Okay. Great. Let me ask you this about your Glock 27 that you say this looks consistent with. When you shoot your Glock 27, does it expel shell casings?
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 27 and the 43. I prefer to shoot a 9mm, so I went with the 43.
So you don't even own a Glock 27?
What?
I just said when I was researching the two, handling the two at the gun dealer.
So now you don't own a Glock 27. You were researching it, which means you were handling the gun at the gun dealer. That's your experience with the Glock 27.
I never asserted that I owned one. I've seen one. I've handled one. I can recognize one.
So you've handled one at a gun dealer, and that's what you're basing the identification on.
I've recovered a good bit of guns in my
Okay.
career. I know what they look like.
All right, let me ask you this. Since you know about guns, at least through your career, Glock 27s, when you shoot them, do they expel shell casings?
Yes.
Okay, Glock
Where is it?
27s, when you shoot them, do they make a loud bang?
Yes.
When you shoot a Glock 27, does it create a muzzle flash?
It should. I mean, when you
Okay.
shoot it, like during the day, you wouldn't see it, or sometimes at night you can see it, but
Okay, and when you shoot a Glock 27, does it emit gunshot residue?
if it's inside of a contained area, yes, it would.
Okay. All right. Remember on Friday you talked about you get to the end of an investigation, something seemed small is huge. And we were
Correct.
talking about the post. All right. Well, there's one thing, surveillance video. You would agree that that starts huge and remains huge? Like
Every-
surveillance video is a pretty important part of a case.
Every investigation is different, but yes,
Okay. You've seen the BP video, correct?
I have.
And you've seen it, Detective Hogan showed it to you?
He did, for the purpose of identifying the individuals, yes.
Right, okay. Have you seen the FedEx surveillance video?
I have.
Okay. I'd like to watch it with you. Is that okay?
Sure.
Mr. Kokomo, if you could cue it up. Okay.
This is just
before you
crazy.
start, Mr. Kokomo, investigator, when did you first see the FedEx video?
It was after, I met with Investigator Hogan in the afternoon of the 16th, so it would have been after that.
Okay. Well, are you aware that, and maybe this will help you answer this question, you're aware that Detective Hogan swore out warrants against my client without ever viewing the FedEx video?
I can't speak to what he did or did not do.
Okay. When did you most recently watch the FedEx video?
Probably maybe like a week ago,
Okay. How many times in total have you watched the FedEx video?
a few times.
A few times. When you say a few times, how many is it?
I mean, I've watched it a year ago, or a couple years, like 2 years ago. I've watched it.
Okay. Mr. Kokomo, if you could please publish the FedEx.
Here we go, you guys. Here's the FedEx video.
Okay. Go ahead, Mr. Kokomo. Mr. Kokomo, if you could pause that video right now. Thank you. Investigator Viverito. At this point in the video, as we have it paused, you would agree that Mr. Drinks' red Versa is on the left, correct?
Correct.
Okay. You would agree that Mr. Stillwell's rented white Audi with tinted windows
Correct.
is in the middle. And you would agree that Mr. Nichols, actually Miss Lewis, Mr. Nichols' wife, that Ford Fusion is on the right, correct?
Either the right or staggered behind it, yes.
And according to your investigation, Mr. Drinks is alone in the car,
Yes.
okay? Mr. Stillwell is in the car with Mr. Garlington per your investigation.
Correct.
And Mr. In the car, the Ford Fusion, we have Mr. Nichols driving,
Correct.
Mr. Boyer,
Correct.
and Mr. Farley.
Correct.
And your theory is that while at this light, Mr. Stillwell shot Mr. Drinks, correct?
I'm not the homicide investigator, so I'm going along with the evidence that was presented to me by homicide. But yes, that's consistent with what Detective Hogan, his case.
Well, you know, he swore out a warrant for Shannon Stillwell for actually shooting Mr. Drinks.
That's consistent with what Detective Hogan had found.
Okay. In this video, you could see headlights, correct?
Correct.
You could see traffic lights,
You can see tail lights and traffic lights, yes.
and you could see brake lights, correct?
Correct.
All right, awesome. Mr. Kokomo, could you just play the video? And I'm just going to ask you to look at the cars closely.
Mm-hmm.
Okay, pause, Mr. Kokomo, please. All right, so we're paused at 1:02:36 on this video. At this point, Mr. Stillwell in the white Audi is pulled off, correct?
Correct.
Okay, and Mr. Nichols and with Mr. Boyer and Mr. Farley have pulled off.
Correct.
Okay, while they were there at that light with Mr. Drinks, did you observe any muzzle flash on that video?
No, and with this quality of video, I would not expect to see it.
Okay, right. You just
Play
see
the next 3 seconds.
brake lights and traffic lights and headlights.
Trap.
But no muzzle flash. Okay, I got you.
A muzzle flash is much, much, much dimmer than a brake light. Like if you're shooting at night, you're hard pressed to see your own muzzle flash.
Firearms expert again.
I'm telling you, my experience from shooting a firearm, we do take night firing courses.
Okay. So let me ask you this. Gunshot residue. You aware that the headliner from Mr. Stillwell's car, the Audi, was collected and tested for gunshot residue?
I am.
You ever talked to Alexander, GBI analyst Alexander Coven about the results that he found?
I have not.
And you are aware that warrants were taken out certainly before any of those GSR results were in, correct?
Correct.
Let's talk about tint. You've been preparing with the state. You know that the state has said that Mr. Stillwell had tint applied to his windows of that white Audi upon renting it, correct?
Correct.
In violation of the rental agreement, I may add.
Correct.
Okay. And this tint was applied on Flat Shoals Road, according to the district attorneys, at about 6:30 p.m.?
According to them, yes.
Okay. You were able to observe the white Audi on March 16th?
I did not walk. Wasn't that interested in it at that point, so I did not walk. It was very, very dark.
Have you seen the pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested?
I have.
Did you see any damage to the tint, specifically the front driver passenger tint on that car?
I did not.
A little honesty. Okay.
Mr. Kokomo, if you could rewind again. No, actually, you know what? I'm sorry. Keep it here. Keep it here. Just play it. I'm sorry, Mr. Kokomo. Okay. You saw that car speed up behind Mr. Stillwell? Pause it, please. You saw
Yes.
that? Mr. Stillwell, you're aware that he, well, you've already stated this, he was victimized in the past. Someone shot through the rear windows, killing Tiara Jones.
Yes.
And now, that car that sped up is next to Mr. Drinks, correct? Or approaching Mr. Drinks?
It's approaching, but it stopped short of Mr. Drinks.
Okay, Mr. Kokomo, if you could please play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from the angle that it looks like the front of the car. I'm sorry. The front of the car is like, from what I can see, looks like the front of the car. The front wheels are still towards the back of the vehicle. It's not like exact with the car.
Okay. Mr. Kokomo, if you could please play. Pause. See that car make a U-turn?
I do.
Okay. What car was next to Mr. Drinks when that car suddenly made a U-turn?
Judging by how the lights are, that car still appears to be back a little bit, but next to it.
All right, so now you're making three-dimensional evaluations, but we can't see a muzzle flash off this.
A muzzle.
AMV.
Mr. Schardt, I'm going to explain to you. When you're, I don't know if you're mischaracterizing it. When you go to the range, example, to fire your weapons at night, and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted, if it shows. So this far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that would have let this person know, no, I need to find another route?
No.
Is there a officer saying, hey, turn around, you can't come this way?
No.
Is there an animal crossing the road that would have made this man do a U-turn?
No.
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay. Do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay. Could
The heck, lawn crime? Lawn crime! Oh my gosh, not while Schardt is cooking. What is this? Lawn crime! Maurice! Okay, Atlanta news first. Who pulled the plug? Holy moly. All right, let's see. Fox 5 Atlanta. Oh my God, it's all of them. No. Why is this happening today, right now? Oh my gosh. Oh my God. I'm gonna cry. Wow. Wow. I see the chat is on it. Type shit low says Fox 5 is the same. You guys are all checking and verifying right away. This is crazy. Oh my gosh. Let's see. I don't know. I guess we'll stick with Law and Crime. I do have Fox open in another window, but it's the same camera, so if one comes back. Ah! Not the rainbow colors. The old school, not working symbol. Okay, we can go back to...
I can see, looks like the front of the car, the front wheels are still towards the back.
Okay. Off this.
A muzzle. Mr. Schardt, I'm going to explain to you, when you're, and I don't know if you're mischaracterizing it, when you go to the range, example, to fire your weapons at night, and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted, if it shows. So this far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that
a train
would have let this person know, no, I need to find another route?
No.
Is there a officer saying, hey, turn around, you can't come this way?
No.
Is there an animal crossing the road that would have made this man do a U-turn?
No.
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay. Do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay. Hypothetically, could that car made a sudden U-turn at that exact moment because they heard a loud bang?
Checks your honor, be speculation, although she's an expert, she's not an expert in.
I'm gonna allow it.
That would be, no, that would be problematic based on the video.
That would be problematic based on the video. So you're telling us that you know that this person did not make a turn due to a loud bang?
If you're going off the loud bang theory, may I explain?
Yes.
If Mr. Kokomo can hit play, or rewind it back and hit play for a second. You're going to see there's a gentleman or some person walking here. They do not break stride. They do not flinch. They do not stop. They do not jump back. They continue walking towards your loud bang or your gunfire.
Well, actually, they disappear.
Can see that?
It's not a bush. It's a shadow. And I went out there and...
Trees right there? I've been out there too, Miss.
Okay, I've been out there too, so they're like walking through, but they don't break stride. They don't jump. They don't run back. They don't run from the gunfire. So if it was gunfire enough to make a car stop, pull a U-turn in the middle of the road, that would certainly be, and using your theory, make a person get taken aback a little bit and run away.
So who's that person?
I went out there and canvassed. That's an area where it's there's a large homeless population. It's very transient, and there's also a Greyhound bus station right there.
So you didn't talk to this person?
I did not.
You're saying that they didn't break stride and all that. You've never talked to that person. You've never identified that person.
Could not. I tried.
Okay, but again, I'm going to ask you, and if your answer is really no, then that's fine. You're telling us, you're telling the jury that you, as the determiner of facts, have determined that that person did not make a turn because of a loud bang.
Consistent with the person walking that would be outside of a vehicle that had no reaction at all. That's what that would lead me to believe. And I didn't charge this case, so I'm not the determiner of facts.
All right, let's talk about something else while we got this video. Mr. Kokomo, if you could just play. I want you to pause for a second, Mr. Kokomo. I want you to pay real close attention to Mr. Drinks' car.
Okay.
His brake lights. Now you see the other car pull up a little bit more?
Correct.
And you see the brake light go once, on and off?
Correct.
Okay. You're aware that Mr. Drinks was shot twice.
Correct.
Okay, and you're aware that the fatal shot was to the neck.
Correct.
Specifically, it was through the basilar part of the occipital skull.
I don't know that. I know it was in his neck.
Okay. And as an investigator, as the investigators you sit here today, did you find the brake light going on and off significant?
I saw the light going on and off, yes.
You don't find it significant?
I'm not a medical examiner, but
Okay. Cool. Have you spoken to the medical examiner in this case, Miss Dr. Melissa Sims Stanley?
no, I have not. I'm
Okay,
not the
and-
homicide investigator.
All right. Are you aware that Dr. Sims Stanley testified that upon being shot
Objection.
in that exact spot,
Hang on just a second.
Improper question with a lack of foundation. And she can't listen to testimony to know what the doctor would have testified to. And she said she has not spoken to.
Overruled.
that the loss of any control over your body parts would be instantaneous,
Okay.
okay? And that if shot in that exact spot, no one would have the ability to lift their foot on and off the brake.
Okay.
Have you spoken to Dr. Stanley? Did you know that she called that a medical impossibility?
Objection, Your Honor, that's improper with a lack of foundation. So this was the speculation.
Those two objections are overruled.
Objection, facts not evidence of mischaracterization of her testimony.
That objection is also overruled.
So, how long had, and we can rewind it, Mr. Kokomo. I want to know how long after Mr. Stillwell in that white Audi had left Mr. Drinks, how much time passed between that moment and when Mr. Drinks' brake lights are going
A couple of seconds.
on and off? Well, we're gonna, Mr. Kokomo's gonna let us figure this out. Right now, that's Mr. Stillwell next to Mr. Drinks, correct?
Yes.
And Mr. Stillwell's leaving now at 1:02:26. And the brake lights have now gone off at 1:02:45. 19 seconds to be exact, correct?
Sure.
All right. That car that was next to Mr. Drinks when the brake lights were going on and off is also the car that was next to Mr. Drinks when the car pulled a U-turn, correct?
I don't know if I'd characterize it as on and off, like multiple times, but that was the car that was a little bit further back from his car, yes.
Okay, and that's the same car that was next to Mr. Drinks at the time of the U-turn, correct?
Staggered behind Mr. Drinks, yes.
Okay. Have we identified that car?
You keep asking me about the homicide investigation. Unfortunately, with APD, we're not allowed to be in, like, may I finish? I can't answer your questions about Detective Hogan's homicide in full.
So you don't know if anyone used LPR readers to determine the license plate of that car? That was
You
next to Mr.
would
Drinks?
have to ask Detective Hogan.
Okay, and we don't know who the driver of that car is, do we?
You would have to ask Detective Hogan.
Okay. Has the headliner from that car that was next to Mr. Drinks, when the brake lights were going on and off, when the other car was doing a U-turn, has that headliner ever been collected?
You would have to ask Detective Hogan.
What are the gunshot residue test results from that car?
You would have to ask Detective Hogan.
Okay, thank you. I have no further questions.
All right, it's a good time to pause for lunch. So let's be back at 1:40, please.
So doing an hour lunch. Crazy that this is going on with the crazy. What are you guys thinking? Because I think this is the state's worst witness officially. Yeah. Oh,
Before 1:30.
1:30 or 1:40?
1:40, 1:40, sorry.
Nothing from the station, right?
Okay, see y'all at 1:40.
no issues, and Hylton wants that full lunch. She doesn't want to miss any minute. She wants all of that lunch till 1:40. Now, this is crazy. I mean, and so far, I mean, when we were on direct, right, there were things that, like, the chat would be like, oh my gosh, they need to clean that up. They need to, I can't believe they just let that fly. They didn't object to it. But look at the way that Schardt is teeing up every single issue that we might have raised a fuss with in the chat while it was happening on direct. Schardt is teeing it up on his cross rather than objecting to it in the moment. You can see how much, sometimes Viverito's getting double wound up. The scene, to see, the city issue. In front of the jury, she's given 2 different answers across different days and then double down on it. We have a probable cause affidavit for the search warrant on Jeffrey Williams' home. She gets called out on it and says she would do it all over again. I mean, if we objected and raised the fuss and moved on from the subject, we never would have gotten that. Then we get this video, which I know everyone's seen a million times, but finally we're having him lay it out step by step. And she's trying to excuse things every second. Every time she gives an answer, she's trying to explain something. And when you have someone say, well, the person walking didn't jump, they would have jumped. So why would the U-turn be explained by someone noticing something crazy and wanting to turn around and get out of that mess if the person didn't react? Well, by that logic, that person didn't react 2 minutes earlier or 2 seconds earlier when you claim that the shots were fired from Shannon Stillwell's car. Like, this is crazy. And then you literally go into talking how you canvassed the neighborhood. So this is a whole mess, you guys. This is crazy. Yeah, Jackie, she cannot be rehabilitated. Can you imagine what redirect is going to be like? Like, holy moly. I'm her. She put all of this in front of a grand jury and lied. Also, big shout out here to Kayla. Thank you for the 10. No comment, just pure 10. Good to see you today. I think, are you in court? You might have gotten out of there when the feeds cut, but I think Kayla's in court today. So Kayla, feel free, if you have anything to share, feel free to let us know, and you don't need to super chat it. We'll be able to read it out loud. But good to see you. Shannon Alexander says another way to say I don't recall. Like, this is a whole mess. Casey Dog, yes. The victims' families are being disrespected by her. And it just makes you wonder, you know, I understand there are people that are more inclined than I am, right? I have a different starting position when it comes to criminal prosecutions, because I think the state should have absolute sunlight on what they're doing. We need the transparency. They bear the burden. Prove your goddamn case, right? And I'm all 100%. That's where I stand. But I know other people are like, well, you know, I think as a means to an end, if someone out here is in a lot of trouble, causing a lot of trouble, give the state some grace. I disagree, because that's not the way I look at the Constitution and a lot of state constitutions as well. But for people that are concerned about the victim's family getting justice, how is this the way to do it? There's no way that this process, this approach, this curation by the investigator, who's willing to pass the buck and put it on Hogan when she doesn't want to explain something. How is this justice? So Casey Dog, I absolutely agree. The victims' families are being disrespected by her. Like, she's an unlikable person. If I was the victim's family, I wouldn't want anything to do with her. Go away. You're making this worse. Sweetie88, thank you for the 10, says it's absolutely disgusting how she continues to try and sound right no matter how dumb she sounds. I am literally disgusted. It's infuriating. It's infuriating. And I mean, I don't really have, this is just, I think this speaks for itself. I agree. And I know on a stream when things are happening, sometimes my shocked face probably looks like I'm laughing. And I am laughing because it's just such an awkward thing to see playing out. But it also makes me mad. Makes me mad. Yeah, and this has been great too. The judge overruling all the objections today. And she's had a tone some of the times when she says overruled. Sometimes she's saying overruled before Hylton finishes stating her basis. So, love to see that there. Casey Dog says she's everywhere yet nowhere. Exactly. She sees everything. She gets notifications when people post, but she didn't see Jeffrey Williams talk about the Lil Uzi diamond. And if you look at the timestamps, it's like within the same 24 hours. So it's not like it wouldn't be common sense to put 2 and 2 together. It actually seems like common sense to say Viverito chose not to see it that way on purpose because it wouldn't fit her narrative. And then to tie that with the threat, the supposed threat on YFN Lucci, when that was worded as, if I didn't like the way you treated your kids and your mom, I would have been handled you or whatever, or you would have been dead. If you would have been. So to me, that sounds like, hey, if something was happening with Lucci, it's not me. Because you wouldn't even be here to claim I was doing something to you. Because I would have handled it. Therefore, it's not me that actually has anything to do with what you think is happening. Like, if I wanted you gone, it would be done. So, that's not a threat to me. In my book, that's not a threat. That's clearly I'm not the one causing you trouble. Because you wouldn't be here to talk about it. So, Tina Haskenhoff says, I was about ready to throw something at my TV. Right. There is just something that's infuriating about her in a way that's totally different than the other detectives that have testified in this trial. And I keep calling it a mad scientist thing. That's the best way I can conceptualize it. But there's just something so infuriating about her determination in being right when she's so wrong. Thank you, Tina. STS says, I think someone tried to sabotage the public feed. Yeah, it's weird that it's still down. I mean, maybe let me open up. Let's see if Kathy Roussan, give us an update. Tell us what's happening. All right, they said that they're working on it during the lunch break, so there's that. There is that. But STS, like, yeah, remember Schardt said the discussion on the internet. I don't know. This sucks. I don't know if I think it was sabotage, but it definitely sucks, like specifically of all time. All times for it to go down. was right in the middle of like, you know, when they throw the oil on something, you're getting hibachi, they throw the oil to make the fire like voom up. Like that's what Schardt was doing, and the feed was like, nope, not live anymore. So, but yeah, just a whole mess. Too coincidental. Hope they fix it. And I know you guys in the chat a few times are asking about closed captions today. There were other times throughout the stream where Law and Crime refreshed. It wasn't me. I break things a lot, but there was closed captions went off and then they came back on their own. Stuff was finicky about the feed today. So hopefully they get that fixed and we can get closed captions consistently because I saw you guys asking for them. Brian B says 60-second all caps for Max. We can do that, you guys. We can do a 60 seconds all caps here. Go ahead. Go ahead. Totally with that. Shout out to Brian B. If you don't know what else to say thanks to Brian B for the excuse to be loud in the chat. Be louder than Viverito in the chat. And then David Newth, good to see you, David, says that's one of the major issues with shooting at night. The muzzle flash is like a flash bulb and it can blind you momentarily in a dark space. Now, if this is part of training, right? I don't know, so I can't speak. But David, I'm going to take your word on it. If this is something that's commonly advised, commonly mentioned, it's even dumber that Viverito was like, no, and you might not be able to see the muzzle flash. It's blurry, but we can see the person making strides or maybe jumping at the same time, right? Everything she said made something else she said sound more dumb, right? We can't see the muzzle flash. It's too blurry, but we can see body movement of a person. We can tell a bush from a shadow. That's a shadow, not a bush. Because I've been in the bushes. I know the bushes. Like, just a mess. There's a whole mess here. And common sense tells me you can see a muzzle flash. I also really don't think that a brake light, there might be a wider frame of lights for a brake light, but I don't think as far as measure of brightness that a brake light is necessarily going to be brighter than a muzzle flash. Not an expert, but I'd be sitting like this on the jury. Like, so, I don't know. Yeah, Orlando Antonio, definitely. Max said it's Burrito Tuesday. Absolutely. Guys, it's just like all week we just gotta have like burritos or burrito bowls, right? You can do a naked burrito. Definitely all week long. Thanks for the 10, Orlando. Thanks for making me hungry. Viral Me Crazy says she sounds like Detective Burke from Raising Kanan. But what's the problem there? When in the storyline, Detective Burke was determined to the point where it led to her demise. But she was onto something. She was actually onto something. So, slightly different there, but same conviction, right? She could have been wrong and had the same conviction. So, great reference there. Lovely, thanks for being a member. Peter Ortiz says, ladies and gentlemen, welcome to the circus. Welcome! This is like day 163. This is like the final stop of the traveling circus. Day 163, state's final witness, and it is the worst one yet. Cannot believe it. Thank you for the 2, Peter. Dolly1 says she didn't search for the 3rd or 4th car because it was Hogan's case, but Hogan's relying on her to identify things. Like, where is this just like hot potato? But looked for the walking homeless man while it's still being Hogan's case. Everything she says makes the last thing she said sound worse. And I'm telling you, this is why, and I don't really need to tell you guys get it, but it's why you didn't see Schardt objecting, right? That was a very long direct, and we had like 30-something objections total. And thinking back to one of the cross-examinations that was maybe 45 hour and 15 minutes long, and Love objected like 32 times. So I think it was when Steele was crossing somebody. So that was a whole time. But we didn't really get that many objections, all things considered, for this exact reason. Just let her get caught in her own web, right? So thank you for the 10 here. AK says, look at Max when the objections were overruled. I mean, he's been cheesing all day. We can go as soon as we get through some of your guys' thoughts. We can do a replay on that last bit with the video. So, cue this up. Classy Beats dropping 10 gifted subs in the chat. Can you guys throw some classies in the chat? Big thank you here. I know I'm behind on the banner. I'm so behind on the banner. I've got to update objections. I wasn't counting. But definitely want to show love to everyone that's being so generous and giving gifts to the channel, supporting the channel, and making it a lot more fun, because everyone that has a gifted membership, or if you became a member yourself, you can use your very own burrito in the bushes emoji. There's a channel emoji for it. So feel free to use those to your heart's content. And Steph, thank you so much for dropping Classy's link in the chat. Great content creator with a morning show every morning if you like recaps, having something to do while you get ready for work. But also, again, Monday, Wednesdays, and Fridays. And shout out to Steph because she premiered her music yesterday. But Mondays and Wednesdays and Fridays, a music program. Great way to rewind. And we do drop some jokes and stuff in the chat, some references to this trial, because so much has depended on lyrics. So it's a really great place to hang out and relax. All love here to Classy Beats. Thank you, Steph JK, and congratulations. So proud of you for premiering your music yesterday. Classy also says, that chick has lied on the stand so much, it's crazy. Shaking my head. Keep up the great work, Kat. Shout out to the beautiful Amy E. Shout out to Amy E. Heck yeah. All love for Amy. Yeah, just crazy. And it doesn't stop here, but I still can't believe she said she would do it all again with this probable cause affidavit. Like, I get that that can happen, right? Police will misrepresent in these probable cause affidavits. And, you know, sometimes it can go unchecked. That's why they do it. They want to get the means to the end. But at the same time, when you're called out and it's shown loud and clear right in front of you that you were wrong, for you to say that you would do it again, that means you would misrepresent the same information to the judge again. That's not good. That's not good. So, thank you again to Classy and to Amy E. Brian B says, true slimes, hit the thumbs up. Just make sure you do it an odd number of times, right? Don't hit it twice or 4 times because it'll end up being a net 0. Gwen and Garnett, yep. Gwen and Garnett says 24 million Diamond said so much. Yeah, and she kept trying to defer. Well, he's saying that we rule the world. It's an enterprise. And you guys called it out so quick in the chat. I thought you told us yesterday that YSL is not a traditional gang and there is no leader. And now you're insisting that this we rule the world, while he's referring to someone who's not part of YSL, not affiliated with the street gang activity. Now you're trying to bring those things together and say this is Jeffrey ruling some enterprise, leading some enterprise, having 24 million. Like, none of this says what you think it says. And for you to screenshot other instances where someone that you're watching makes a social post, for you to get those screenshots within 16 seconds, 42 seconds, but then you don't see this video at all? Hello? Definitely has blinders on. Definitely has blinders on here. And I will be upset if, like, the jury doesn't catch this. I will be upset if we get, and I get the fear of, like, a compromise verdict. I get that that's an issue. But if we were to get a guilty across the board for all of this stuff, including the murders, my heart will sink to the point where, like, lights out for me for several days. I'm going to be upset. Especially after all of this. So, I think this is so good for the defense. The state's grand finale. David Newth says, I've spent hours on the range doing night shoots. You may not remember seeing the flash because you're in the moment as an individual, but that's more your reaction at the time. Okay, so I get it. You're not going to think about your own muzzle flash, but at the same time, you still have the overall knowledge that there will be a muzzle flash. Like, if you were sitting out on your porch watching someone else fire away at night, you're going to see, like, the flashes of light and have that image in your head just because you're taking it in differently. but in the immediate moment, that might not be what you store in your memory. So still, like, it just seems like Viverito either doesn't have the experience or she's lying. She's being disingenuous. Same thing. Yesterday, she told us all about how in her personal experience, and the judge paused to make sure we're talking about experience, personal experience. And she misrepresented. She made it seem like she'd have a reason, a good enough basis to be able, from a picture, a still frame of an Instagram video, to be able to identify different Glock models. Because her whole goal was to establish that she can identify it as a Glock that would shoot a caliber that would be consistent with what was recovered, the projectile recovered from Chamel Drinks. So that they have some way to tie that firearm, any firearm, to Chamel Drinks. And today we find out she talked to a gun dealer when she was considering getting that model of firearm. Didn't get that model of firearm. That's her experience. Like, hello. So thank you again, David. And NS Ogre, I think, says, knew what it was about when Love asked the judge to let the state keep all the ish they stole from Williams. Yeah, where is it, right? Because that would solve the problem. We can't return something that we don't have, so if you allow us to keep it, then we eliminate that problem. So big problems there, and that's going to go to civil. That's going to play out in civil, I think. So definitely interested in seeing how that plays out, especially now more than ever. I can't believe Pink Watch, man. That's the one that shady stuff is happening with, the pink one. Oh, Dougie. STS says, V in the right stuff. I've tried A, I've tried B, I've tried C, and I'll just squirm until you believe me. And then can you let me explain? Can I explain? If you let me explain. Every time she says that, I think it sounds worse. If someone does that once or twice, it might make sense. But when you do it for every 5 answers that you give, it's squirming. You are exactly right. That is the word. Squirmy wormy. The Honorable Yeah That says, please replay it. He was cooking, in the wise words of Schardt Cochran. Schardt Cochran. Max Cochran. Johnny Schardt. If the 19 seconds don't fit, you must acquit. No way, Paige. Let's drinks go to jury. I do think she's keeping... I don't even think we need a directed verdict on... Maybe we'll ask for it and take care of it then, but that fatal flaw with the 2 counts in the indictment charged under 16-11-133, Whitaker says unless the state can present case law, and Whitaker seems to be at the position that she knows they're not going to be able to present case law, those counts are gone. Those counts aren't going to go to a jury. That's immensely helpful for Shannon Stillwell because it's the possession of the firearm on March 14th and March 17th being tied back to Shannon Stillwell. That would be a huge, huge win for Shannon Stillwell. Because then if it's just the murder, well, we don't think he did the murder, but he had guns that right. We think he had guns on him. Well, now you take away that opportunity for a compromise verdict. Very, very big win here for the defense and the right thing to do for Whitaker. So, very, very curious about directed verdicts, if that will even be part of what they can motion for, if it's off the table, right? And we will replay, we'll get caught up. Anthony Samora says, Miss Hylton was like, objection, Your Honor, he's caused our house of cards to crumble. Literally, you're ruining my case. Oh, beautiful. My favorite kind of objections. On day 163. Day 163. Love this here, Anthony. Thank you so much for the 20. Chloe Albert's Revenge says, Lion Love hating Hylton, vindictive Viverito gang. I love alliteration, so I love this, but it is. It's like, this is the conspiracy. We're going to conspire to introduce these things in a certain way. We're going to confer with each other to make sure it looks and sounds squeaky clean. And we hope that the defendants have busy, overworked, not passionate attorneys. Like, for God's sakes, we see them asking Martinez Arnold's attorney, well, maybe you can just move forward, let us call him as a witness, even when you're gone. State doesn't want a passionate attorney, passionate advocacy on the other side of the aisle. Just really wrong in so many levels. And thank you for the alliteration and the 2 here, Chloe. Forever on Fire says, show a muzzle flash video at night, LOL. Well, it's like, Do we need to do that? Because I think it's just common sense. Oh, man. Let's see. Let's see. Oh my God, even from the search, like look at the still images when you do a search result. Like I know these are like AR-15s, but whatever. Like wild, wild. And again, she's claiming to have all this knowledge of firearms because Max put that back to back with the Glock identification and then going through the video. He put it back to back. So to follow on the tail ends of you touting yourself of how much expertise you have that you can identify a specific make of a firearm because of the caliber it fires. And then 2 seconds later, you're like, you can't see muzzle flashes at night. Who are you kidding? Just crazy. Totally impressed with Max Schardt. Let's see, that's what Lay said. Asked Detective Hogan, but listened to my observations of the video and all my personal observations and went out to the scene myself. I mean, see, but definitely not city. She's reaching. Yup. And really, the whole order of this is beautiful. Schardt laid out that inconsistency with the scene and city before he went into the representation about the Glock and then the representation about the muzzle flash on the video and this U-turning car. I mean, these puzzle pieces, he really looks at this like a sports game. Like, he coached this out for all 4 quarters. And we're getting to 4th quarter on this cross-examination. But he set the plays up for the whole rest of the game to make sure 4th quarter would be on lock. Beautiful, beautiful stuff here. Love it. I can't wait to watch it again. Thank you, that's what Lay said. Y Turner said, did y'all miss when Burrito said she owned several Glocks, then said she never owned one? It's just wild. It's just wild. Zero credibility left. Just zero credibility left. Leah's dad says, Whitty told the state to take their beating. Judge getting misled might be a sore spot for her in this case after all of this. Especially with a bad indictment. Yep. And I do want to say, I think these things are helpful for the defense. So if Whitaker was here at the beginning, these counts, as soon as the grand jury passed them along, Whitaker might have been like, if it was raised, Whitaker might have been like, oh, heck yeah, let's do away with those, and decided to keep all that stuff out. You know, you don't need to present evidence to these counts because it's not relevant. It's out. So now it'd be prejudicial or something, right? I think if this was a tightly presented case from the beginning, that would be a disadvantage. Maybe not one that the defense couldn't overcome, but I think it would be a disadvantage to the defendants. So at the cost of this trial being messy and drawn out and very long, I think it's become extremely advantageous to the 2 remaining defendants, right? Which sucks that that's the way it is. But at the same time, I think the balance, the advantage is here for, well, I guess it would be the heavy one, would be where the advantage is. You want to be the heavy one. So great point here, Leah's dad. Violet out here gifting 5 memberships. Thank you so much, Violet. Also, always love your commentary in the chat. Like to try to give a shout out loud when possible. Show some love for Violet in the chat. Very glad that you are here with us. And I'm going to update this member counter, I promise. I'll get to it. Toothless Tiger says, hey, cat mods and chat, the governor ordered it. Listen, I think we need to do a new exercise. It's been a while since we've done an exercise. One of our favorites of all time as a chat was, man, it was like 40 days ago. But we were pretending to ask questions the way Adrian Love asked questions of witnesses, with the example of making a peanut butter and jelly sandwich. We might have to do an excuse edition, as if we're Marissa Viverito. And let's say the scenario is why we're late for work. But you've got to make an excuse as if you're Viverito, so it's got to be more creative than just your tire going flat, having a bad tire, right? So let's do an exercise here. Heck yeah, Toothless Tiger. Great to see you guys. Toothless Tiger is another content creator, so if you have a second here, because we have time, if you want to go over and show some support, check out other content creators that are talking about Fulton County and YSL. Here is Toothless Tiger's link here to go do that. But yeah, we'll get another thought exercise here going. Like, oh, late excuses. Just crazy. Dee Dee says, I'm not late, I'm on time because this is when I plan to get here. Crazy. And then we need to do, guys, can we get some STS in the chat? Can we show STS some love? Because if you've been waiting to get a gifted membership, there's a good chance you got one. Like, this is just awesome. STS dropped 50 gifted memberships in the chat. So we officially have a squeak sponsor. Which I don't think I'm counting it right. But we had some squeaks today from Atkins. We'll get that up there. STS is always supporting the channel and helping to educate us on different terms, complicated terms, terms that have legal meaning that maybe go over our heads. And then also a lot of IT stuff. So tons of appreciation for STS in so many ways here. And then for him to just gift 50 gifted memberships is super awesome. Thank you for all the love in the chat. Look at the STS, the squeak sponsor. Woo! Heck yeah. There we go. And also while we're here, let me show some love. Again, a very humbling problem to have here. I don't mean to miss things, but I miss things. I do want to give appreciation here to Nene, who sent over $10 on PayPal. So thank you so much. Thank you so much for that. It was really nice of you to do. And I know I had, and it was interesting. It's something I got to look up from Chantel saying, for Doug, that the Viverito's face is all over YouTube. Yep. So I think the main picture people keep seeing is the one where she's holding the award. There's another one that's she's holding a sign that says "Way to go, Viverito." Let's see. I think there was a bunch on X. And let's see. We'll just use the Marissa Viverito hashtag and see what's going on. Yeah, pictures of Viverito all over here. And a lot of these were posted in public places. It's not just like, here's an account that I'm posting, but it's private and friends only, and it got out somehow. Like, this stuff was posted all around. So yeah, big thank you there to Chantel for the reminder. I mean, there are people that, like, why is her face not being shown? I don't have an answer. Judge agreed with the states in the arguments they made that I guess it was for her security, but it is what it is. And also Detective Flores, the other messy detective that, you know, helped with Waters Road, was working this case for 3 days, Schardt asked, and then that was it, just 3 days. He wasn't shown on camera either. So very interesting. The state wanted to make sure they protected the facial expressions. They didn't want the facial expressions to be seen publicly for those witnesses. Again, big thank you to STS. Thank you to the chat for showing so much love. KC Dog says that love went to the basement and hit the breaker box to cut the camera feed out. She said, anything, get this off. Gwen and Garnett says, I've been binging 48 hours, 98 cops are tunnel visioned. Yeah, to me, mad scientist is the way I conceptualize it. Tunnel vision, same thing. Like, you just think on this linear path. You don't want to see anything that disconfirms what you're already trying to see, because you want to keep moving to the path forward, right? Like, we should not be treating criminal prosecutions, investigations, arrests as manifest destiny. That is not how we should be approaching this stuff. It's not allowed by the Constitution. And we find all these wishy-washy ways to squeeze through it as a means to an end. It should not be okay. And I totally think, tell you again, and I think I'm pointing the wrong direction because I think StreamYard flips me when it gets to you guys. I wouldn't do this Bush picture of Viverito if I didn't think it was important to shame her for what she's doing. I am confident that she has misrepresented information in her investigations. And she told us today that she would double down on that same type of misrepresentation. So the gloves have been off for me. They're out. I put gloves back on to take them back off again with Viverito. She should feel embarrassed. She should feel ashamed. Because if she doesn't, then there's absolutely no chance. And I'm not saying there's much of a chance, but if we don't point out that what she's doing is wrong, what's going to be her motive to change? Or reflect on what she's done? And I don't think she's anywhere near close to reflecting on things, but, you know, maybe with due time. Maybe with due time. And if people were genuine, people are able to admit they're wrong, I wouldn't be having a moment watching the way she acts on the stand. It would be unfortunate, but a little bit different if someone said, wow, I really had no idea that this other thing happened with the diamond on someone's forehead. I mean, I would never conceive that somebody would embed a $24 million jewel on their forehead. So it was just over my head. No, I would not do that again. Right? It sucks that we're here, but at least, I can say okay to someone saying that at this point in time, knowing what they know now. But Viverito refuses to know what she doesn't know. She wants to stick with what she thinks she knows. So, just crazy. Just crazy. Peter Ortiz says, does Max have witnesses? I do believe Max is going to put on a case in chief, but I mean, that could change. I mean, can you imagine going out with a bang and this is it? We're going to have some redirect, right? And maybe some recross. But imagine if this just went to the jury right now. Like, it ends with what we ended with right before lunch. And the jury's like, well, what do you make of all this? Go decide. I mean, I get it. I don't have a full scope of the needs. I think Schardt's probably still getting some clarity because of the jury charges, right? This determination and how jury charges this conference are playing out might change how or if he presents certain witnesses, calls certain witnesses on his case in chief, right? So I don't know. But I'm sure he has witnesses prepared if he decides, absolutely. So good question here. I don't have a definitive answer. KC Dog says there are not enough characters allowed to mimic a burrito excuse. Oh, that's true. Good point. I think this wins. This wins. Let's see. Living in Truth, thank you for the 2. Appreciate you big time. Kim Hunk says, I received a gifted membership, got the email this weekend. Yeah, if you're seeing it through an email, you won't see who gifted it. So Kim Hunk is saying thank you to whoever turned her green. Really nice of you. Thank you for the support here with the super chat. And yeah, if you don't catch it in the chat when you get gifted a membership, usually you won't have an indication who did it. So thank you again, Kim. And thank you to whoever gave Kim the gift. William Fagan says, protect Max. Viv is recruiting Shell Keldesline. Man, listen, there's some suspect stuff going on. And I really think she's not mitigating violent crimes in Atlanta. She's holding out bait, right? Because she thinks she's got a lead on something or she can do something to get a lead. And her means are causing a beef that might not actually be there or might not be as inflamed. Before she gets involved, she's stoking the flames. Highly problematic. Not good. Thank you for the 5, William. KC Dog is also out here gifting memberships. Let's show some love for KC Dog. And I know, shout out to the KC fans in the chat. Sorry if you're not a KC fan, but let's all come together to show KC Dog some love here. Very nice to be gifting the 5 memberships. And of course, get you in the banner. And let's see. David Newth with the follow-up says, oh wait, hold on, wait, there's 2. Let me do this in the right order. Okay. All right, we got it. So thank you so much for this. David says, Resident Hedgehog and Gunsmith here. Love the 2 together. Looking at these pictures as an expert, and I could not tell you from those pictures what kinds of guns those are with any certainty. That seems like common sense to me as someone with no knowledge. Like, there are so many makes and models. We can't see your serial number. They're far away. I can't imagine how someone could say with certainty. I just don't see it. David also says, wrong. Even with low flash powder, a firearm at night is going to make a nice big flash, especially a subcontact like the compact like the Glock 27. Big fireball, especially from a 40 caliber. And maybe can we do a, let's see. Okay, so I don't know. I know there's like issues with this stuff on YouTube, but these videos are on YouTube, so I mean, it is what it is, right? Yeah, that's pretty apparent if you ask me. This is called Glock 40s waking up the neighborhood. Oh, let's see. But yeah, like, look at this. So, I mean, clearly looks visible to me. It's not just like a little teeny boop. Like someone checked their phone quick in the car. Oh, man. Yep, and then David, and this seems like common sense to me too, to think about it. That's one of the major issues with shooting at night. The muzzle flashes like a light bulb and it can blind you momentarily in a dark space because, I mean, I think it's something to do with age, but even just if I turn the light on without letting my eyes adjust, I have like that momentary kind of flare. And that's just from turning like a warm light bulb on in my room when I wake up, right? So I can imagine this being true. Again, common sense would tell me. So how is an expert on the stand saying what she's saying? So David Newth, big appreciation here for you for breaking it down. Let's make you a squeak sponsor. There we go. Got 2 squeak sponsors now, you guys. This was an awesome way to lay it out. Big appreciation. KC Dog wants to do a vote. Who's worse, Burrito or Love? They're so similar to me. They're so similar to me. And I want to say that Love is worse on one hand because she has the opportunity to decide she's not going to use something, not going to pursue something. She has the opportunity to see that it's a garbage input, and she chooses not to do that. She also chooses to double down. But I'm going to ultimately say that Viverito's worse because I think she comes off as a little bit more likable at first, right? I don't think she's actually likable or a genuine person in the way that she speaks. But I think she's a bit more dangerous than Love because I don't know. Like, I feel like if we didn't get into such a lengthy cross, if we didn't have such an impassioned advocate for their client, too, with Doug, maybe it wouldn't get to this point where it comes off as obviously full of herself, misrepresenting, misleading, right? So I think she's a little bit more dangerous. I think she can pass along when she's trying to misrepresent something for a little bit longer than Love can. And that's not good. But yeah, they're twinning. Ultimately, I think they're like this. They're like, okay, wait. They're like how she represented the third car pulled up next to Drink's car. One was a little bit more forward than the other, not perfectly aligned. But they're pretty much like this from afar away. One in the same. So great question there, KC Dog. Angie Lay out here sniping, always out here sprinkling with memberships. Very nice all the time. Angie, great to have you here on this day of all days. Like, this is just crazy. This is just so crazy. KC Dog says this is why she wants to hide her face. She's dangerously stubborn and a bold-faced liar. She sees only out of one lens. Now, this all makes me think of her own statement on Direct. People like talking to me. Do they? Do they? You think if people don't talk to you that their silence means that they're engaging in something bad. You use their silence against them because you're so arrogant and think that everybody likes talking to you. Every person that's a good person likes talking to you. That is not a good premise for an investigator to be operating under. And I really think she still believes that even after Max has ripped her apart for 4 hours. Not good. I don't think people like talking to you, Marissa Viverito. So maybe it's not fair to use their silence against them. Maybe it's just you. Maybe it's you. L1915 says she has a different interpretation of ESPN. Right. Forgot about that already. That was a gem, right? Pulling up right away with this ESPN tattoo. Oh, well, he's not YSL, so it must mean something different for him than it means. She didn't say it must. She said it means something different for the YSL members. As if to conclude why somebody put a certain tattoo on their body. You don't know that reasoning. You don't know that reasoning. But she concluded it when confronted with a weird, Dwayne Carter, someone who's a role model. And I would imagine Diamante Kendrick has met Lil Wayne, right? It's not just like a stranger, right? Why wouldn't there be a closer tie to why someone might have a similar tattoo? We know Dwayne Carter likes sports. Like, him and Skip Bayless are like semi-BFF, right? Skip Bayless always puts the turtleneck and the chain on, and you know he's going to see Lil Wayne that day. Like, ESPN, cool. He's a fan. Diamante Kendrick, very good football player in high school, got a scholarship for college because of his athleticism. Viverito didn't know that because she's such a great investigator. She just didn't know that major thing about somebody's life. Even though education level is something you need to be aware of when you pursue people's understandings of things. But it can't mean the same thing for Diamante Kendrick that it means for Lil Wayne. It's just crazy. It's just so stupid. Thank you for the reminder there, L1915. There's just so much that makes her look dumb. Peter Ortiz says she went from a burrito to a chimichanga fried. Heck yeah. And, every once in a while I like something good and fried. And if we're going to talk about burritos, maybe it's got to be chimichanga time tonight. So, Peter, keep laying out the menu items. Definitely going to do something in the genre, the burrito category today. And I'll go, speaking of burritos, Ike, I think I'll go to Tequila 21, right? I think that's what it's called, in the Publix Plaza, not too far away from me. So I think Ike was the one that said that they've been there before. And Ike, thanks for the 5, says, your Viverito will be done when it's golden brown, begins floating in the hot oil, spoon out carefully and place on a cooling rack. She just wants to stay in the hot cooking oil. She doesn't want to come out of it. That's the crazy part. Thank you so much, Ike. KC Dog says this was worth the wait. Guys, I mean, this is why we've kind of got her face in the bush here, but people are tuning into this. And again, Young Thug, not in this trial anymore. People are tuning in because we've got these 2 remaining co-defendants and the mess of the investigation surrounding most of why they're here, right? She wasn't the lead for Donovan Thomas. She's had some interesting commentary about the Donovan Thomas stuff anyway, but still, a big part of the charges that Shannon Stillwell's facing are because of Viverito. Just insane. Squirrel Brain Gang has a new picture. Squirrel Brain Gang, thanks for the 5, says, I think it's safe to say everyone for the prosecution is now looking like my picture. Doe. I think she's the squirreliest brain of them all. And she comes off a little bit more serious at first, because it doesn't seem like she just kicks up her feet and does nothing all day. I get that impression from Gaither. Gaither doesn't want to go out in the field and work, so she takes a position where she can just, I'm done for the day. Cool, I'm leaving. It's a little different because Viverito's very serious. She wants to rush to the office and work, which is maybe admirable when you're not operating with tunnel vision. But yeah, I think she's ultimately the squirreliest brain gang of them all. She's the type of squirrel that, I saw this thing recently where someone popped the hood of their car, their truck, and a squirrel was the squirrel, the hood of the car. I don't know how there's so much space under the hood of a car, but there were hundreds of pine cones. Maybe that's too high. Maybe it was 80. But there were just pine cones all throughout this person's hood of their car because some squirrel was sitting there like tucking away, tucking away, tucking away. And like, you dummy, this might seem like a good idea, but if someone junks that car or drives away, all of your stuff is gone. And this is what Viverito's doing when she's hoarding all these social posts that she's putting them in this folder. She's decided they're relevant. And then Schardt came along and just drove the truck away. Like, you dummy. You dummy. So I think she's the squirreliest brain of them all. Just hoarding all these carefully curated things in her folder to turn over. Always love to see you, Squirrel Brain Gang. Ike is giving us the definition of hubris for no reason whatsoever, right? No reason at all today. It's a noun. It means excessive pride or confidence. It's never occurred to this gang unit that some of them could be played. Dumb. Dumb. And I really think the jury still got to remember Woody telling us exactly how this went down. Tell them a little bit of a truth to let the lie sink down. They're not going to forget Kenneth Copeland. So if the jury wasn't aware of this, Kenneth Copeland made them aware. So, but yes, defining hubris for no reason whatsoever. Touche says, ugh, I want to be out of the bushes so badly today. Oh no, are you stuck with Viverito? Yeah, this is a very exciting day. I can't wait to replay what went down today. Probably on Flesh of the Gods channel tonight, 8 or 9. I think he'll be doing a recap. The mods will probably know more than me because they're so good at what they do. I'm just like lost. But yeah, I can't wait to watch this on replay. Like, watch this twice. So it's just a day. Sorry that you're in the bushes, Touche. I know what that's like. Glad you're catching some of it though, but I totally feel you. Peter Ortiz with the reminder here, 5K people watching, 1K likes. Hit that thumbs up. An odd number of times, of course. Thank you so much, Peter. Positive Q says, good morning, cat, mods, and chat. She's full of herself. She's also arrogant. My favorite rapper said, loose lips sink ships. She talks too much. Rest in peace, Tupac. And this is the thing. Like, just let her keep talking. Let her keep talking. And maybe she should be familiar with this lyric and take some, do some self-reflection, right? Go listen to this. Take it to heart. Let these lyrics actually mean exactly what they say they mean. And maybe reconsider the way you approach things. Great to see you, Positive Q. Thank you for the positive message. Shah Diggy here with the reminder, like the video. Heck yeah. You only have 2 options here to like the video or like the video. Thank you so much, Shah Diggy. Casey Doug, well, this is a little bit earlier, but she's gonna look so bad. Wait for it. Pride comes before the fall. And, you know, great opportunity to, like, I don't like being, when someone gets something that you think or say or did wrong, and you want to explain yourself because it's not the way it happened. That's a real situation. It happens, and it can be emotional to try to want to explain yourself. But at the same time, when that's always what you're having to do, don't be that person. Try to stand on the outside looking in and see how that comes off to the other person. Because why should that person give you any trust? Take what you say seriously or think you're being genuine with them when you constantly need to explain yourself. And then you switch up your story within your explanations, right? So it's not normal to want to explain yourself in the right context. But this is not normal. What Viverito's doing is not normal. It is pride. Thank you, Casey Dog, again. Tons of support today. I think we've got to put you up in. We are up to 3 Squeak sponsors. Incredibly generous, you guys. And again, I'm all for you guys watching this for free 99. We don't have a cover charge here. Absolutely no cover charge. But it's really overwhelmingly kind that you guys are sending so much support to this channel. I've had a blast doing this, so again, would do it for free. Nana Banana says, eat her up, Max. Her knowledge opinion isn't a fact. Yeah, and she's been using I believe a little bit more today, at least in the earlier part. Right when it was still, we had like the slow entry into where we are right now. But yeah, Max is eating her up. Derision says, Viverito Burrito is on the Brady list, y'all. Oh, I can imagine there's a bunch of reports against her. But again, that online index is kind of just like, it doesn't always tell you the actual information. It just seems to be aware sometimes when some report is filed. So this does not surprise me at all whatsoever. I'm sure she's had plenty of complaints. Leo Senpai celebrating 2-month anniversary. Thank you so much. Tracy Fagan says, why is Max going to let go of the Instagram story? So earlier today, we saw that Schardt came to some kind of agreement after a conversation with Adam Abadi yesterday, where I really think when he opened his cross-examination and he told Viverito, hey, I know we left off yesterday talking about this still screen grab from the Instagram post with Mr. Nichols, but we're going to talk about that later. I really think he said that. One, I think you guys are right in the chat. You said it could be to disarm her. She thought she was prepared to speak on that when she sat down. So on one hand, I do think it disarmed her, or caught her off guard. But I also think it was to remind the jury, like, hey, don't draw a conclusion that I went somewhere I'm not supposed to tiptoe on. I'm going to remind you of it and signal to the jury that me talking about it and getting Viverito to get all flustered about whether or not Nichols chose the words or she chose to take a screenshot at a specific point in time. You can let that like flow back into your mind right now. And just know I was allowed to talk about it. Right? So I think he's letting it go because he established what he needed to establish and work something out with the state where they're going to just play the whole series on redirect and he might recross. But I still think he reminded the jury strategically. Like, just so intelligent. Max is so intelligent. William Fagan said, why are Woody's lyrics not a confession? SB's are. And this is great. This is from earlier today, but we heard the same kind of issue with Shalkel. Something that Shalkel did with either lyrics or a music video. Well, you didn't look at that, did you? Big questions. And again, I really don't think the jury forgot that homicide video. I mean, when that came out in front of us in the chat, we were all like, oh my God, how did the state ignore this? This is like talking about putting 24M on someone's head. And it's just a little Uzi Vert forehead diamond. But then we have this music video where someone, as a visual, is putting money, cash, on someone's head that looks like Donovan Thomas. And the state's just like, haha, we're going to look this way. Like, come on. Come on. William, this is the never-ending question, right? It's pick and choose. She's a picky choosy me. Ashley Linnell says, Kat, what happens with the plea deals if the indictment is flawed? How can you plead to a faulty indictment? I mean, I guess with Jeffrey Williams, he might still be in that window to take his plea back, but I don't really think that there's recourse in this regard. I don't know, because it seems messed up. It seems really messed up. So I don't know. I'm not really sure. So I don't have this answer. If there are attorneys in the chat that might know better. So sorry I have to defer, but I just don't know. Plea deals, I look at them as something, my understanding is they're kind of more of a risk because you're conceding to something. So if the statute's wrong, it seems like how can you concede to something that's just wrong in and of itself? I don't know. So I think it's over. I think like unless it's within, again, that like period where you can say, never mind, I changed my mind. I didn't want to take a plea, that limited time period, which is a different mechanism than, you know, there's something wrong with this. I don't think there's any recourse. I think it's just done, which really, really sucks. So thank you for the question here. It is great food for thought. I don't have a decisive answer. I'm not going to pull a Viverito and tell you that I know. Star Push and Wait again says the state has been scrambling and scraping since the indictment. Tell me again, how many years have they been, quote, investigating YSL? 2014-ish? And don't forget, I mean, you know, if they're talking about rock crew, sex, money, murder, 30 deep, this investigation, they're saying it all blends together. So technically, if they've been investigating before that, they've been investigating the precursors before 2014, right? So the scrambling and scraping, to me, what you say you have isn't what you actually have, right? That's the only excuse at this point for this type of scrambling and scraping and panic and the objection, Your Honor, you're ruining my case type of action. So, yep. Thank you for the 10. Tracy Fagan says, can we indict Fani? I do know, I did see news that the Georgia Supreme Court doesn't need to hear oral arguments, and that's the Trump RICO. So I don't know really exactly what that means, but to me that suggests that whatever's in the briefs is enough for them to make a decision or a non-decision. So I don't know if that will be a burst to another RICO, Fulton County RICO case or what. I don't know yet. I don't think anybody's going to indict her because it's just, I'm pretty pessimistic in that regard. And I think they'll say they don't have much to indict her for. They just don't want her prosecuting these cases the way she's prosecuting them. So, I don't know. And again, kind of like a bit of a lot of unison over here with this Fani issue and the RICOs, right? She wants to weaponize and hold tight to this RICO statute in Georgia, which is pretty broad. And, she's fighting for additional discretion, prosecutorial power to prosecute gang charges, gang cases, right? And I think collectively, and not all of us are in Fulton County, but collectively we're like, this RICO thing is just too much. Like, please, Fani, all other issues aside, please stop doing this thing that you're doing with these RICOs, because it's just not right. Jennifer Devine says, the sad thing is that even as bad as this is, Fani just filed another RICO case with a lot of celebrity victims this time. Oh my gosh. I didn't know that. Although it kind of sounds familiar, so I probably saw someone, I don't know the info, but I do definitely think I saw this mentioned. So this is just like, here we go again with another RICO. So, Jennifer Devine, thanks for that. A whole mess. Nana Banana says, Kat, you make this whole mess make sense. Thank you. You're welcome. I try. Because when things don't make sense to me, I like to try to put the pieces together and go look it up. I'm telling you, guys probably saw me staring into space during the jury charge mini conference this morning, because I was trying to pull the old indictments and look at what Hylton was talking about with counts 52 and 63, where she really meant 52 and 64. So I was doing that because I wanted to make sense of it. Like, I got that an element was missing, but how could they be so dumb? Like, I got to see it myself. Again, with the assistance of Jim R. or Happily Angry Lawyer in the chat and on X, piecing that together with you guys. We're making it make sense because I selfishly want to make it make sense anyway. So just doing it on screen with you guys so you guys can be part of the journey. Darren Richard says, states still believe in this case fully. It's crazy. And yet yesterday we hear during yesterday's mini jury charge conference, states still not sure. Well, we can never be 100% sure we're not in the car. And I get that, right? But what's interesting is, I don't know, I think yesterday afternoon changed the confidence with which Schardt is approaching this cross-examination. Because now he's fine saying Boyer was in a certain car. He was in the car with Nichols and Miles Farley. As opposed to, Shannon Stillwell's car, it was him and Garlington. So it seems like he's more confident than ever. Like yesterday he said, I still don't know what the state's theory is. And then the state's like, well, we can't be 100% sure, but we think Garlington may have leaned across Shannon Stillwell and shot through Shannon Stillwell's car at Chamel Drinks. And Schardt's like, all right, I guess we're not fighting Demarco Boyer's location anymore. We're just going to ride with it because this is just ridiculous. So, just crazy. So yeah, I still don't think that they believe their case fully, and even though they tried to lock down on a new theory yesterday, I think it unraveled a little bit. So uh big thank you, Darren Richards. It's something we don't like the way that they're presenting it. And I would say as a prosecutor, maybe there are times where you're iffy on something, but you think it meets a certain standard, right? So if you think evidence meets a certain standard, maybe it's still, even if you think personally, you don't think this way. If it's enough to meet admissibility standards, maybe it's still your job ethically to try to get it admitted. But here in this case, the state stuff isn't admissible unless they bolster it with what their weird, irrational belief of what something has to mean, the only thing it could mean, and then suddenly it rises to the level of being admissible. And that to me is not the right way to do it. So I don't know. I couldn't be a prosecutor though, so speaking as someone that couldn't be a prosecutor. Danielle Judge says, don't forget to hit that like, show your love. It is free. Thank you so much, Danielle. And then I'm so behind. Full drinking, half thinking. Good to see you. I've caught you over on your rants and bans. Glad to have you over here. Although I swear you've been in here before. Maybe on Replay Crew. But good to see you today. Sorry I'm so late on this. Love, love, love full drinking and half thinking's name. Kind of could be, not saying anyone's drinking, but half thinking definitely applies to some people in this trial today. Also very generously gifting 10 memberships. So I've had you in the banner here. Thank you so much for showing the support here and stopping by. Good to see you and hope you're doing well. Let's get some love for, and we could abbreviate this. Well, either write full drinking or half thinking in the chat. You guys can choose, but let's show some love. Thank you so much again for the gifted 10. Floyd says, was the jury there for all of Viverito's cross yesterday? I was just confused when Paige got on her about her answer. It didn't seem like they were. So, there were a few times where they approached yesterday, and there was this time. This sounds like you're talking about the clarity. Viverito wanted clarity because she was concerned about the defendant's rights, and she didn't want to talk about someone having been through a trial for a homicide that they beat or didn't beat the homicide. She said, I just want clarity. That might have been the approach where Judge Whitaker herself said, can you guys approach? But that was outside the presence of the jury after that moment. The jury still heard a good amount of mess until the approach, and the jury was sent out of the room for a break. Right? So the jury did hear a part of that mess. I'm sure they pieced enough together of why that was messy. But the way Paige was like, no, you shouldn't be trying. What do you need clarity on? His question's pretty clear. That stuff was not in front of the jury. So hilarious, but not in front of the jury. Thank you so much, Floyd. Peter Ortiz says, and Peter said this right before that jury charge thing, which when you sent this, I was like, I agree, that's always the risk, right? Especially, I think jurors are inclined, they want to find some type of closure, right? Peter said, it's very unlikely that a not guilty verdict across the border, across all of them. Too many charges and strong evidence in some areas. Now, Peter, this was before. I really think count 52 and 64 are going away. I don't think the state's going to find case law. So I agree. I agree with this. This is rough, right? Jury could be confused. There's guns, there's drugs. We're going to check yes on the guns and drugs things, but no on the M's. That's my position of what a compromised verdict could look like. It's a scary prospect. But then they get the counts wrong for the March 14th and March 17th, 2022 possessions for Shannon Stillwell. So imagine those were the two charges that were the big risky ones. Now those are off the table. All because the state is a hot mess. So very, very big win there for Shannon Stillwell because of this concept here, right? It's a lot to expect a full acquittal across the board unless the 12 jurors are just like, I really think jury nullification is a stronger possibility than all 12 jurors going in there and saying, we think they've proven nothing. they might come out with a full unanimous acquittal on all charges after talking about it and weighing each thing. But I think jury nullification is a stronger prospect just because the state has been so infuriating, and Viverito closing the case is such a hot mess. But it's always a risk, guys. You know, the jury is not us in the chat. The jury is not us. Are they back? We'll see. Let's go over there and see if they're back. I don't see them back, so they're still on the seal. So they're late. Let's see if Kathy... Do you have an update for us, Kathy? Kathy Roussan. Yeah, don't see an update from Kathy. Kathy Roussan is with Law and Crime. So I'm not just yelling Kathy for no reason. All right, so they said they have a backup broadcast being rushed to the courthouse. Send prayers and good vibes. So we'll see. We'll see. But I have several feeds open. And that you see how it's making me jolt around. But I do have several windows open. Let's reduce it down. And then I should be normal again. I should be normal. Yeah, I have... Yes, but it's on the seal. So guys, I have... Okay, they are back. Hold on.
Thank you. Thank you. All right, Ms. Hylton, you can go ahead with your redirect. Thank you.
We're redirecting? Okay.
Good afternoon. How are you?
Good afternoon, I'm well.
So I want to start with some questions that Mr. Weinstein asked you regarding the watch that was in Mr. Williams' home in the closet.
Correct.
Did you steal the watch?
I did not.
Someone laugh?
Next, Mr. Weinstein asked you a few questions regarding whether or not Mr. Kendrick was inside of the home at the time that the search was taking place. Do you remember a line of questioning regarding where Mr. Kendrick was?
I do.
Okay. When the SWAT team made entry did they clear out the house before you went inside of the home?
They did.
And was that after Mr. Kendrick was apprehended after fleeing the house?
Objection.
Sustained.
Were you made aware of where Mr. Kendrick was found, was apprehended?
Yes,
Where was that?
outside of the home.
As a part of that investigation, did you ever recover a cell phone from Mr. Kendrick?
Yes,
And did you have that cell phone extracted in the same way that we talked about other cell phones being extracted?
yes, a warrant was drafted and it was extracted by Kevin Leon Packer.
In that phone, did you find any information that was taken on May 9th, 2022?
Yes,
Okay. What did you find?
a text message, I believe, saying that I'm at Slime Spot, if I remember. I have to see the text message in front of me, but
So were there any pictures of his phone from that day?
I'd have to look at the dates on the photos. There are photos, but from the home, but I don't know if it's that day.
Permission to approach?
You may.
I'm going to show you what's been marked as 534 VV and 534 VVA. Tell me if you recognize 534 VV and 534 VVA.
I do. These are photos from Mr. Kendrick's phone.
And do those pictures have a date on which they were captured on the phone?
May 9th, 2022.
And do they appear to be photos that were taken from Mr. Kendrick's phone after you reviewed it pursuant to the search warrant and the cell phone extraction?
Yes,
At this time, the state would like to admit 534 VV and 534 VVA into evidence.
Those are admitted.
No objections.
And we'll publish in a moment. And is this a picture that was found in Mr. Kendrick's phone?
it is.
Okay. And do you recognize anyone in the picture?
Martinez Arnold.
Right. And who is Martinez Arnold? Which individual is Martinez Arnold?
In the white t-shirt and the black pants.
And if you can just show on the TV screen the date in which it says the picture was, I believe it said it was modified.
May 9th, 2022.
And then did you also say earlier that you saw a text message in the phone on that same date as well?
Yes.
All right. Now, I want to transition to Mr. Schardt's line of questioning. Mr. Schardt spoke with you in detail about one of the search warrants you drafted. Do you remember that?
Yes.
Okay. And I'm going to show you what I'm going to mark as 530 VV. And I'm going to go to, I believe it was unnumbered page 5. Excuse me, unnumbered page 7.
Mhm.
Looking at 530 VV, unnumbered page 7, is this the page that you and Mr. Schardt were discussing with the YSL Rule the World Kid 24 mil on the N-word's head?
Yes.
And does that appear to look like a page of your search warrant affidavit that you drafted for this particular search warrant in this case?
It does.
Right. You're right. This time the state would like to admit page 530 BV, unnumbered page 7 into evidence.
Can I seek clarification from the state?
Sure.
Can't wait to watch her try to clean up this little Uzi Vert thing. She said she would do it again, so it doesn't matter if she was
Alright.
wrong at first.
It's just that one page.
Just that one page, Your Honor. And permission to publish.
You may.
And I want you first, is that page, the unnumbered page 7 of 530 VV?
It is.
All right. And are we able to zoom in?
I mean, the font looks bigger, but maybe it was a screenshot of the extraction.
The portion that has the circle, how did you grab that information and put it inside of your warrant?
I believe it was a screen grab from Instagram records that were received.
And as you screen grab, is that how you place it inside of the warrant?
It is.
Once we get it back up, I want you to read what is the paragraph right above the screen grab. Now, while we're waiting for that, Mr. Schardt, do you recall him asking you a lot of questions about writing reports in this case?
I do.
Over the course of these 2 years, have you ever had opportunity to meet with Mr. Schardt?
I have not.
Have you been available to meet with Mr. Schardt if he had any questions about any information contained in the warrant or March 22 folders or anything that you may have done in relation to this case?
Absolutely, I have been.
Now, are you able to see and read the paragraph before before the screen grab?
Yes.
Can you please read it?
In a conversation thread from February 4th, 2021 to February 7th, 2021, Jeffrey Williams brags that YSL rules the world and has $24 million. Jeffrey Williams then tells YSL members to pay him directly, and he pays for everything already for the members. This shows Williams' leadership role within the enterprise, directing the actions of YSL members and obtaining the profits from the enterprise.
At any point in there, did you say that he was given $24 million to try to kill Lucci?
I did not.
Did you infer that in anything that you wrote right there?
I did not.
And is that what you presented to the judge in addition to all the other pages of that affidavit?
It is.
And how many pages is that affidavit?
Several. They're not numbered, so it's multiple.
Now, do you remember? You can take that down, thank you. Do you remember there being a line of questioning regarding Mr. Stillwell's song "Slap Talk" and the verse where he said, "I just beat a murder rat, pay my lawyer 30 for that"?
Correct.
And are you aware of when Mr. Stillwell was initially arrested on murder warrants regarding Donovan Thomas Jr.?
I know it was sometime in late 2015.
To your knowledge, did he ever receive a bond on that original murder warrant?
At some point, yes.
Okay, do you know when?
I want to say maybe the winter of 2016.
To your knowledge, between 2016 winter and 2019, was there any indictment for the murder of Donovan Thomas?
No.
Okay. Between 2019 and 2022, was there an indictment for Donovan Thomas?
No.
When did this indictment for the Donovan Thomas murder occur?
May 9th, 2022.
And when did the Donovan Thomas murder occur?
I believe January 10th of 2015.
So if my math serves me correctly, it took about 7 years for there to be an indictment in Donovan Thomas murder.
Correct.
I'm going to now publish the video that Mr. Schardt talked about on Direct, which is the full video of the screen grab regarding Quarmavius Nichols. Remember, do you know what we're referring to?
I do.
All right.
This might be a pretty short redirect.
And this is going to be for the record, Your Honor, and we're going to we're going to ask to admit 471 VVA into evidence, Your Honor.
All right, that's admitted.
No objection.
And permission to publish.
You may.
And I think the court asked the question we needed.
I tried to mute it and press rewind. Oh my gosh. Don't get me, YouTube. Don't get me. So, and this is a good time. Dancing Horse had asked what happened with this on Cross yesterday. So the state pointed out that it had been excluded for a different reason. This whole series of stories on Instagram as a whole video was ruled out as just, you know, cumulative. But Schardt didn't realize that the screenshot was from that thing that was taken out. So he talked with the state yesterday and they agreed we'll play the whole thing on redirect and we might get some recross from Schardt. I expect recross on this after they play the whole thing during redirect. So. Sorry, I keep pausing McPauserton with the music. Oh, I agree, Sheriff. Sheriff Chuck says he baited them. Yeah.
Did my time, I ain't
And this is what they want me to do on Scudder Heights. I might die. Never get on another fucking roller coaster day in my life.
Oh, you talking about? I don't want to talk. Won't speak on that, them two.
Grabbed in addition we published earlier. And is that the video that you screen grabbed?
There we
in
go.
addition to the two pictures that we published earlier?
It is.
All right. And do you recall when you pulled and screen grabbed that video?
Probably a day or two after the homicide of Mr. Drinks.
And on here where it says 18 hours, would this video have been posted this particular video been posted 18 hours before you screen grabbed it?
Correct. Whatever day, I'm not sure the day of the actual capture, but it would have been 18 hours before that.
And if it said 1 hour, would that video been posted 1 hour before the capture?
Correct.
Right. Now, there was a line of questioning regarding Shell Kell and the two shells on his face. Do you remember that?
Correct.
The Christian McMiller and Darius Ford case, is that still an open and pending investigation?
It is.
Are you the lead detective?
I am not.
Have you done additional investigation on that case?
I've assisted on that investigation.
And have you turned that information over to the lead detective?
I have.
And is it up to the lead detective to take out warrants or do whatever next steps in the investigation?
It is.
Demarco Boyer, when did you confirm that Boyer, let me strike that. How did you confirm that Boyer was at the gas station? How were you able to confirm that information?
There was a call that precedes the call at 9:59 that let me know that they were at the gas station.
And did you ever get phone records to confirm whether or not there was accuracy regarding that call?
I don't believe I obtained them, but I did see them and the results of them.
And to your knowledge, do you know when those phone records were obtained?
It would be a couple months after the indictment, I think. I didn't obtain them, so I'm not 100% sure.
Okay. Let me ask you, do you know if it was before or after the indictment?
After.
Mr. Schardt asked you some questions about tinted windows. Do you remember that?
Correct.
All right. Have you ever had any cars tinted, windows tinted?
I have.
And have you ever received instructions after the car has been tinted on what you should do about winding up and winding down the windows?
I have.
Have you always listened to that instruction?
I tried to, yes.
Has there been a time when, and let me ask you this, what is the instruction generally?
Don't roll your windows down for 3 to 5 days.
You said you tried to. Have there been times where you have rolled them down before the 3 or 5 day period?
The next morning, getting out of my parking deck, I accidentally rolled down my window.
In your experience, did anything happen to the tint?
It did not.
So I want to go to State's Exhibit 437 VV and the call that's on March 15th, 2022 at about 2 o'clock a.m.
Yo. All right, man. There's all kinds of shit going on. I just jump in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense. Yeah, yeah. The fuck you getting dropped off for a nigga ride with the nigga who brought you? Yeah. That's stupid as fuck. So any of you niggas be on the gun here, so. What the hell? What's up with you? We right here down here. Yeah, what? Ride past trying to see.
Here we go with this again.
Fill up. Try to get it filled up for right. Yeah. All right. I'm listening. Huh? I said, all right, I'm from listening. What's going on? I just, I'm pulling out now. You back, son. You say, I was gonna jump in with y'all. All right. That's what I'm saying, Kyle. What you doing? All right, I'm gonna get it full up now. All right.
Now I want to pull, are you familiar with the vault page of the actual wiretap information that you receive when you get the wiretap?
Yes, a typical,
Sorry, the PDF pages.
Yes.
And earlier, did we talk about yesterday that sometimes within the wiretap, there was mapping information?
If it's available, the wiretap will display a map of where the device is at that time.
And is this what the PDF page looks like when you get the wiretap information?
So when you export the wiretap data, this is the PDF form, how it's going to print out and be exported.
And does it have a link for the audio and a link for the map?
Correct.
And is the audio link, would that link us back to the audio that we just heard?
It will allow you to play the call associated with this record.
And then what does the map link do?
It will show you, if it's available, the map of where the device is located at the time of the call.
Okay, you click on the map.
All right, so we're gonna get caught up. Law and Crime is back. They have closed captions, so we're gonna switch back. But, and to clarify here, we are not on, that was not Infamous Sylvia, the handle. It's Infamous Sylvia streaming it, but she has a second channel, Infamous Sly. That's the channel that we were streaming while Law and Crime was down. It's pinned to the top of the chat, so if you don't have her second channel, make sure you grab it at the top of the chat there. And we are back hopefully with closed captions. So let's see if we get captions.
And if you can use the pointer. Looking at the map, are you able to see the area or the neighborhood that the phone, that it appears that the phone is in?
Yes,
Okay. What neighborhood is that?
Mechanicsville. Right. All right here.
And where it has the pin drop, is that where the phone is supposed to be located on the map?
It should be within that radius. So it'll give you a radius and say within this many meters, and that judges how big the circle is going to be.
And on the radius, do you see Fulton Street Southwest?
I do.
And do you also see McDaniel Street?
I do.
Is the is I-Windsor and I-20 in this general vicinity of this area?
No, it will be right here.
I'm going to object to vague general vicinity.
Sustained.
Within the map, are you able to see where the I-20 Windsor area is?
Right here.
Are you able to see, court's indulgence for a moment. Thank you. Now, do you recall Mr. Schardt asking you about whether or not the phone call that was at 9:59, where the call says get on FaceTime, whether that was, where did you get that time information from?
Yes.
And where was it that you received that time from?
The wiretap itself.
I'm going to publish for you what's already been admitted as 397 VVD, which is the ankle monitor location information. Looking at 397 VVD, do you see a time for 9:59 p.m.?
I do.
And do you see a location for 9:59 p.m.?
464 Windsor.
I'm going to show you what's been admitted as 397 VVC. Do you see that same address located on 397 VVC?
I do.
Okay. And is that the is that the BP gas station?
It is.
And is that the BP gas station located at Windsor and Fulton Street?
It is.
Is that the same BP gas station that you saw in surveillance video?
It is.
Is that the same BP gas station where the car that was rented by Shannon Stillwell and Demarco Garlington is inside of is at that gas station?
It is.
Is that the same gas station where the white Ford Fusion is in, that Demarco Boyer is in, at that same gas station?
It is.
And is it at 9:59 that that call comes in that for them to get on FaceTime?
It is.
And in looking at the surveillance video, is that moments before or after the red car in which Mr. Drinks was in is pulling off from that gas station?
I'm going to object to cause for speculation. I don't know how the video cameras link up.
I think that's an argument.
Do you want to rephrase the question?
Sure. On the surveillance video, do you see at approximately 9:59 from the BP surveillance video, that car, Mr. Drinks' car leaving the gas station?
I believe Mr. Drink's car leaves the gas station, and the other cars shortly thereafter follow.
And then do they then go to, those cars go to the light that's on the FedEx surveillance video?
Yes, they stop at the light.
Now let's go to the FedEx surveillance video.
Sure.
All right, we're back to the video, guys.
Now, what time is on the surveillance video on the bottom? How much into the video are we at?
1 hour, 1 minute, and 32 seconds.
All right. Mr. Bach, if you can press play, please. Is that the red car approaching the light?
It is.
Right. Is that now the first white car, which is the white Audi, now approaching next to Mr. Drinks?
It is.
And is that the white Ford Fusion then approaching next to the white Audi?
It is.
All right. And are those cars just all at the light currently?
Yes.
And do we now see cars moving in the opposite direction?
Yes, oncoming traffic is starting to move.
And actually, Mr. Abadi, can we go back to when the cars first get to the light? I want you to tell me, I'm Investigator Viverito, what time does the red car first get to the light?
One hour, 1 minute, and 36 seconds.
What time, and tell me what time the Audi gets to the light?
At the 45-second mark.
And what time does the Fusion get to the light?
52-second mark.
What time does oncoming traffic start?
1 hour, 2 minutes, and 11 seconds.
Are they still at the light?
They are.
What time does this car that's behind pull up?
1 hour, 2 minutes, and 24 seconds.
Do you see the white Audi pull off?
I do.
What time was that?
You may have to roll it back for
Okay,
a second.
if you can pull back for a second.
You may have to go back more because it's already pulled off.
You can go back to 102.11. We'll pause. Do you see the Audi pulling off?
Foot comes off the brake at about 1 minute, 1 hour, 2 minutes, and 21 seconds, and they pull off at 1 hour, 2 minutes, and 24 seconds, or 23 seconds.
And prior to the Audi pulling off, do you see the Fusion make any movement?
No.
Okay, let's go back. Can you go back to 102.15?
Oh, the Fusion starts creeping up.
And what time is that?
It's around like the 17 or 18 second mark.
And is the white Audi going into oncoming traffic?
Yes, it darts into incoming traffic, oncoming traffic.
The lane that Mr. Drink's car in, is that the left turn lane?
It is.
The car that pulled up behind, does that car go left and turn left?
Yes.
And you said that you've been out to this area before.
I have.
Is the middle lane a turn lane?
No.
Is it only the left lane?
Yes.
Now, if we can go back again to 102.15. Now, Investigator Viverito, I want you to focus on, remember the individual you saw walking in the video before?
Yes.
I want you to focus on that individual walking.
Okay.
And when if you can show the jury when you first see the person walking.
Right there. Or is it not on my screen? It is. Oh, there it is.
And you keep playing. Do you still see the person walking?
I do.
Are they still walking when the car makes a U-turn?
It is. They are.
Can you still see them walking?
It's muffled, but yeah, they're still continuing towards the intersection on foot.
And is Mr. Drink's car still sitting in the left lane?
It is.
Do you still see the individual walking?
You see, surfacing right here. It's very hard to see, but you see the movement right here.
And he's still walking towards the light?
Correct.
On Windsor Street, where the individual is walking, what is to the right of where he's walking?
I believe I remember correctly, some bushes or shrubbery, or and there may be a wall of some sort. I can't 100%.
Now, we're going to have to go back again to about 1:02:11. Again, is that where all three cars, the Fusion, the Audi, and and Mr. Drink's car, all at the light?
Correct.
Now let's focus our attention on the car that pulls up. What time does the car pull up?
At about the 27 to 28 second mark at 1 hour, 2 minutes, 27 or 28 seconds.
And I actually want to pause. Mr. Abadi, are you able to zoom in to that portion now? And once you zoom in, if you go back to 1:02:11. If it's not working, we can just go back. Thank you. Is that just a zoomed in area of the location that we've just been looking at?
It is.
All right. And now I'm going to focus on the white car that pulls up. Do you see the Fusion pull for it first?
Correct.
Is that the Audi pulling off into traffic?
Correct.
Now, is the white car behind those cars?
It is.
And from here, can you tell if the car that pulls up is behind the car with Mr. Drinks?
You'll see like a gap here. It's like the tires are back towards the back of the car.
In the turning lane?
It's in the middle lane.
Okay. Keep going. And do you see the car flash on and off and the car still behind Mr. Drink's car?
Yes.
Right. And is that light red?
It is.
And does the light turn green when he goes to make the left turn?
It is.
Following road traffic?
Correct.
Or following the correct signals?
Correct.
And is the car still sitting there?
It is.
At any point in time in this video, do you see any muzzle flash?
No.
But was Mr. Drink still shot inside of that vehicle?
Yes.
Now, when the Audi that Mr. Stillwell takes off, does he go left as well?
Yes.
Right. I want to go back to 397 VVD. And I want to go all the way up to the top initially,
Okay.
this exhibit. Now, do you see the top, the categories of the information that's contained within this exhibit?
I do.
Do you see column I?
Yes.
And what does column I say?
Speed.
All right. I want to go back to March 14th, 2022. And I want to scroll to when we last looked at this document at 9:59, was he at the location at 464 Windsor Street?
He was.
Okay. And at 10 o'clock, was this at 464 Windsor Street?
He was.
That's the same BP gas station.
Correct.
All right. At 10:01, was the income out at 405 Cooper Street Southwest?
It was.
All right. And do you see that column I where it says 17 and 18?
Correct.
All right. And that's in miles per hour, right?
Correct.
Okay. When we go at 10:02, PJV2 plus VR, is that at 18 seconds?
18 miles.
18 miles per hour?
Yes.
Excuse me. And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car is at the, or the ankle monitor at the PJV2 location?
A minute.
Excuse me, a minute after the PJV2 location,
Yes.
right? I want to show you 397 VVF.
Yes.
Here, you guys, my bad. Just saying, something interesting might happen, and I don't have any promises. I'm just going to share let's see, home. Every Wednesday, Kayla B, Miss Jefferson, and Millionaire Mel do a program called WTF Wednesdays where they react to YSL, everything that happened in the previous week. There may have been something interesting that happened in the last hour or so, so definitely check that out. There is a link there. If I get more certainty there, I will definitely let you know. And we're approaching, I said it in the chat, but just want to say out loud, I do think we'll get to Recross today. So I think we'll get to Recross. I know people don't love when the state's doing the questioning. I don't think we have much longer of them. I think they're getting through the last of their stuff. And maybe it'll go quicker if this approach ends up with Hylton having to move on from something. And yeah, I don't particularly have tea of my own. And I really think when you hear it, it's not really going to surprise you. It would not surprise you at all. It's not my tea to share. And it might come out in court, so we'll see. Big thank you to Heart of Inspiration earlier, who said, I'm not visiting any of y'all until I get an inventory of what's in your house, right? You're not going to get me caught up, right? And now the state's showing a picture like, here's proof that Diamante Kendrick was in the house during the raid, even though it was a picture that was taken presumably right before the raid and not actually physically during the raid. But, you know, their representation is whatever the representation is. Maybe Doug will recross on that. But Heart of Inspiration's playing it safe here. Love to see it. All love to Heart of Inspiration, one of my favorite people out here. Met each other covering a different trial, and here we are back together for YSL. So I'm going to drop a link here. Heart of Inspiration has done great astrology reads on the dynamics of Whitaker and Adrian Love. Definitely recommend checking it out because it was spot on. So there is that there. STS, thanks again for sniping another membership. Tina Haskenhoff says, if Detective Burrito uses her superior intellect and I'm suddenly missing, please be sure to bail me out of Rice Street. I apparently still have a flagrant affiliation with ESPN via my Hulu, Disney, and subscription bundle. So, her superior intellect is hilarious. Yeah, we're going to make sure we bail you out, Tina. And yes, be careful with this ESPN affiliation because Viverito gets to determine whatever she wants it to mean depending on who she's being asked a question about. So, shout out to Tina. Love this here. Thank you for the support. Dave911 says, since Viverito wants to be shady and hide from the camera, we should change our profile pics to her face while she's on the stand. Hilarious idea. Everyone just has a bush picture of this bush that's here. Too funny. Oh my gosh. And then also back to Tina here. Rice Street says, once I got you, Tina. So be careful. Be careful. Let's see. Mike the Mob says, good morning. It's me, Miss V. Listen. She got up on that stand with a different approach this morning, and it all crumbled down an hour in. All right, jury's leaving? They're sending the jury out? They didn't send the jury out before the break, right? And sent the witness out. All right.
Your Honor, I don't know what the Mr. Schart's going to tell you why he objected. I had already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it, what was on the spreadsheet. Then that is when Mr. Schardt objected. So that is the objection that's on the floor. At this point, I've asked her to read PJV2.
Well, she is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data. She doesn't work for that company. I don't know, for instance, the PGV2 or whatever, PJV2, I don't expect to hear her testify or what that means, because she's not the ankle monitor person. The ankle monitor person would have been the person to ask about those things. So I don't get.
And what is VJV2?
So the next thing that I was going to show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
But how does she? Okay, so
What you were going to ask her to read.
Yes. So this is the spreadsheet, Your Honor.
Okay.
On here, which I had her read earlier on the spreadsheet, the column has the name, column D has the date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read, at March 14th, 2022 at 10:02 p.m., the location PJV2 plus VR, Atlanta, Georgia. That is what my question entailed. And that was the
Okay, and
objection.
she read that?
She
Or
read,
is- Okay, she read PJV2 plus VR, Atlanta, Georgia?
I believe that. if
Or
the
is that
object-
when the objection came?
That might have been when the objection came.
Okay, and then what?
And I was just going to have her read the date and time of that location. Then I was going to show her what has been admitted already as already admitted as 397 VVF.
That plots that location
Correct.
that's
by the ankle monitor company? Or by whom?
He showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJV2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude?
Yes.
Somebody plotted latitude and longitude
I don't.
on a map
No, we
to get
pulled
that
up-
location?
No. We pulled up the map. We went into Google and we put PJV2 plus VR. We just Googled it. And we pulled up the location.
So essentially, they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person is already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors printed out, and
That is already in evidence?
that's
You're
already
right, it's in evidence. It's not, we're not admitting it through her. It's in evidence. The ankle monitor witness introduced it. He
Okay.
introduced it along with the record. of the pictures. And so
Okay.
at this point, when Mr. Schardt has
Okay, and
challenged,
then what? So you'll then say, and here's this other piece of evidence that is a plot of PJV2 plus VR.
is that the location at the light that for the surveillance video that we just observed? Because all of
Okay.
this is in this is all in response to Mr. Schardt's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Schardt made is that the 9:59 phone call, this started with the phone call at 9:59, which is the wiretap phone call. Mr. Schardt asked Investigator Viverito, are you able to know if that is the accurate time? Because of that line of cross-examination, we are now showing Investigator Viverito other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJV2, at 9:59, the
Please
ankle.
put that exhibit back up. Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
Your Honor, we're showing Mr. Schardt started off at 9:59. Then, if you can recall, he went through the entirety of the surveillance video at the FedEx. So that's after 9:59. So what we are showing is other evidence that
he does not dispute that he was at the light.
He disputes
at the same time as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that the call at 9:59 was a call to get on FaceTime to shoot Mr. Drinks. We are saying that that call, that FaceTime call, is a call where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the BP gas station. He then a minute
9:59 is accurate.
Here's
And lined up to, I mean, I don't see how you can establish that 9:59, according to the ankle monitor company, is, spot on to the second. 9:59, according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point. That is my only point, is 9:59 on the wiretap. We don't know when it is on the rest of these devices, and this information does not give us, or other surveillance systems.
Agreed.
And
Do you have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him, we believe, the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence is circumstantial evidence that he is at the gas station. Do we have direct evidence? No, Your
No,
Honor.
do you have evidence that the 9:59 that you want is the same 9:59 on all of the different things that recorded time in video?
That is why we're showing this, Your Honor, because we're trying to show circumstantially that all these times are
How
together.
are you showing circumstantially that it lines up?
Your Honor, because when we look at the ankle monitor information, he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time could not just be off because all of the time are at approximately 9.
That's if he got the call when he was still at the gas station.
Your Honor,
The fact that they all at some point say 9:59 doesn't establish anything if you don't have a video that shows him talking on the phone at 9:59 so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's just what you want it to say, but it doesn't actually, even circumstantially, establish that. You can argue it, but you can't have a witness say, yep, this says 9:59, so that means
but we
that's
didn't
when that.
ask her to say that, Your Honor. We never asked Investigator
But-
Viverito to
but-
say that. We asked
I
her
know,
what
but
time
you were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said I would never have her say, is he exactly on the phone at that time? Because he's in a tinted car, so we don't know. What we know is from the wiretap that at 9:59, there's a phone call. That's what we know.
That
So I
at
can never-
9:59, according to however the wiretap clock was running.
Correct. Your Honor.
Yes,
And that's
nobody
what-
disputes that.
And, Your Honor, we've stopped talking about
Ms. Hylton, you
9:59.
came up here and said, I'm asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, the timeline lines up. So
Okay.
at this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's approximately the same time.
Mr. Schardt does. Okay.
You can have her, it's in evidence. You can have her read something, but you cannot have her say, yeah, that means all of these times lined up.
I
Or that
never was
means
gonna have-
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJV2 when he objected. Well, we were finished with 9:59 about 5 questions ago. So the only thing that Mr. Schardt objected to at this time was that she was reading PJV2.
No,
That's
that
what the
she was
objection-
about to interpret.
She was not, and that's the thing. That
Okay,
was-
well, great. She's not going to.
Okay,
but-
well,
and that wasn't the state's intention.
Okay,
don't
then
know
I have
where-
no idea why you think any of this is going to establish that all of the times lined up, but.
I'm going to object on relevance grounds at this point because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm going to object to relevance in 403.
Your Honor, as I stated earlier, Mr. Schardt has challenged what occurred at the light.
I
His-
know.
So at this point, we're just showing, based on admitted evidence, what occurred at the light, Your Honor. That's all.
Backs.
Can I ask a question? Why is it improper or not relevant? So if there has been questions and testimony about whether the times for everything sync up, I think has been Mr. Schart's, his argument the entire time. Well, in the screenshot that was admitted to Detective Hogan and
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was that it's not within the scope of redirect, which is when Ms. Hylton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
But on cross, he disputed that the 959 from wiretap was anywhere close or could be related to the 959 anywhere else.
Was established as being the same 959, and I have heard nothing that, maybe you could tell me how you can establish that.
So at 9:59, when he makes the FaceTime or the call, he is at 464 Windsor Street. Okay, so then you go to your next step.
No, that is, how do we know that he's at 464 Windsor Street?
Says it.
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59, if everyone would just wait, and we'll get to the big ta-da. So at 9:59 on the wiretap thing, it says 464 Windsor Street. On the ankle monitor, on a separate device, at 9:59, Mr. Jackson is at 464 Windsor Street. That correlates, they're the exact same place at the exact same time. At 10:02, it shows that he's at PJVR2, whatever. That's the intersection of I-20 and the light. And then at 10:02 on the FedEx thing, and it says 10:02:17. So it's the exact same thing. It's to show that all the times line up. All this questioning that the times are not accurate, that the times don't sync up. We're proving that they actually do sync up, which is what he challenged Investigator Viverito about this 9:59, and she's just making it up, and all the evidence is being presented as how she wants it to. And now we have physical evidence from different videos that show they actually all do sync up, that they're all running on the same, time width or band or whatever.
I think you can argue that. I don't think that is established. But if you want to have her say, but Ms. Hylton says she'll already left 9:59 anyway. So I'm still at a loss as to where we are. But we'll just get her back in and.
I have a motion before the jury comes out.
Here we go. Here we go.
Unfortunately, it's my job to further tax the patience of the court.
What's that?
This might be it.
Yeah, I have a motion to strike the testimony of Investigator Viverito.
The
as
T.
well as
This
any
is the T.
evidence that came under her. And the reason I make this motion, Your Honor, is yesterday it came up that she had not been, that she had been following the case. The court asked me to not
No,
pursue
it
that.
did
I'm not.
Come up that she had been following the case. It came up that she knew that somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case? Because
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
Okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay,
And if that's so, then it still doesn't exclude her testimony. It just lets the jury know, well, she may know some of this other stuff from listening to some other witness.
okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why is that relevant to the guilt or innocence of
I'm
these
about
men?
to go there, Your Honor.
Okay.
Just let me finish a second. She got into it because she was watching Kayla Bumpus's YouTube feed about this case. And Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mm-hmm.
You may not get into whether she got into a dispute with somebody
gets into
about their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
What are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that was the last time she was going to call her a hoe. It goes direct.
I'm sorry, the last time who was
That
going to call?
Kayla, sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito
We need to
a
get
hoe.
into who it was, or just that somebody,
I think we need to get into who it
Why?
was.
why?
Because she's married to Mr. Jackson.
Well, was she at the time? Is this for real, y'all?
Yeah, well,
None of this is relevant. Whatever is happening between Ms. Bumpus, Mr. Jackson, has nothing to do with the guilt or innocence.
Unfortunately, the bias of a witness, well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
if she is in a dispute, if she is
Don't
in,
talk at the same time.
Kayla Bumpus is not a party to this incident. Kayla.
Yes, but if she's married to one of the parties, then that might qualify.
If I
Here.
just maybe heard, I don't know, I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Mr. Weinstein's saying because I may have an objection myself.
what I'm saying is that if there is a relationship between Miss Bumpus and the defendant, then Investigator Viverito's bias against that.
Against being called a bad name?
No, if she is in an altercation with someone that's in a relationship with the defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested for less.
Your
You may ask.
Thank you, Your Honor.
No, I'm not finished with my sentence. You may ask if she is following the case and has been following the case in any kind of manner. But it's really only relevant
Hylton.
if she listened to the testimony of a witness. So you could ask that. But if she's just looking at, and I don't even know if she was looking at, maybe somebody told her. So why don't we get her in here and find all of that out outside the presence of the jury before we go into something that ends up being a bunch of nothing?
Well, that's why I wanted to bring it up when the jury wasn't here, Your Honor.
So can we also bring up before we go into the side searches, the fact that Ms. Bumpus represented Mr. Copeland, we thought to open up.
Yeah, I mean, I don't think saying who this is before we find out anything, I mean, do we know whether, we don't even know whether she's actually married to him or if she was married to him at the time, or if Miss Viverito knows that, or if it was because of any kind of bias against Mr. Stillwell, or just that she doesn't like being called that name.
Well, and no one would, Your Honor, obviously. But if she is in an altercation with someone in a relationship.
What do you mean by altercation?
A verbal altercation.
Okay. I mean,
You know,
a
if there's-
verbal, that's the
if there- I
last
don't-
time you're going to call me that?
Excuse me, I'm sorry.
That's the last time you're going to call me that? That's not exactly an altercation. Is that,
Okay.
is that all you've got?
That's all I have.
Okay, that's it.
The state says that that's a threat,
I
though,
think
for their
this
evidence.
is 403 material.
There we go. One for the state.
Hoisted on my own
Affidavit.
petard, Your Honor.
Correct. All right, let's get the witness back in and the jury back in.
Oh, boy. So Viverito made a comment to Kayla Bumpus in the hallway. That's the last time you're going to call me a hoe. And that would have came from Kayla's court stream yesterday, day 162, which means she was again watching trial coverage where testimony of other witnesses was discussed. So I don't agree with Whitaker saying that it's not a problem for her to be watching the trial. She did make a comment that she shouldn't be looking online for stuff about other testimony. So I don't know why she barked at Doug like that for that part of the argument. But there we go, you guys. There we go. Tune into WTF Wednesdays tomorrow and every Wednesday. Look at the whole defense table is just like collectively hilarious today. A whole mess. Oh, they keep muting and unmuting us. Max. And now think about it. Hylton has to like recover here and not be snippy snappy or exhausted going back into the rest of her questioning.
Go ahead, Ms. Hylton.
Thank you, Your Honor. I'm going to publish now 397 VVF. And looking at 397 VVF, do you see that same PJV2 plus VR location that you saw on the spreadsheet?
I do.
Okay. And are you able to tell where that intersection is?
I am.
Where is that?
At Windsor, looks like just north of Rawson or at Rawson.
Now, on cross, do you recall when Mr. Schardt asked you about the handgun that was on the table at 2830 Waters Road?
I do.
And he asked you about 3 types of guns: Springfield, Sig Sauer, and Smith & Wessons.
Yes.
Right. First, let me ask you, do you know if a Springfield makes a .40 caliber weapon?
They do.
Do you know if a Sig Sauer makes a .40 caliber weapon?
They do.
And do you know if a Smith & Wesson makes a .40 caliber weapon?
They do.
Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as Exhibit 531 VV, 532 VV, and 533 VV for demonstrative purposes only. Tell me if you recognize those types of weapons: a 531, 532, and 533 VV.
One is a Springfield XD firearm, one's a Sig Sauer P229, and one's a Smith & Wesson.
And looking at those 3 weapons, are they able to illustrate what you were talking about, the distinction between the Glock 27 as well as these other types of weapons?
Yes.
Okay. Your Honor, this time the state would like to admit 531 VV, 532 VV, and 533 VV for demonstrative purposes.
Admitted.
Permission to publish?
You may.
Looking at 531 BV, are you able to tell the jury about the distinction you were making between the grip of, say, a Springfield versus the Glock that you were talking about on the table at 2830 Waters Road?
Yes, it would be along the bottom part of the grip.
Say it one more time.
Along the bottom part of the grip. Should be right. You might have to scroll it up for the jury.
Or can you use the one at the...
Or, I'm sorry, right here. This is straight across, like with a little bit of a piece that comes down towards the back.
And is that distinguishable from what you were describing with the Glock?
Yes.
All right. Now looking at 532 VV.
Again, the same thing. You'll see there's something that comes down in the back, but otherwise it's higher up towards the front.
And you have to speak into the mic for me because I can't hear you.
Sorry, it's lower towards the back, higher up towards the front. So it kind of a part that dips down in the back and then comes up.
And for 533, sorry, what kind of gun is this 532 VV?
I believe that's the Springfield XD.
Or 532?
I'm sorry, which one? 532? It's a Sig Sauer P229.
Okay. And then 533 VV.
You'll see again here, there's a piece in the back, but then once you get to the front, it's just straight across.
And then what type of weapon is 533 VV?
That would be the Smith & Wesson. I'm sorry, the 530. Yeah, the Smith & Wesson.
Now I want to go to, and Mr. Kokomo, if you can help me out, please. DS57A, DS57C, and DS58A. And while that's being pulled up, Mr. Schardt, they asked you whether or not there were people, I guess, not to say looking for Mr. Stillwell, but that there'd be some concerns for his safety because of the Tierra Jones killing. Do you remember a line of questioning regarding Tierra Jones?
Yes, several years ago, that was an incident.
When was the Tierra Jones killing?
It was several years ago. I can't remember the exact date.
Do you remember the year?
Not offhand.
Now, looking at, I believe this is DS 57A. Is this the communication between Mr. Stillwell and Miss Alexander regarding the shooting at McDaniel? Excuse
It
me,
is.
at I-20 and McDaniel.
It is.
Do you see any response from Mr. Stillwell in the text message that's, dang, babe, I was just at that intersection? Or, man, glad it wasn't me. I just missed being at that location.
I do not.
Do you see any text messages to Miss Alexander that says, man, I was just at that BP gas station a little while ago. That's up the street from there.
I don't.
I want to go to DS 58. And is that the communication between Mr. Stillwell and his grandma?
It is.
All right. Do you see where she says, hope you are not near Windsor Street shooting on the news? And says, answer me, please.
Yes.
Does he say anything to his grandma? I'm like, know what, grandma? I was over there earlier, but it's not me.
He does not.
Now, we talked about searching on Fox 5. Do you remember talking about the searches on Fox 5?
Yes.
Okay. Did you see any searches on March 14th when both his grandmother and Tyesha were asking him about whether or not he was around that location or if he heard about it? Did you see any searches for the shooting on that day, on March 14th or in the early morning hours of March 15th?
No.
Are all of the searches on March 17th?
They are.
And is that the day he was ultimately arrested for these charges?
Yes.
Now I want to go to Stacy Exhibit 437 VV, page 2145, April 1st, 2022, from 11 minutes to 11:20 seconds into that call.
What time's again, I'm sorry?
11 to 11:20. You can pause the call.
Yeah.
Yeah, that's all it is. Just assume. Hey.
Yeah, I already know. Like when they got down, go to wiping down, doing them got down, them. You know how they gunpowder, forensics, all that shit there.
Yeah.
You gonna come back clean. You see what I'm saying? So I ain't tripping on that.
Uh-huh.
Yeah.
During that call, he says when they talk about that GSR stuff, when they wipe it down, it's gonna come back clean.
Correct.
At any point, he's saying, I don't know why I'm even I don't even know what any of this is about.
No,
Does he say to his best friend, I don't even know why they took this.
Proper commentary, also facts on that.
Sustained.
Does he say to Demarco Garlington on this call, I don't even know why they took that car?
no,
Does he say to Demarco earlier in the call, that Miles and Quay, they don't need to worry?
yes,
Miles and Quay, were they both in the Ford Fusion?
yes,
Were they in the car that was furthest from Mr. Drinks?
yes,
Did you hear when Mr. Stillwell told Mr. Garlington, I told them not to talk to the police, don't say nothing? Did you hear what he told Mr. Garlington that?
yes,
And this entire call is on the contraband phone
correct,
that can't be monitored,
correct,
or outside of it being a wiretap, cannot be monitored.
correct.
LPR readers, what information do you need about a car in order to look for a car on an LPR reader?
A license plate, a tag number.
Do you at least need to know the make and model of a car?
Overruled.
You can try by make and model, but it's not very accurate sometimes, especially at night.
With the two cars that we saw in the FedEx surveillance video, were you able to see any license plate information on either of those two cars in the FedEx video?
I was not.
And at that FedEx video, is that where we see the Audi and the Ford Fusion run the red light?
Yes,
Court's indulgence.
What are we doing? Are we passing?
All right,
Uh-huh.
recross.
Recross.
Thank you, Your Honor. May it please the court. Investigator Viverito, good afternoon.
afternoon.
So you were just asked about LPR readers, and I think the context is figuring out the car that did the U-turn and the car that sped up behind Mr. Stillwell.
Okay,
And you said you need a license plate and that you can't see the license plate from that video.
or if you have it, sometimes a make and model search might work, but at night, in my experience, it's not very accurate.
Well, are you aware that it was in fact a make and model search that night that revealed the license plate of the white Audi and the white Ford Fusion?
No,
Okay. That Detective Ender, I believe her name is, did? Okay. So, the bottom line is, LPR search by make and model, it's never going to work if you don't try, is it?
no, but if you're saying she did it for those two, it probably should have captured whatever other car.
Okay, I agree. All
Yeah,
right,
but
so what's the license plate of the car that sped up behind Mr. Stillwell?
Well, I was going to continue. Like over the summer, I've been working in investigation quite extensively, looking for a very particular two cars in the city. I probably have searched every LPR in the city by make and model. And at night, you may put white Nissan, you may put white this, white that, and I'm getting back white Tesla, when I look at the license plate and pull up the results, they're not correct.
Okay. And I appreciate that anecdotal story about what you've been doing this summer, but the fact is, that night, make and model was used to reveal the license plate of the Ford Fusion and the white Audi.
Right, my
And it was nighttime on March 14th, correct?
right, but depending on what LPRs those cars had hit, that location on Windsor right there, I don't know if there's one right there that would have caught it clear enough.
Okay, well, what LPRs did the car that sped up behind Mr. Stillwell that has not been tested for gunshot residue, what LPRs did that hit?
You'd have to ask Detective Hogan.
Okay, you keep saying ask Detective Hogan. One minute you're on the side of Windsor Street trying to
Bushes.
find homeless people as part of this case,
Correct.
and the next minute you don't know anything about the case and it's ask Detective Hogan.
That's not what I said.
Okay, well, I want to know, do you know if any LPRs were run on the make and model of any cars besides the white Audi, the Ford Fusion, and the red Versa? Do you know if any other LPRs were run or even attempted to be run?
First, I wasn't in charge of running the LPRs for the case,
Okay.
and if they were running it by make and model, that maybe they saw, if you have a make and model, it's much easier than just say, not having one that you're looking for.
Okay. You talked about the phone conversation between Mr. Stillwell and Mr. Garlington about he never told Mr. Garlington, I don't know why I'm being arrested or something to that effect, or I don't
Correct.
understand. Okay, when people are arrested, you've arrested people before, right?
Correct?
Okay, and you typically tell them what the charges are. You give them that courtesy.
Yes, of course.
And you tell them what you're arresting them for.
Of course.
Okay, they don't have to agree with you, but you do inform them of it.
Correct.
Okay, so are you saying that Mr. Garlington is the first person that Mr. Stillwell would have talked to after being arrested on that jail call or that phone conversation? Is that what you're saying?
No, he'd been in custody for a minute at that point.
Okay, and you would agree that there's probably been significant ability for the people that arrested him, other people involved with the case, to inform him what his charges are and generally what he's accused of?
I don't think that's what Ms. Hylton meant. That's not how I took the question for me.
Okay, cool. We pulled out this mapping information for the call on March 15th at 2 a.m.
Correct.
And it showed that, remember that radius? And it was
Correct.
Mechanicsville.
Correct.
Mechanicsville is in fact in the city of Atlanta, correct?
Correct.
It's in the city.
Correct.
All right. And finally, just one other thing I wanted to ask you about. Miss Knight, could you do me a huge favor? I think it's 471 DB. Could you publish? Did I get the number right? Oh. Okay. This is 471 VV, and that is a picture of Mr. Nichols, correct?
Correct.
And on it says, on the picture on the right says, what you saying, I run with cold-blooded killers, bloodied killers.
Correct.
Okay. Now, I'm not an Instagram person.
Okay.
Those words, are those words that Mr. Nichols typed into this photo?
No, I stated that yesterday.
Okay, well, we're going to go through the whole process today.
Okay.
So these words are when you pick a song such as Young Boy Never Broke Again, Villain, and someone clicks on the post, the music plays, correct?
Yes.
Okay, and as the music plays, lyrics come up.
Correct. You select a portion of the song that you would like to play.
Well, That's not entirely true. Instagram suggests a
Sugge-
portion.
It's like between a 10 and 30-second portion.
Yeah, and
that
Instagram suggests.
you can agree with it or you can modify it.
Right, but Instagram suggests.
Correct.
Okay, so if I'm posting something and I want Young Boy Never Broke Again villain, I'm going to post, I'm going to say that's the song I want, and Instagram makes a suggestion.
Correct.
Okay. And now I want to go to the video. Miss Knight, can you help me out with the VVA? Thank you, Miss Knight. 471 VVA. And Miss Knight's about to publish it. What I would like to do, and I know we've seen it already, but if you would indulge me, tell me when the screenshot that you took and provided in discovery for 471 VV, tell me when that comes up.
You know what, man? I don't give a fuck. But y'all pussy. Don't even come from no fake page. Come from your real page. I don't get no fuck, man. Come on, man. Hey, it ain't private. It ain't private. And this is what they want me to do on Stillwell Heights. I might die. Never getting on another fucking roller coaster damn my life.
Nigga ain't gon' fuck with us. So what you saying is up? It's up. I step on any nigga. Name a block ain't hit. Name a hoe ain't hit. Name a nigga don't try this shit and survive this shit. Every nigga don't try this shit, don't die this shit.
I can't tell you. It might have gone too fast. I'm not sure.
Okay, could you go to 140 and just 138? Okay, right there, and just start playing again.
Nigga ain't gon' fuck with us. So what you saying is.
So, Miss Knight, if you could just rewind it, and it's very brief, about 1 second. A little bit further. I appreciate it. Investigator Viverito, when you saw this story by Mr. Nichols, you had to scour this story to find the spot on this post where it had those lyrics, didn't you?
Well, no. I turned over in Discovery the video in its entirety because I felt all of it was pretty damaging and consistent with the case. But it's my understanding that we had to condensed the social media. So that was the screenshot that was turned over in lieu of the video.
I'm going to ask that question again. To get that screenshot, you had to parse this to a millisecond to get those words up on the screen.
Or I just took a screenshot and it happened to be that one and we kept it.
Oh, it just happened to be that one.
There are other things that that probably would have been better to keep
Okay.
that weren't kept.
So, so you just happened to screenshot. Now, you would agree that in this video, there's Mr. Nichols and these lyrics are being shown on the screen as music is being played.
Yes.
And you would agree that many of the lyrics, as the song is being played, are up on the screen and easy to read.
Correct.
Okay. Right before the lyrics become easy to read, there is a split second, a millisecond, that has those lyrics in that picture, 471 VV, isn't that correct?
Correct.
You don't even know if those lyrics were the ones, first of all, you don't know if it was just suggested by Instagram or actually chosen by Mr. Nichols, right?
The song was chosen by Mr. Nichols.
Of course, the song. I'm talking about the lyrics. You don't know if it was Instagram choosing these lyrics because these are the most popular ones in the song, and they make a suggestion.
No, but based on the rest of the videos on the post, the theme is murder, bullets, guns, things like that. It fit.
So again, and you don't even know when it's on for that millisecond. Just supposing, hypothetically, if Mr. Nichols did choose the lyrics, you don't even know if that was Instagram just had the last lyrics up and then was getting to the lyrics he chose, which are shown clearly, or if it's something that Instagram just chose. You don't know.
I don't, but he can preview the post before it posts to his account.
Okay. So you have absolutely no evidence that Mr. Nichols intentionally chose those lyrics.
Which is why I included the video in its entirety with the other posts about murder and shooting.
And in preparation of this case, you scoured this video and paused it at that exact millisecond when it had those lyrics. didn't you?
Did not. I took a screenshot.
Okay, took a screenshot. I'm sorry. At that exact millisecond where it had those lyrics that are in
I-
471 video.
I probably took several, trying to catch all the lyrics, and that was probably when we had to condense evidence. That's one that was chosen.
How many different screenshots did you take?
I have no idea.
Well,
We're
can
talking
you
about.
just tell me from your report?
I can't. You can look at my folder that was served to discovery and tell me.
All right, thank you.
You're welcome.
Ms. Weinstein, anything? Okay.
Good afternoon, Investigator Viverito.
Good afternoon.
So you mentioned that Mr. Kendrick's phone was seized at the time that he was arrested on May 9th, 2022, correct?
It was.
And his phone was extracted.
It was.
Did you review that extraction?
I did.
And if you reviewed that extraction, did you see that he had been spending several months in LA and then only returned to Atlanta within a day or two of the day he was arrested?
I did.
Did you also see other location data within that phone?
Absolutely.
Okay. And in that location data, again, he'd been spending the bulk of his time in California, correct?
Correct.
All right. Did you look through all the photographs on that phone?
I looked through a good bit of them, yes.
The two photographs that were shown in court this afternoon, are those the only two photographs of interest that you believe were in the phone?
No, there was probably a few.
Okay. Did you find any evidence on that phone that Mr. Kendrick was in possession of any firearms?
No.
Okay. Let's briefly return to the Richard Mill watch.
Yes, sure. Sure.
I understand the eye roll. During the seizure that day, and I'm looking at a property report.
Sure.
During the seizure that day, you, and when I say you, I mean APD, can I say under your supervision? Is that accurate?
I didn't work for APD at that time, so I
Well,
couldn't.
Okay, then let's just say APD. Y'all see, APD seized, APD seized a necklace and a pendant from a bedroom, correct?
I guess I'd have to look at the report. I don't have it in front of me.
Okay, well, you were involved in this. They seized a blue box of jewelry, correct?
Correct, in a red box.
And a red box of jewelry. They seized jewelry that was on Martinez Arnold.
I believe so.
They seized a Chevy Corvette,
Yes.
a Dodge Durango,
Yes.
a Mercedes-Benz AMG,
Yes.
a Mercedes-Benz GLS class,
Yes.
a Porsche 911,
Yes.
a Jeep Grand Cherokee,
Yes.
a pink Lamborghini,
Yes.
another Mercedes-Benz aluminum silver,
Yes.
about jewelry that was located in a Mercedes AMG.
Yes.
And they even seized a ring found on Jeffrey Williams' hand, correct?
I'd have to see which one was on his hand. I didn't have any contact with Mr. Williams when he was arrested.
Okay. So despite seizing all of that, you left behind the Richard Mill watch, pink with a white ceramic case.
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on the thing, if you watch the video, and it's placed on the shelf, and nobody messes with it again.
So was that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. Thank you, Detective. You are
Thank you, Your Honor.
excused.
There we go.
Do you have any
Sorry I
more?
disappeared, guys. Had a client call.
I know, but before we do, we just need to, can we have about 5 minutes, Your Honor? I just want to confirm that we have it in evidence.
To make sure that everything's in evidence, sure. We'll take a short break.
Oh my gosh, what if they come back and want to add another witness? Guys, by the way, if I have to take the young boy music out of the stream, if you see that the stream's blocked or no longer available, which is what tends to happen, give it 2 to 3 hours. It'll be back up. It'll just have a random chunk missing from it. So, yeah, I know. Thank you guys in the chat for looking out. It is what it is.
All right. While you are
Miss Knight,
making sure that all of your stuff is in evidence, I need to ask each defendant some questions about to make sure that they understand their right to testify or not. All right, let's be back at 4:45.
Interesting. Both of them? Do they always ask that before the case in chief starts, or is that just before they the defense rests the case in chief? Yeah, this is weird timing. Interesting question. And obviously, yeah, I don't think they're going to testify, but still an interesting timing of the question. So, but yeah. I don't know, what a day, you guys. State finally rested. Do you want to do like a 120-second all cap session? Finally rested on day 163. A week shy of when the trial started. Wild. So The celebrations, the finalies, the oh my goodness. Yeah. Yeah, you're right. It's not official. You know what? I should have us hold our horses. Celebrate that Viverito's off the stand. Celebrate that Viverito's off the stand. They're gonna call in all of the people to tell us about the timestamps of the BP video, and then they're gonna call back the ankle monitor guy. I can't believe they got into some testimony that she went into the bushes to canvas. She really went into the bushes. Oh, Doug probably just made the decision it wasn't worth getting into that in front of the jury. So that might have been a interesting slight at, a witness's credibility. I know you're constantly following these men around. You've been looking at them. You were looking at them before you were supposed to see them as suspects. You misrepresented the way you were looking at them. You had tunnel vision. But for the jury to have faith that the jury might draw a positive inference for your client, and really Shannon Stillwell, which isn't Doug's client, from that would be interesting. And then if they weren't going to mention that it was Kayla, I mean, how would he approach that question? Were you harassing somebody that isn't in this courtroom that I'm not going to say their name? So I get that it's like, to me, it shows a lot about Viverito, right? She puts on this, oh, innocent old me. People like talking to me. But as soon as you're outside of the cameras, which you don't want to be shown on, you're out here mean mugging somebody. And it also bothers me that Whitaker is like, well, that's not a threat. I mean, the state keeps putting forward messages that are more convoluted than what Doug presented, saying that it's unequivocally a threat. So a lot of talking points there, but nothing that's really, in my opinion, going to move the needle for the jury. And I'll tell you, it's not a complete lie. And Doug would not put that forth with, in my high opinion, I do like Doug a lot. He would not put that forth without backing. And there is backing provided that it happened. So, I have something pinned at the top of the chat. If you want to hear more on exactly the details, that would be the way to get them. So, no, and this would be, the situation would be the other way around. It would be the other way around. This is something that unsolicited, just like, because Doug said it, just right in the courtroom, if you want to rewind, that Viverito made an unsolicited comment to Kayla Bumpus. So, okay, wait, so Kayla, hold on. Hey, Kayla. There you go. So maybe if Kayla wants to tell you in this chat, she can tell you in this chat for sure. That's her call. I'm going to defer to WTF Wednesdays pinned at the top, because it's not mine. It is not mine. Julie says, Doug, call Kayla back to the stand. Yeah, put on a case in chief and just call one witness. And also, shout out to KC Dog 9779 who says, Kayla's gonna play herself in the movie. That's right. Don't let anybody take your likeness. Do it yourself. Love this here. Thank you, KC Dog. KC Dog also said, when being nosy comes back to bite you, everyone will definitely know your face now. We all know what's in a burrito anyway. And it just bothers me to pretend that, if you're not supposed to be watching the trial, you shouldn't be watching the trial. And I think it's interesting that she chose to watch Kayla's trial. Like, she knew she wanted to hear something that would be personally offensive to her, maybe. It's not anything that's really investigatory. So, and then she took offense. She clearly took offense because she made an unsolicited comment in the hallway when she thought nobody was looking at her. So again, all of this, I would never steal a watch. I wouldn't do this stuff. I wouldn't misrepresent things. I wouldn't lie to a judge. You put on your goody two shoes on the stand and then you walk out that courtroom door and you act an entirely different way. I mean, That Girl Shine says not guilty on all charges. They saved the worst for last. Yeah, that was their finale. Let's see if they have their 5 minutes to figure out they suddenly want to call another witness. I mean, like, just, where do we do that at? Where do we do that at? And I feel like they're doing that because they don't expect to have an opportunity for much on a rebuttal. Doug's not going to put forth a case in chief. If Max does, maybe it'll be limited, and now they're scrambling. So, no, I don't know. Sean Turner says the trial would not have been complete without one last motion. This is very true, right? You got to get that motion in right before and maybe they're not going to rest their case with this witness, but it seems like they might. So, got to get one more motion in there. The state has been watching online. The state hurried up and said they are married. Yep, and I still think the timing of it all is very interesting because that marriage certificate said August. So, what else is a surprise here? More interesting stuff in this trial. Mark Lyon says, Hylton, we stipulate that the witness is ... Listen, I think my favorite part of the day, I know a lot has happened today, but my favorite part of the day was Hylton yelling to save this whole thing with the timestamps. And then a body coming in with the assist. So, of all the things that, like, the final hour here, Mark Lyon. I don't even know. Thank you for the 2. KC Dog says, this got my blood pressure up, Your Honor, in my Woody voice. Yeah, gotta get the water. Or not the water for Woody, but this definitely is a day. I agree, so I'm flipping over. Biff says they all wanted to cry. Hylton was sitting there like this. Oh my gosh. Fashionably Fit Life,
Will
thanks for
both
being
be
here for a month.
examined by your attorney and cross-examined by one of the prosecutors. Do you understand that? All right. And do either of you need any more time to talk with your lawyers about your decision whether to testify? All right. Mr. Kendrick, do you personally want to testify or not? Okay. Mr. Stillwell, do you personally want to testify or not? All right. I find that each of these defendants has made a decision whether or not to testify with an understanding of his rights. All right. All right, we need to do anything else before we get the jury out, and I'll ask if you rest. And then have y'all made a decision about whether y'all going to present evidence? Okay, you want to let me know or you want to be dramatic about it? Okay. All right. All right, then I'll get them out. We'll close the evidence. I'll let them go for today and tomorrow. Have them come back on Thursday. And tomorrow, I mean, we can start the charge conference. And, oh, forgot something. There'll probably be a motion, I suspect. Okay.
Directed verdict.
Forgot about that. Okay, so I guess technically you need to rest before that motion. So I'm going to have to bring them in, then excuse them again. Okay. Yes.
I understand that we're trying to keep things moving. I'm going to ask if Your Honor would consider giving us the afternoon and evening to look at the directed verdict motion. I know that you've suggested we need to be doing that, but there's only 24 hours in a day, and I think it would probably be more fruitful if all of us had an opportunity to review kind of what's come in, and so we can sit down and have an educated discussion.
Sure, that's fine. So tomorrow we'll gather together. You'll present whatever motions you have.
Thank you, Your Honor.
Whatever response there is. I'll have to consider all of that. But I would also like to do the rest of the charge conference, the RICO part of the charge conference.
Can we have
Yep, sure. Okay. What are you, do you need?
I was just thinking procedurally, what happened? We rest, then we have, do we bring them?
We rest. I let them go for the day. All right, Ms. Hylton, does the state have any further evidence?
No, Your Honor, the state of Georgia rests.
All right, thank you. Okay, ladies and gentlemen, considering the hour, I think that I'm going to let y'all go for the day. And then actually tomorrow, we will all have matters to take up outside of your presence. That's been kind of a common theme in this trial, and it happens in every trial, I promise. So y'all will have the day off tomorrow, and we'll see you back Thursday at 9 a.m. And just let me remind you, all of the instructions that have been applicable to you for the entirety of this trial remain applicable right now. Don't try to find out any kind of information about this case from any source outside the confines of this courtroom. Don't talk to anybody about this case. Don't let anybody talk to you about this case or anybody involved in it. Don't try to do any research about the case. Don't ask anybody hypothetical questions about the case, and we'll see y'all on Thursday. Thank you. Okay, so what else did we want to discuss?
When we were, Your Honor, when we were talking about the RICO jury instructions, I guess what I'm trying to figure out, I understand that we have certain jury instructions, preliminary, we both submitted preliminary jury instructions.
Yeah.
And I know that we have certain ones on that document that we're all sharing.
Mm-hmm.
I'm just trying to make sure, are there any other proposed instructions from the state that I need to be aware of to prepare for argument? Because I don't want it to be sprung at the last minute.
I mean, I haven't gotten any. Are there going to be any more forthcoming? I've been trying to put some together from various things that I've culled from different RICO cases, and that was pretty rough when I sent it to y'all yesterday. I've worked on it a little bit more today, so I'll send y'all an updated draft, which, Ms. Percival, let me send that to you right now. So what this is now, it will look somewhat familiar, but it's in a little bit more polished form. So the first 4 pages are what I've put together, and then the last page and a half probably is lifted, some of the language lifted from the APS, RICO, not APS Atlanta Police, APS Atlanta Public Schools cheating trial. I have looked at some other trials too and tried to pull some language from that. But if there's something else, I haven't gotten it yet. Mr. Floyd, are you going to be providing us with any suggested jury instructions on RICO and or a possible verdict form with regard to RICO, which would be really nice?
Those are separate but related questions, Your Honor. So to answer the first one, we haven't sent anybody any additional ones. We've looked at yours. They've been kind of evolving. But I don't have very much complaint about them. They're largely drawn from APS, and I wrote those, so I'm not in a, it's only just a matter of whether there's anything in between.
Those aren't actually drawn from APS. I didn't look at the APS stuff until this afternoon, but okay, you can take credit for it.
Well, I thought that's what you said. I'll tell you that they are, if they're not drawn from APS, they're drawn from cases that use a version of the APS charges.
Okay.
There might be an intermediate generation, but they.
Anyway, I hear you saying you think they're pretty good.
You heard me say, I think they're pretty good.
Okay.
And I mean, I can't at this stage, because we're just starting this process.
Sure.
I can't foreclose that depending on what you decide to do with one charge, we might suggest that another needs to be supplemented or we add something.
Sure.
But I think.
You don't have any whole scale additions that you think need. We'll just hash through it. Okay.
I do not, and I think there's one issue that has to be resolved. I mean, I only have 2 charges submitted by Mr. Kendrick.
Yeah.
I don't have any charges submitted by Mr. Stillwell. On RICO.
They're working together on it.
We're working together.
Okay, that's what, I'm just making sure I'm accounting for everybody here. I understood they were from the defense. They had the name Kendrick on them, so that's why I made that specification.
Thank you.
But I'm gonna surprise you. We disagree with them. I'll explain why. One is a short explanation. One is a longer explanation. You have statute of limitations.
Oh yeah, I already told him he's totally wrong on half of that.
Okay,
You missed that part. But.
Okay. All right. It's the opposite. The rule is the opposite of that.
All right. Well, we'll get into the nitty gritty tomorrow if that's okay with everybody.
Sure. And the other one, which is how you instruct the jury about overt acts and what conclusions they need to reach, that feeds into the jury form. And I've done a good bit of research and I have some things to say about that.
Well, if you have anything for me to consider sort of in the interim, because you probably are not going to be, I mean, you might be working on the directed verdict motion and response, but if you're not, and if you have something that I could be considering in the interim, go ahead and send it to Ms. Persifield.
Will do.
Because, yeah, I mean, it's a lot more straightforward when you're alleging RICO and not a RICO conspiracy. And so I definitely want to get right what it is that the jury has to find.
Understood. Yeah.
So, yeah.
Yeah. So, I mean, I can tell you that what the state submitted is based significantly on APS, which was also a RICO conspiracy case.
Mm-hmm.
It was also based significantly on the jury charges that were submitted in a federal Georgia RICO case based on sex trafficking this year.
Okay.
And also on a case that was tried last year in Brunswick that was a Georgia RICO conspiracy.
All right.
So it's sort of the evolution of that. And I'll address what you want me to address, however you want me to do it.
Okay. All right. So if you do have anything more in writing, go ahead and send that now, and that includes a potential verdict form, just send it to Ms. Persifield, she can send it out. I mean, I think we've got a list of all of the attorneys, so.
I don't have anything set to send right
Okay,
now. But
that's
if
fine.
it's tonight or first thing in the morning, our view is the verdict form can be very simple.
Interesting.
We would want probably a more detailed.
Tell me more.
Okay, why don't I get into that then, Your Honor? So the question I think that has come up is whether the jury should be asked to decide which acts of racketeering activity the members of the conspiracy agreed would be committed. And there's two approaches to that. One approach, which is usually what defendants suggest, is that there's going to be a very long list of every one of them, and they're going to be asked somehow, did the conspirators, which would really mean any of the conspirators, any two of them, agree this crime would be committed? Because the ultimate objective has to be a substantive violation of the statute. That's the Supreme Court, U.S. Supreme Court said that in Salinas, and I think you've recognized that in things you've said and pleadings that have come along. The other approach is to say, instruct them that they have to agree that the conspiracy contemplated certain types of acts of racketeering activity, and they have to decide whether the conspirators agreed that any of those types would be committed without going to specific ones. So, and usually when I've addressed this issue or something like it, the argument from my opponents is, well, why wouldn't we want to know everything? And the answer is, you get a case like this where you have almost 200 overt acts, about half of them are also racketeering activity. And that is an opportunity for a lot of confusion, and it takes a lot out of the jury. It's a big ask for them. And jurors.
No, we've already asked so much of them.
I suggest we ask not that much more, but that's just me. But the point is that is just not normally how it is done. And this starts out with, and I know we submitted a brief on this earlier, a bench brief, but it starts out with a basic understanding of what conspiracy is. And the crime in conspiracy is the agreement. The crime is not the commission of acts of racketeering activity, because none have to be committed.
Right, it's
for a
the
conspiracy
agreement plus
violation.
one overt act.
Exactly. And the function of the overt act is important to understand too, because the overt act doesn't have to be a crime. And the reason is the function of the overt act, which is to show that the conspiracy is in operation.
Right.
And I realize I may be telling you a couple things that you are very familiar with, but I will be very brief. Common law, no requirement for overt acts at all. There's no constitutional requirement. Federal RICO doesn't require overt acts. The Georgia General Assembly decided to track 1648, which is the general conspiracy statute in 2015. That was added. I'm actually kind of familiar with how that happened by coincidence. And so that's it. We have an overt act requirement. But all that overt act does is show that the conspiracy doesn't exist solely in the minds of the conspirators. It's actually moved into the real world. And there's kind of a fairness issue in that, which isn't required, but many legislatures decide to do it because it gives someone who, I'll just draw the example, there's folks are having a few beers and there's a lot of talk about what ought to be done, and everybody says, yeah, that's great.
Yeah,
Nobody does anything. The next morning, someone sobers up
Charge
and says,
somebody with the crime.
hell no. So that's how it functions. So this question has not come up under Georgia RICO. This question has come up numerous times under federal RICO.
This question being what?
Does the jury have to decide which acts of racketeering activity the conspirators agreed to commit, or is it sufficient for the jury to decide the types, okay?
Okay.
And the answer is uniform. Every federal court that has addressed this question has said it is type, it is not specific. And I can give you.
I mean, I think that makes sense because what is required is they're agreeing to do bad things through a pattern of interrelated racketeering activity.
Yes.
So.
Yeah, and so what we get to, and I mean, just to kind of illustrate it in a case like this, suppose you have members of a gang and they are discussing what they want to do versus their ops. And they say, we hate those guys and we want to kill them. Everybody agrees. Yeah, I mean, wherever they are, we're going to hunt them down. We're going to kill them. If we can get them all, we'll get them all. We'll get as many as we can, right? Have they agreed to kill a specific individual? You don't know the first person they're going to encounter. You don't know which of the members of the conspiracy will encounter that person first. If they are successful in encountering them, you don't know whether the encounter will be fatal to that individual, whether they'll be wounded, or whether they'll just be assaulted because somebody shot at them and missed. But all of those are acts of violence. All of those are within the scope of the enterprise.
Mm-hmm.
And in this case, you have all of those things actually happening in real life. They're not hypothetical. A terrorism analogy would be a group of people who agree to plant bombs. And they say, we need to destroy, I'll put it in Al-Qaeda type references. We're going to destroy the symbols of the great Satan's arrogance. Yes, one of those. His monuments, his hotels, his whatever, okay? We must do this, yes. How far will we go? As many as we can do. They've agreed to make bombs, plant bombs, destroy things, hurt people. We don't know exactly which bomb will get planted, exactly where, if it'll actually go off, whether hundreds of people will be injured or nobody will be injured. But they have agreed to engage in this course of activity. That is the violation. It's manifest. In federal law, all they would have to have is that conversation. Georgia law, all they would have to do is have that conversation plus an email, a phone call, or in some cases, as it tends to be, many, many other things.
Mm-hmm.
But that's all it is. And that's why, just for the record, I'll give you a few examples. United States v. Applins, APPLINS, 637 F3rd 59 at 8081. It's a Second Circuit 2011 case held. The jury was not required to answer special interrogatories as to which specific predicate acts each defendant would commit. U.S. versus Gutierrez.
What? 637F what?
Sorry.
What's that one?
637 F3rd 59
Okay.
at 8081. United States versus Gutierrez, GUITERREZ, 963 F3rd 320 at 328. District Court was asked to issue special verdict form requiring the jury to identify specific racketeering activities each appellant conspired to commit. It declined, affirmed.
Okay. Is it reversible error to require the special interrogatory?
I could not say that, no. I don't think it's reversible error.
Okay.
I think, I believe you have some discretion here.
Okay.
The question is, how is it best exercised under
Okay.
the circumstances? U.S. v. Cornell, spelled like the school, CORNELL, 780 F3rd 616 at 625, 4th Circuit 2015. Cornell cataloged the cases. It surveyed the federal cases and said I'm quoting, every circuit to have considered this issue has concluded that for a RICO conspiracy charge, the jury need only be unanimous as to the types of racketeering acts that the defendants agreed to commit.
Okay. And that does seem to make sense to me because, again, we're at the conspiracy stage. We're not at the completed racketeering acts stage necessarily. So, okay.
Yeah.
All right.
I won't belabor the point then.
What else? How about overt acts? I mean, those need to, if there's going to be one one needs to be found, at least one needs to be found, that would need to be specified, right? And found unanimously, right?
At least they have to be unanimous that an overt act occurred. Yes. They generally, and I'm looking for, I apologize, I have the language with me. It'll take me 1 second. I have an example, and if I can't find it in 20 seconds, I will send it to you.
Okay.
But the instruction was, you must unanimously find that an overt act was committed, and you must be unanimous as to which one. It was not, you have to go top to bottom. And I think that is more efficient and just less likely to cause confusion. The overt act,
I would like
something the
that
statute requires, but it doesn't require a great deal of effort. Here, the question was, and I'll show you the case. It was not a RICO case. Unfortunately, lots of cases talk about what the court did, but don't tell you exactly what it said. They don't give you the exact instruction. A case called United States versus Boyle, B-O-Y-L-E, 96 F 3rd, 1444. It is out of the Fifth Circuit. It was, I just want to be clear, it was not a RICO, it was a conspiracy. The question that was asked was, do you agree unanimously on at least one specific overt act which was committed in furtherance of the conspiracy to commit each of the offenses you checked in question 1, because there was more than one conspiracy?
Yeah, I'm not sure how much we can say that's on all fours, though, considering, like you said, it's a conspiracy case and not a RICO case, which I know RICO's a conspiracy, but we've got a specific overt act requirement in our statute. Do you know of any Georgia case law or case law from a sister state with a similar RICO statute that answers this question?
Well, let me tell, I'll take a shot at that in a second, but let me back up, because the case I was talking about, and I should have said this up front, it was conspiracy to commit obstruction of justice.
Okay.
The federal obstruction statutes don't have their own embedded conspiracy provisions. So that's a general 18 U.S.C. 371 conspiracy, which is almost identical to 1648. So that was under a conspiracy statute that had an overt act requirement, just like ours does. And if you were to match 1648 against 18 U.S.C. 371, basically the same statute. I think 1648 is drawn from 371.
Okay.
As far as other states addressing this, I have not found anything.
Okay, and so would your suggestion as to how the court ensures that they find one within the statute of limitations just be to include that in the instruction, not only you must unanimously find one and it must be unanimous as to which one it is, you must unanimously find one within whatever that date range is?
They have to find one within 5 years of the indictment. That's the test.
But I mean, would you just say like, you must unanimously find one within this date range?
Yes, I mean, you could, well, the instruction that I saw, that's the other one I was going to talk about, and you suggested that you'd already settled that. I didn't hear exactly how it was settled.
Oh,
but the test.
Yeah, the other one about like, I can't remember exactly what it said because I've already deleted it from my version, but that anything that wasn't an overt act within that statute didn't even get included, and that's not true. It can be 500 of those as long as one of them is within the statute. They can find however many others they want to outside of the statute.
Yeah, and they can go back to the beginning of time as well. This question was answered in a ruling by Judge Glanville. The statute of limitations question.
Yeah, I don't have any question about the statute of limitations
Okay.
question.
All right.
I know that that proposition was incorrect, and
Okay.
I understand what the law is.
All right. And then, okay, so I may have been missing the exact question you asked me.
So
I'm
the
sorry.
question I asked is if I am not having them find, overt acts 1 through 190, do you find this or not?
Right.
Then is the way that I ensure myself that they found an overt act that is within the required 5 years prior to the indictment to just tell them, you need to unanimously find at least one overt act within the date range, and your decision about which one has to be unanimous?
Yes, I think that takes care of it. It actually answers both questions. Those were the only two
Okay.
charges I really had much to say about, and I think that would take care of it neatly.
Okay. All right. Well, again, we'll get into the nitty-gritty tomorrow.
Okay. All right.
Okay.
For what it's worth, in Georgia, the closest that I know of this issue coming up was the Dorsey trial. And in that, Judge Becker had initially said she wanted the jury to fill out this form. That was a substantive RICO. And so she would have been listing predicate acts, not overt acts. But that's kind of the same idea, basically. I don't know exactly why. And initially I wasn't successful in changing her mind, but she wanted to do it after they decided guilt or innocence and then bring the jury back. Jury went 3+ days and they came back and
Well, there are these
were a mess.
federal statutes, or not statutes, I'm sorry, but there's federal case law that seems to suggest that they need to find guilt, and then, and only then, do they need to say what predicate acts they found, which I find to be odd, but.
That's mostly, I think, out of the Second Circuit, and nobody else
Third
has
Circuit,
decided
too.
they like it. I mean, you can
that
find
may have been
many
why,
different
but
ways of
anyway,
handling it,
yeah.
especially if you go back.
Very odd, doesn't help the jury at all.
Well, no, and asking the jury to do that if they've been deliberating for a very long time and coming back in and saying, and now you have another homework
I
assignment.
mean, what I want to do is give the jury a logical and correct roadmap as to how do you consider this?
Right.
What are you supposed to think about? What are you supposed to find? If you don't find it, then what happens? I want to give them instructions that actually help them deliberate.
Yeah, yeah. And it's actually, there are federal opinions that say sort of offhandedly a RICO conspiracy case is a lot easier than a substantive one. I'm not sure everyone agrees with that, but I don't think it's a lot more complicated. It's really, do you have an agreement? Would the agreement have violated the statute if it was consummated? And was there an overt act? And then as to each individual, were they part of that conspiracy or not? And if it's
All right, let me ask you this.
the nuts and bolts.
So there has to be a, determination from the jury, whether it's a violation of subsection A or subsection B, that, they conspired to either participate in the enterprise or acquire money through a pattern of racketeering activity, and that somebody committed an overt act to further just the criminal objectives of the conspiracy as alleged in the indictment, or to further the specific pattern of racketeering activity that had been agreed upon.
No, it is not. There's nothing, first, to kind of walk it through, there's nothing in the case law that says it would have to be as specific as the second. And so if I'm just conspiring in an enterprise, if I'm just saying, I hear you guys are the best robbery crew in town, I want to be part of it. And they say, okay, but you have to ante up $1,000, or we have to use your car. Pick anything you want. Give me your cell phone. Lend me $100 till payday. Any of that. As long as it ties to that enterprise, that's sufficient. And that's why the overt act itself doesn't have to be a crime. And part of what happens here is if we pile on additional requirements that aren't in the statute,
Okay, so it's just then to further the criminal objectives of the conspiracy.
Yeah.
And it's the criminal objectives of the conspiracy as alleged in the indictment, right?
Yes. So
And
if
it's
I,
not the non-criminal objectives of the conspiracy, is it?
if I wrote a haiku that didn't talk about other gangs or violence or anything else, I don't think that would do it. I agree. But the point is, that overt act doesn't get mutated into a full-fledged attempt or conspiracy of its own.
Oh, yeah, I
Because
know.
otherwise the
I mean,
statute
it can
would say
be,
that.
we're going to kidnap whomever,
Yeah,
and then we're going to kidnap their daughter or whatever. If I go by rope, that's not illegal, but that's an overt act in furtherance of our conspiracy to do bad things.
you drive by the house and you say, yeah, they're home.
Yeah,
Okay? It's
Okay.
not illegal to drive by the house, and it's not illegal to look in the window, but if
Okay.
it's part of that conspiracy, yeah.
yeah, but the objectives of the conspiracy, I mean, the objectives, so in the indictment, there are these objectives of the enterprise, YSL, listed out, some of which
5, I think.
are criminal and some of which would not be criminal.
They have, some have non-criminal aspects to them, yes.
Some are entirely non-criminal.
Right.
And so an overt act to further one of those things would not equate to a crime, assuming all of the other elements are there,
I understand what you're saying.
right?
I think that's correct.
Legally correct? Okay.
It says, the statute says an overt act to effect the object of the conspiracy. It speaks in the singular, it doesn't preclude the
Right.
plural.
And that has to be a criminal object, right?
We're talking about, well, the object is ultimately to violate a substantive provision. And I'm not trying to mince words, I'm thinking along with you.
Yeah,
But if you're forming an enterprise, remember that an enterprise can be legal.
yeah,
And so I might, if I form an enterprise as part of this, like, different from this case, but an example, I form a corporation. But I'm forming the corporation as part of a securities fraud scheme or a money laundering scheme or something like that. That can be an overt act in furtherance of the objectives of the conspiracy. It is not itself illegal. I think we all agree the overt act itself doesn't have to be illegal.
right,
The statute says to effect the object of the conspiracy.
right. And when it says to effect the object of the conspiracy, implied in there, but necessary, is it has to be a criminal object of the conspiracy, because it wouldn't be a conspiracy if it weren't an agreement to do something criminal.
We wouldn't be charging a conspiracy to comply with the law. That's correct.
Okay.
Yeah.
All right. Anybody need any further exposition before we get more detailed tomorrow?
No, I just want the opportunity to respond tomorrow. That's all.
Oh, absolutely. And if you want, I mean, it's only 4:20, so if you want to respond to anything right now, go ahead. But y'all wanted the afternoon to work on the directed verdict, so.
Right. And I'm going to reiterate my humble request of the state in an effort to get to the bottom of the directed verdict stuff and arguments. I know you're busy. Could someone please send over email copies of the exhibits that you have admitted? Because I think they were giving us, for most of the trial anyways, PowerPoints of the upcoming exhibits. And I think that would cut to the chase about a lot of these directed verdict. Because my memory is not perfect going back 8-9 months.
I believe Ms. Knight has started, and I thought she sent the link, I'm confirming. Are there
Okay.
certain acts that you want, because of the amount of media in some of them, and they're taking a little longer, are there certain acts, and we can talk offline.
Yeah,
Are there
yeah,
certain
yeah.
acts that we can start with first, and then get
Okay.
the other ones up?
All right.
And I assume you'll have, if you find it, whatever that law is that we're talking about on the gun count.
Yes, Sean, I will forward the case.
All right. And then y'all will have specifically a list of evidence that exists and is admitted in this trial to support every one of these counts, right? Because I'm assuming, I mean, I don't know what they're going to move for directed verdict on, but you'll have the answer as to whether there is evidence to support it. Okay.
And I'm just trying to.
All right. By tomorrow, when we take this up in the morning, like, I don't want you to say to me, oh, now that I've heard what the directed verdict is on, let me have the next 4 hours to get my response together. Because we talked about this a week and a half ago, that we were getting to this point and y'all needed to be ready with whatever y'all were going to say as the defense and whatever you were going to respond to as the state. Okay. All right. See y'all at, we want to say 9? Okay. See y'all at 9.
Now, tomorrow is my kind of day because I feel like you get to learn a lot. I know that it might have seemed like John Floyd was going on and on there, but it's interesting to listen to. He's regarded as the RICO expert. Paige was looking forward to Judge Whitaker was looking forward to hearing from him. And all said and done, I mean, I'm learning from what he's saying. I'm getting that there's things that he doesn't know. Are we back? It never ends. It never ends. Why is the body looking like that across the camera? Okay, Maurice just wanted to run it back one more time. All right. All right. So there we go. Maybe, right? Maybe. So guys, it seems like this is really coming to an end. I don't know, jury deliberations could take a very long time. It's going to take a long time, and I expect the day that Whitaker gets the jury in and reads them the instructions, guys, that's going to be a long and boring day, so that might not be everybody's cup of tea, right? Whatever they come up with and argue for jury instructions, then they've got to read it all to the jury, so that should be coming. But I am really interested in, Whitaker has researched this stuff. That is clear. She has gone and looked at multiple circuits. Even when John Floyd pointed out, the Second Circuit, they do things a little funky. Whitaker is like, well, the Third Circuit too. So Whitaker is out here looking at this stuff. She's bookworming. She wants to know what she's supposed to know. And I can't give answers here to everything. Even Floyd said, hey, we have to look over at sister states for some of this stuff because it's a new question here. It's a newer frontier here. But really, I think what stands out the most, and again, we are going to hear some response from, I guess Doug Weinstein is ready, but also probably Schardt on this issue. Doug Weinstein had said he was working on this a lot over the weekend because he knew that Stillwell was the subject of Viverito's the most of her testimony. So Doug Weinstein, I think with Justice Served on that podcast, he said, look, I'm focusing a lot more on, the RICO statute and jury charges and what we're going to do with all of that, because I know Max has a lot on his plate because of the bulk of testimony focusing on Shannon Stillwell. So I'm excited to see the response, but Whitaker is tuned into this issue, you guys, and she's even dropped hints throughout, like even when all 6 co-defendants were here, certain questions about the RICO statute. And I think it's really sticking with her. I wonder if Bruce Harvey, I don't think Paige was unaware, but I think Bruce Harvey kind of like unlocked an extra nuance when he underscored the conspiracy to violate RICO versus a substantive RICO where you're dealing with someone selling drugs, right? Is that necessarily a conspiracy to violate RICO? Because we do these things all of the time. It's our lifestyle. It's our nature. We're always doing this. We're always on code. We're on the same page about the illegal things that we do and would do for our enterprise, which in and of itself might not be illegal, right? I think extra nuances were sparked in Whitaker's mind. And I really think she's in tune with this. Just curious to see where it goes, where it plays out. But with the Overt Act requirement in Georgia statute, John Floyd, and I might want to go back and look at it, but John Floyd mentioned, the option of a special interrogatory. Now that's something where let's say the jury has their verdict, and you heard him reference this, like they're supposed to find guilt first, and then maybe we ask the questions for clarity. I guess this is a thing. I guess special interrogatories are a thing in Georgia. I know in some states they don't allow that, but it's a way that after the jury has made a determination, you can ask a pointed question to the jury, kind of to get clarity that they're finding, that they understood their finding one more time. And some states have done away with that because the instructions should be sufficient enough, and you should trust the jury to follow them. So, hold on, I've got something up that's making this all funky. Oh yeah, so guys, I clipped that like 14-minute recross with Max where he did the music playing. It got 4 copyright hits on that thing. So this stream, when I end it and it processes, it will go down, it'll come back up. It just needs time to render and reprocess the stream. I have to remove the audio for each segment. So if it got me 4 times and it's a 8-hour stream, the stream will probably be unavailable in most countries for several hours. So sorry about that if you need replay, or you get to this, you're behind and you miss the end, because it'll stop. When I end the stream, if it gets hit and blocked, it'll be blocked for those that are watching behind. So sorry about that. Thank you guys in the chat for looking out. But back to this special interrogatories, I'm not fully aware of what's going on in Georgia, but because of John Floyd's statement, it seems like they can have special interrogatories where they can ask the jury after the fact if they really understood their determination while they were making it. With the overt acts, I think Whitaker's really curious here about what exactly constitutes a conspiracy to violate RICO. John Floyd gave, I think his examples are really clear. You know, it's not a crime. Whitaker said it's not a crime to buy rope, but then if you commit a crime using a rope, that could be an overt act. If you drive by someone's house, this was Floyd's example, and you message someone, hey, they're home, that it's not illegal to drive by someone's house, but that could be an overt act. Now, does that puzzle piece, that gave me the framework, right? Like you put the edges of some people when they do puzzles, they put the edges together first, and then it's easier to put everything in it. It seems like they combed through the evidence to find things that they could say were these overt acts. So think about I was riding around the scene. That whole insistence, having Viverito be the last witness, and she's the one laying out this issue of fact that's up for dispute that the jury has to determine. Were they riding around the scene to check out this Chamel drinks thing? Right? That fits John Floyd's example of riding around the scene, if that's what it actually means. Wouldn't be a crime in and of itself, but it's an overt act if they were the ones that committed this murder of Chamel drinks. Right? So if you look at it through this lens with what they're saying would constitute an overt act, you can kind of see why they want these certain witnesses so badly to get up there and give their gang expert testimony assertion of what things mean. So there you go. And I highly disagree, guys. I live in Florida, so the way people pronounce things, I cannot imitate it, but the way people pronounce things like city, it's like they skip the T. It's not like city. It sounds like C. They skip the T. But they would say what I heard on that, riding around the city. Like, I don't know, I can't like not say the consonant there, but I'm just explaining that I've heard it be said that way, but they're saying city. So I disagree with Viverito's assertion, but this is why the state wanted to hinge their case having a witness like Viverito up there at the very end. Looking at some of these text messages saying, I'm out here op hunting. You heard Floyd reference something about going out and hunting for your people that you don't get along with, your enemies, right? It seems like Floyd was considering this stuff. Somebody's fitting the pieces together based on what they think they need to meet to get a jury verdict returned the way they want it returned, right? You're seeing why they're fixating on certain things so much. So I don't have much clarity because this is still up for debate. There's no conclusion here with what Whitaker is going to say should be the charges to the jury on how to handle this RICO. So I am nowhere near as informed as John Floyd or Paige Whitaker So that's what I've got. But you can kind of see the process with which the state put their case together. So yes, I was trying to think of this, LaShawn. LaShawn says, like, Hylton says the T acts instead of ask or modify. Today I saw you guys all modify instead of modify. Yep. So that's my summation there, guys. I'm excited to watch the directed verdict tomorrow. It seems like Whitaker's excited for that, which is very interesting. It seems like the state isn't prepared for the tumble through the closing, right? It seems like they've got a lot of homework to do. So, I think this is going to take a while, this jury charge, figuring out the rest of RICO. The directed verdict will take some time. But let's say, for example, we go into closing statements on Thursday when she's telling the jury to come back in. State's got to be ready to prepare, and it seems like they might not be ready to. So, I don't know. And this is why Rio, the enterprise, the structure, this is why it was also important for Viverito's testimony, and she's not the only one that testified to it. But this hybrid structure where there isn't a traditional hierarchy where everything's like pyramid shaped. It could be, here's a bunch of people that kind of organize different enclaves, and the enclaves are like loosely associated through someone that communicates with one in the next. And even recently, we're kind of seeing that with this testimony with Unfunk and Quantavious Greer, where there's some overlap with other gangs, known gangs, and even some of the members move back and forth between them. So they're an enterprise under RICO doesn't need to fit one specific structure, right? So the state has argued that, well, it doesn't need to look like a pyramid with someone at the top. It can be kind of more superfluous. So, which kind of sucks because the state has argued that Jeffrey Williams was like the big dog, the top dog, the leader calling the shots. So they've made both arguments, which I think is problematic. But again, the jury might have picked up on that. I want to give a big shout out here. Esquire 1995 had dropped 10 gifted memberships, which is super nice to do. I'm so late, so sorry if you're not here anymore, but thank you so much. Kevin Kirksey said, and yes, we bringing back the PB&J sandwiches. Heck yeah. Always love a good sandwich, and love the examples you guys gave with the way that Adrian loved to ask the questions. Mark Lyon says, doing all possible to avoid resting before the end of day. A little bit, right? A little bit. I mean, redirect was pretty long, right? And they were hanging on to that spreadsheet. They were screaming, yelling to let that spreadsheet let us get these timestamps in. Please let us have our firework moment with the thing that we're not supposed to be trying to have this witness make assertions about. Because on direct and cross, she said she couldn't be exactly sure about the time sync. But now we're trying to close out with her by letting her attest to certainty in synchronicity across these timestamps. Just bizarre. But I'm glad they rested. Surprised, but glad they rested. Mark also says, thank you so much, Mark. Did anyone ever do an explainer on the weird exhibit numbering system at use in this case? 397 VVD. Listen, I think they were using certain different structures. They tried to change it at one point. And when Whitaker took over, when Glanville was recused, they had to have Christina Weaver, the court reporter, go through, I think Brian Steele and another defense attorney pointed out that there were over 100 exhibits with some type of mismatch in the naming schematic. So an explainer, I think in simple terms, it boils down to it's just a hot mess. So good recall here. Good little throwback here. Thank you so much, Mark. Violet says, come on, Hylton. Don't act like you don't see the brake lights engage after the two white cars pull off and the other white car pull up besides the red car. Yeah, and then Viverito was trying to get ahead of that by saying it couldn't be, the car that was pulling up after because it was slightly misaligned. But the shot, we didn't really get to see the pictures. We kind of saw them on accident. But she described it as kind of like coming from this angle, like back here. So does it really make a difference if the car wasn't perfectly lined up? I don't think so. So good call here, Violet. And it did seem like Hylton was trying to clean this up. And I'm all for a counter argument, but I don't like to see desperate counter arguments time and time again by a prosecutor that's trying to convict someone with something that might be weak. So, yeah, KC Dog says she's nothing but a parrot at this point. I mean, it did seem pretty interesting, that whole identify these guns right after we have a lunch break, but I mean, what do I know? What do I know? KC3, thanks for the 5, says, if someone says they're riding around by the city, Mechanicsville is literally 10 minutes from downtown. The map proves that even more. Yes, and Viverito tried to say her counter to this, maybe I misheard it, but she said something like, they didn't leave the city. So did she take it literally to mean that they were going to exit the metro area and drive in a circle? So, haha, they didn't literally leave and drive in a circle, so they can't be riding around the city. I thought that was so nonsensical, the way she tried to. Nobody, when they say they're riding around, means literally driving in a circle. So, but she really tried to, like, reverse intelligence the counter argument there that the defense put up. And she sounded dumb. She sounded dumb. KC3, thank you so much for calling this out, because that's something that I forgot, but it pissed me off in the moment. Girl Ryan, thank you for the super, says, example, 11 billion of Viv's deception. Yeah, many examples. Freak out about being shown on camera in front of the jury, so they think she's more important than she is, but she's really just arrogant. Doesn't want to be seen being wrong. I agree. It really, like, I don't know. If you've seen me talk about other cases, I always give Florida their props. We have Florida man stories here, right? But pretty easy to access records, good amount of public access to courtrooms here in Florida. We have sunshine laws, and, you know, got to give the props. I think it's really important. Georgia, I'm glad this is televised, but with this being such a high-profile case, with certain witnesses that are all over the place, yet they're not being shown. Gaither is another example. It's not just Viverito. Flores, I mean, I don't know. Like, why are we not showing these people? Show them. And I get that the jury can still kind of see their facial expressions because they're sitting in the room, so it doesn't matter if there's camera coverage. They still have the opportunity to do a credibility read on the demeanor and expressions. But still, I think public access, I think, unless there's a valid reason, the public should have that access as well. And really the defendants, I think the defendant has a right for the public to be able to see, to have this public trial, where we can look at Viverito's face and say, oh, she looks like she's being deceptive right now. I think that's part of a defendant's right to a public trial, unless there's a basis, a good cause basis otherwise. And I don't know what that would be for Viverito, because she says that people love talking to her. So, pet peeve of mine, probably more serious than a pet peeve. It's not just like a personal issue. I think it's a issue of justice, but thank you, girl Ryan. Violet says, oh, good, Catnut Williams. I thought Burrito slimmed me and I was seeing things. Hey, now, they said that Burrito slimmed down, so she slimmed down. They said she went, and this is a quote, not mine, but Burrito is now a taquito. The only reason Burrito became a thing for me, guys, is the closed captions. So, but thank you so much, Violet. Mel S. Good to see you, Mel S. This is super generous. Mel S says, thank you for supporting Infamous Sly. Now, I was confused because I didn't have the other channel. So if you guys need to rewatch that, I had changed the pinned comment. But Infamous Sylvia's channel, she wasn't live on that earlier. She was live on Infamous Sly. So I can pull that again when the Law and Crime feed went down. So thanks for hopping over here, Mel, and no problem at all. But just to reiterate that out loud, because I was confused, it's two separate channels. So, but there you go. And thank you so much for hopping over here. Good to see you. Hope you're doing well. And no problem at all. And thanks to everybody in the chat that was like pointing out, especially the ones that specified look for Sly, not the Sylvia channel. Tina says, what the heck is her point? If you can't explain the brake light, then just zip it. Look, I don't know. You can't see lights at night, but you can see the body language reactions of somebody walking in a blurry shadow bush. So, Tina, it never ends. As Crier says, Hylton's efforts to get ahead of her issues are failing. I often felt bad for my adversaries, then I get over it. Hey, Kat, chat, and the mods. All love to the mods. Let's show the mods some love today. They were exceptionally helpful today, especially thank you again, guys, for looking out with that music playing. It is what it is. It is absolutely okay. Just please understand, if the stream goes down, it will be back. It will be back. Esquire, thank you so much for the 5 and for showing love. KC Dog says, I bet Fulton County hasn't invested a dime in more cameras. And aren't they like one of the last to get body cam for, their police force? Weren't they late to the game on that? So I wouldn't be surprised. I saw an article earlier. Let me pull it quick. The city commission. What's it? City commission. Let's see. The Atlanta City Commission approved like 1.7 million for the training facility or something. City Council. Okay, here it is. So Atlanta City Council also approved another 1.7 million for security enhancements at the site of the Public Safety Training Center, further highlighting questions around how the city is going to keep the complex secure once it opens. So just some more monetary funding here. But I thought of this because you're asking about, they're going to spend more money on cameras. So let me link to this here if you guys want to check this out. There you go. What else is new with questions about Fulton County spending? Them honey-baked hams, you guys. I think Viverito became a honey-baked ham today. Angie Lay says, this is what drowning Hylton looks like. FFS. Shout out to FFS. I agree, Angie. Lucia says, with the pick, there, you can see the victim's car move forward when they pull off. I hope the defense notices that. Guys, Doug has said that this is going to be a closing arguments moment, I really think. I think Max Schardt is going to get up there and he's going to show this zoom in and he's going to tell the jury, he's going to ask the jury, now, when you go back in that room to deliberate, watch this and see if you can see a muzzle flash at night. See if you can see the brake lights, right? I think he's going to underscore these specific things. He's put all the pieces together. Laid down the turf, put down the lines on the football field, did all the checks. It's game time, right? And I think he's going to deliver this in closing arguments. I agree, and the chat's noticing it. So and that's the point of a closing argument, right? You want to tie your theory, your argument together, but you also want to cue the jury into what you want them to think about during deliberations. So you want to sow that seed where you say, pay attention to that thing in that video right after that extra car pulls up. And remember what we heard about lights and seeing muzzle flashes at night. So I'm very excited for it, guys. Hope we can all get together and have one big closing argument party. Thank you so much, Lucia. And thank you for also zooming in and showing that angle. KC Dog says, I know what your tea is, Kat. They found the McDonald's tape. Can you imagine the Kool-Aid man barges into the courtroom with the reel from the Cleveland Avenue McDonald's? I can dream. A girl can dream. Let's see. Hold on. William Fagan says, paid by words, yaponomics. The economics of yentas. I love this. I do like yaponomics a lot. Thank you, William. Christy, thank you so much for becoming a member. Ike says the state's using expert as 4th down magic 8-ball again. Look. Look. The magic 8-ball, you like try to turn it, but the piece doesn't actually center forward, so it's just like a diagonal line pressing against the glass with no words on it. Yeah, that's the clarity we got there. Jeff J, thank you so much for the 20 here. Says, thank you for your coverage. This could have been over a year ago if they called this expert on everything as the first witness. Super expert. And now I'm thinking they called her. I really think they called her because she's giving an assertion, a conclusory read on what was in the minds of these individuals when they were sending their text messages. She's really crossing that expert testimony line, what she's supposed to get into. She's asserting things that the jury should be able to determine and that she should not be determining. But she's making a conclusion that's going to edge them towards what John Floyd is saying enough to establish an overt act in furtherance of this conspiracy to violate RICO. So I think that's why they called her last. Hearing John Floyd lay it out like really made that clear to me. But a whole mess, a whole mess. Like from the ESPN tattoo down to, you know, her just saying she knows something means two things. Seen and to see. Why are you changing your answer? Thank you so much for your support here, Jeff. And just a whole mess. This should have been over a long time ago. Orlando says, FUBAR. Yep. And I think this is right around the spreadsheet debacle. So there was no recovering that. Whitaker was not having it. KC Dog says, all Burrito's areas of expertise, the ankle monitor, cell phone, surveillance, social media, guns, gangs, hybrid gangs, tint. Yeah, they made her an expert on vehicle tint now. Or like personal experience, whatever. And I want to, can you imagine asking Hogan, you said people put tint on cars or whatever to hide their suspicious activity? Like, why was Viverito doing it? Let's apply the standard. Let's apply your dumb standard consistently across the board. Also an expert in tattoos, in bushes, in habitat viewing. Not on reports and watches, though. Yeah. Not on a pink Richard Milley watch. Richard me, well, I don't know, whatever. Legal Vices told me how to pronounce it, and I'm not going to get it right. My bad. I'm not a watch expert. But she knew that the other one was valuable. So is there something about a pink band that makes it, you can't determine if it's valuable or not? Right? Makes you wonder, why are you such a selective expert on the value of objects for the one thing that you put back up on the top shelf? And whether she took that watch or not, that did not look good. And remember, Juror 56. That fiery cross with the other officer about the missing watch. That email with Juror 56 was like the next thing we heard after that day. So I still think it pinched a nerve. It wasn't something that juror liked hearing the first time around. Imagine now. And yeah, the first thing, also redirect with Hylton. You know, the first thing you ask, the last thing you ask are supposed to be punchy. You had to bookend your redirect with your witness by starting with the question, did you steal the watch? That's not good. That's not good. STS says, so all Hylton would have to do is to have all of the operators testify that they synchronized to UTC, in spite of contrary testimony already on record. Yes, because we had I believe it was the BP guy that said he didn't sync up his cameras, right? We've had two different witnesses testify that they didn't sync something up. Maybe it was the FedEx guy, it was the second one. So, right, that would be contradictory to other witnesses' testimony, your witnesses. So even if we did all that, it would still be a mess. And I know this has to be irritating you. Thank you so much, STS. Sebastian Mueller says, Nick is going to have a field day with this. Oh, I can imagine. I can imagine. Just a pause, a moment of silence, and a long, long Nick Starro rant. A big Nick Starro rant, but not that big Nick or the other big Nick. Is he live, by the way? We can redirect over there when this is done. I'll set that up. You guys already know. Thank you for calling that out and the reminder here about the redirect. The accidental reminder about the redirect. KC Dog says, Hylton, you're down bad. And that's the thing. They said down bad. And let me close this. I just opened up YouTube and it's being funny. They said down bad meant that somebody was, you know, caught lacking and they shot him because they were lacking. And then Viverito actually walked that one back. That was one of the things she kind of walked back. You're just not fully covering your bases, right? But the state really tried to put forth down bad as a statement that was an overt act, right? Saying someone's down bad might not be criminal to say. But it's an overt act if we're saying that you're the ones that actually killed someone who was down bad. So let's use that terminology. Let's use it. Same thing in the way this is becoming viral, more and more viral. Angie Lay says, is tada a legal term, Weasel? Yeah, when Adam Abadi said the tada moment. Jeff J says, Simone has gone full on Miss Love. Yep. Wrong path to follow if you want a successful career. Yep, and I think people were giving Hylton some grace, right? I think Hylton had some fire under her with the ex parte stuff, how the way she handled Kenneth Copeland as a witness. But then I think people gave her grace. People came back around. They didn't really like listening to her questioning, but Adrian Love still got the brunt of all of the heavy criticism, the worst criticism. But the way she handled these timestamps, wanting Viverito to be able to testify to them, was a full-on Love moment, 1,000,000%. And not a good look. And again, this is televised TV. People can see you doing it. And then your co-counsel has to stand up and tag team assist you. So, KC Dog says this is the evil. See, look, you guys are in the same. Are you guys part of the same enterprise, approaching things the same way? Jeff and KC Dog. KC Dog says this is the evil spirit of love back in the court. Ike says they don't line up. They're just the same numbers. I love this trial so friggin' much in all caps. Thank you, Ike. It's just like idiocracy on full display. Biff, thanks for being a member for 2 months. Known each other much longer. Just saying, cat. KC Dog says, what else could happen? The movie is going to be epic. I do think the comedian Joshua Johnson really nailed how this case has moved forward. But seriously, and he did it in a shorter time frame. He did 45 minutes or something. But seriously, a Netflix series could be multiple seasons. And people would watch it. I'd watch it. I don't even have Netflix, so find a different way to watch it. But somebody out there, if they put it together, could get a lot of viewership, I think. That Girl Shine says, I'm so shockingly excited. Is this real? Yeah, this is when we were approaching the rest. Crazy. KC Dog says, this got my blood pressure up, Your Honor, in my Woody voice. Oh yeah, we got this, but a lot of moments like this, right? And don't forget, Antonio Sledge said the same thing about love. Mocha is me. Good to see you, Mocha. Hope you're doing well. Mocha is me, one of my favorite upcoming YouTube creators. And again, Sapphire Ridge News, friend of this channel, friend in the chat, very kindly, and I think the reason he did it, sent me money to pay it forward. And Mocha is me is one of the 2 channels paying it forward to. We want to see you guys grow, share your voice, give your thoughts, love your commentary and insights. Mocha is me. Really thought it was awesome that Sapphire Ridge News stepped up to also support. Cannot wait for your Saturday stream this weekend. Guys, sorry to rely on you in the chat mods, but if someone could drop Sapphire Ridge News link and Mocha is me, that would be extremely helpful at this point in time, to quote Judge Glanville. Thank you to the mods. I don't know, every time I'm pulling up YouTube, it's locking the screen up today. MT says, Max, ask her why she was out searching the bushes. Oh wait, I had the bush up already. It was there. And looking for the homeless man and not the 3rd car if it wasn't her investigation. That will never make sense to me. They don't look at these other vehicles, but they're so insistent that they knew what was going on. Well, not they. Viverito was so insistent that she knew that person walking didn't jump. Selective blinders. Great point here, MT. Squirrel Brain Gang says, I took Dave 911's advice and changed my profile pic to Viverito. Oh, we have Squirrel Brain Gang in the bushes. Your account has been top tier throughout this trial. I love it so much. And I hope if you If you like trials beyond just YSL, I hope that if you continue to watch trials, you carry this theme on. Whenever there's like a shady, wishy-washy police officer testifying on the stand. I love it so much. Love it so much. A Squirrel Brain Gang says, I took Dave 911's advice and changed my profile pic to Viverito. As you can see, she's back in the bushes. By the way, I'm a few minutes behind and very much enjoying the yelling by the judge. Yeah, that was a great, great time. Love this so much, Squirrel Brain Gang. Slime Rose with a 5 for the S says, thank you, Kat. Stay amazing to all our slimes. Heck yeah, we are on it. Thanks for being here, Slime Rose. We are glad you're with us. KC Dog says, when Doug asked Paige Whitaker not to let Marissa Viverito talk to the state over the weekend. I think this was Schardt that asked, but same deal. Did the judge say not to look at the trial-related material, too? I think Viverito was already out, and this direction was given to the state. I think Viverito was already out of the room, so they were just telling the state within their capacity not to speak with their witness now that they were actively on the stand and sworn in. However, there was a point, I don't remember the issue, but Whitaker did say you're not supposed to be looking online at this trial. So, still an issue either way, although this was Max Schardt and a question asking Whitaker to direct something to the state here. So who knows? I mean, it could just be a difference in the state. Because she is a half expert witness, half fact witness, maybe Whitaker didn't think it was a big deal that she was watching the trial online. I don't know. Because in other states that wouldn't fly. So I don't know if it's a state thing or because she's like a hybrid witness. So. All right, so Ocean Beach is saying no, she told Viverito. I don't know, but you're talking about a day, not when Max Schardt specifically asked the judge to instruct the state not to talk to their witness. You're talking about she also told Viverito in a separate instance. So, and yeah, she should have known, I would think, because she's, yeah, sorry about the hybrid witness. We're gonna just call her that. But yeah, she should know this. She should have enough experience about testifying. So, yeah, yesterday. A whole mess either way. Angie Lay with the very positive words here says, can I just say I love you guys in chat? We get it. Aw, love this. Hawaii Turner says that ho 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 done pissed me off. And right in line STS says, in the valley of the ho 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 burrito. I love that this rhymes. Love that that rhymes. And this is going to be a Streisand effect. And I mean, maybe she said this in the hallway. And what it was, guys, is like a body apologized to Kayla in a message, which is how it was confirmed to Doug Weinstein that this actually went down, right? Because there was someone acknowledging it in a message from the state that this won't happen again. So Viverito did unsolicited, make this comment to Kayla Bumpus in the hallway outside of the courtroom. Big switch up from how she's trying to present herself on the stand. And then a body to get up there and like argue the way he did when it's your message that kind of got this to become an issue. Because you're the one that, you know, kind of corroborated it, right? So, but love that this rhymes. Love that this rhymes here. Y Turner says, keep in mind, she approached Kayla first. Allegedly, if YSL said it, it would be a threat. And that was my problem. I hope that came off clearly. The way that Whitaker was like, well, that doesn't sound threatening. Well, it's the same type of thing that the state and Viverito herself is arguing. This YFN Lucci message, if I didn't like the way you treat your mama and kids, you would have been dead or whatever. This 24 million on the forehead. Oh, has $24 million and he's the leader and this is tied to someone else's bounty. Like, that's the hypocrisy there for me. Is I get that it was a slick comment and probably just verbal. But at the same time, when we in this very courtroom, this same witness is telling us that same type of delivery is decidedly, because she determined, a threat. Apply the same standard to yourself. That's all I ask. That's all I ask. So, MT says the state needs to end this. dead horse. It's been a trash poop fire. Trash poop fire. There you go. There's my vanilla reading of MT's emojis. Big love here for MT. I love the pictograms, the pictogram messages. Shannon Alexander says, wait a minute, let's talk about the blowout in the hallway. LMAO, Burrito and Kayla, she's calling her a hoe. What's really going on? That's what it is. It was a walk by, unsolicited, out the mouth. Like, you ever have someone do that to you? They're walking by and they say it real slick out the side of their mouth, like nobody else is gonna catch it but you, so they won't look like the bad person because you're the only one that'll see it. And if you let that fly, if you don't call it out, that person will look like they, hands are clean. So, but yeah, what's really going on? Always something in this trial. MT says, no way the judge allows a last-minute witness. That list would have had to have been turned around weeks ago. Yep, that would have been weird. And again, I really think that the defense not calling a case in chief is strategic, because can you imagine on rebuttal the scope, right? We always see the state trying to go beyond the scope of direct and then cross, whatever. If you put on a case in chief, you're opening the door for a rebuttal opportunity, which could have been a whole nother opportunity to have somebody else come in and clean up the things Viverito messed up. And maybe if that happened, it would have been the same slippery slope that it just gets worse and worse the more they try, right? But still, I think this is very strategic by the defense. I know everyone's worried, and I'm sure the defense attorneys are worried, right? They have to weigh their risk, the pros and cons of the strategy, but they've made a certain decision that I think has a lot of advantages. Fashionably fit life, great to see you. A body is a messy bee. He couldn't help himself. Yeah, body yaddy. Oh man. Yeah, he really couldn't. The ta-da moment. I know he hasn't been in this room very many days in this trial, but he's always got a little something extra to put forward, doesn't he? Orlando Antonio says, do you think the state will call someone else? I'm glad they didn't. I wouldn't have been surprised if they tried. So I know I'm getting to this late, but that was my stance. Then I'd be glad if they don't. Won't be surprised if they do. Same stance right now. Thank you so much, Orlando. STS out here sniping. Thank you so much. Let's see. Splice S says, why? This is about John Floyd. Too much babble. Bye-bye, dude. It's because he's trying to help offer insight on what Georgia RICO statute says, and anything that isn't super clear, he's making the argument really on behalf of the state, but also kind of, there is some type of reverence here for him, but it is uncharted territory. So went on my spiel about this a little bit earlier after you'd said this, but he's there for a reason. Whitaker's clearly trying to listen to him. I think as just a law nerd, this is something that Brian Steele would have loved to have been part of this trial for. Harvey too, obviously, I guess all of the attorneys. Carton Matthews probably too. But we are going to see some, it's a bigger gray area than normal. How do we figure this out? So we're going to see a lot more of this. And John Floyd was in here to help with the state side. So unfortunately, his babble is important. What would they call it? His expedition. And Whitaker is taking it into consideration, although I think she's done her reading. I really think she's done her reading to try to look for the answers. So, but yeah, it's a lot. There's a lot to listen to, and I probably got to listen to it again. Dimples Dawson says, glad this is over. Cat waiting on your summary. I'm flipping in the reverse here because we're behind on these. But thank you, Dimples. It's really nice that you're looking to see my thoughts on it. Sorry, I don't know more than going to defer to these experts here, the judge and those in the courtroom there. But the stuff that I did take away, I feel like I was learning a bit listening to it, excited to keep learning more about it. And I think you can see the area of why it can be so problematic when your investigators tunnel vision and see what they want to see in something where things might not actually be there the way they say they are, right? So understanding the scope of this RICO or conspiracy to violate RICO, a little bit of a sore topic, right? So boring, wordy, but important. Now what now says, with the yawn face, says, how are they on trial for charges that the state and judge don't understand? I mean, that's kind of like the new frontier part of it, right? It doesn't feel right. It certainly doesn't feel right. And really, in that type of scenario, it seems like you're requiring a defendant's day of justice to possibly wait all the way down to an appeals court, or a higher appeal court, or a higher appeal court, or a higher appeal court. And what does that mean? That means time, right? So when you deal with like a novel issue in law, and the trial court isn't sure how to get it right, and maybe they do or don't get it right, the parties argue about it and appeal that decision after. It's like you're starting from the very beginning knowing that you're giving a long road to this particular defendant or group of defendants to actually have their answer. Did they break a law? Well, just wait until you go through multiple judges to get there for an actual decision. So it's not going to feel right. It's not going to feel okay. And that's it. I guess that's like, it's kind of all I can say there. So Jennifer Devine says John Floyd is a snake oil salesman. A little bit. I can see this a little bit. I thought he did concede to certain points. I don't think he tried to overrepresent. I think when he like got off on a tangent, he kind of like went up here with his confidence in what he was saying. Like the more he was talking, the more he accelerated. But once it was a back and forth conversation, like, and this is kind of in sales too, right? You control the conversation. If you lose control of the conversation, you're going to lose your prospect. They're going to wrangle you with their objections. I think Whitaker started to outsales him. She started objecting to his explanations, asking more questions. And he was conceding to some of her points, which in a way I have some respect that he did that, because we wouldn't see that necessarily from Hylton or Love. Maybe Abati. We wouldn't see that from them. But it was very much like a sales conversation. He lost control of it though. So yeah, I think a little bit here. But he lost his footing. Not so good. If he was trying to sell some cars, I think the people would have some leverage over him. Brian B says, for Steph JK, she is the queen slime of the chat. Love Steph JK. Guys, just FYI, I do put the mods information, anyone who is willing to provide it to me, right? Not all mods are willing to. But their cash apps in the links of our live streams here. So thank you so much for appreciating the mods here. But just so you know, there is a separation. Like, I don't do accounting for what comes in through this chat, and I'm so grateful for you guys for sending stuff. Don't really have a way to decipher it, right? YouTube kind of just like puts it in a big ball, and then 60 days later we get 33% removed from it and sent our way. So D. Critchlow says, Kat, love how you do this channel, only watch yours. Thank you so much for the kind words. I do love my friends out here in the YouTube space, so I want to show them love too. And do hope that you keep in mind that there are other, if you like this chat, like the community, the way this is built, I think there is a lot of spillover with some channels that are still growing. So thank you for the kind words on my channel, and hope to bump into you on some of those other channels that I think are really, you know, have the same type of welcoming, warm, and you guys are so insightful in the chat too. It's not just like you're fun to hang around, but do learn a lot from you guys in the chat. And I think D probably, I'm assuming here, but I think one of the things people love about this channel is the chat, not just me. So thank you again, D. Touche says, I just want to know how the jury is reacting. Me too. I want to be in like the bushes of the courtroom, like looking over. Man, if only. Love it. Finding good, and I hope you've been doing all right with your work lurking in the bushes today, Touche. It's been a day. Finding good says, is it PB&J if you cut the crust off, or is it a hybrid? Well, I think that's just uncrusted PB&J. I think a hybrid might be like, you know, when people put like pickles on a peanut butter sandwich? I think that's getting us into hybrid territory. I'll defer to the chat on their expertise here with their peanut butter and jelly sandwiches. Joanna says, Max asked Burrito if it is okay if we hear what we hear. Oh, he's so slick in such a nice way. Right? Like, there are some attorneys, and I get why they need to do it sometimes, but they really do come off like they're badgering, right? Just like beating on a witness with their words and their questions to a point where it seems unnecessary. But when Max, like, is making his case about, your logic's stupid, he does it in a way that's just like he's calling out common sense. So, right, to say like, well, is it okay if we hear what we want to hear? And she paused. She paused in that moment. So thanks for recalling this. She did not want to, she knew she couldn't say, like, no, it's not okay for you to hear what you hear. She knew she couldn't say it. But she paused. Love it all. Love it all. Oh my goodness. Let's see. KC Dog says if she had a similar experience with Tint, wouldn't it be her witty comeback to Max when he asked her? This was such a good point when you raised it, KC Dog. It's still a good point, but I mean, like, you were so sharp for noticing this. Like, the way her demeanor is, she has no problem. She's not just a yes or no witness. So she comes back after lunch. Hylton cues her up with this question about her personal Tint experience. Did she really need to be provoked? Why didn't she just give that same experience anecdote when talking to Schardt with the Tint? I have no doubt in my mind we've seen how she answers questions. You would expect her to give an unsolicited long story of, well, actually, let me explain. She has no problem talking about her personal experience. So why did it need to be solicited? This was such a good point here, Casey Dog. This is so good. This is so good. I loved it. Thank you so much for sending it as a super. Tracy Fagan earlier had said, well, now they can ask Boyer. He was arrested in DeKalb County. My question, were you in the fourth car? Yep. Boyer is such a weird... It seems like the state didn't want to talk about him, and at some point they realized maybe they had to. But at the same time, Boyer is facing charges for a triple shooting, resulting in at least one homicide. I think one of the 3 victims passed away. So, I mean, at a gas station, too. It was a gas station shooting. So why are we, like, twinkle-toeing around mentioning him in this trial, and then suddenly we want to say that he's in Nichols' car, and we don't hear that until yesterday after the jury's gone, and Schardt just ends up embracing it? Like, it's just weird. It's just all around weird, and I don't know exactly how to decipher it, but something doesn't pass the smell test. So, oh, man. But yeah. So, great question there, Tracy, and kind of seems like they really want to say he was in Nichols' car. Which I think is a smart move for Schardt, right? That's probably why Schardt adopted it. Because if the guys that are supposed to be YSL are only in car 1 and 2, what the third car does can't be wishy-washed in as a conspiracy move with the other guys, right? So I wonder who exactly was in that third car, but the state never made the argument that somebody associated with YSL was in that third car, right? If they tried to make that argument, it'd be a different question right now, because there could still be some conspiracy overarching issue. I think the state messed that up. I don't know. Brian B says, if we can get to 2,500 likes, I'll gift 10 memberships. Well, this was really nice of you to issue a challenge. Thank you so much for doing that and supporting the channel. And then look at that, gifting 10 memberships here. So I got you in the banner a long time ago. I'm behind on getting to these, so very sorry on that there. But this was super nice. If we could get some Brian B's in the chat, that would be super awesome. Shout out here to Brian B. I don't know why it took me a second to get this. Peter Ortiz said, can poison ivy affect a burrito? It took me a moment to get the Bush reference and Viverito. Because I'm assuming like Peter Ortiz always talking about food. My brain went to food burrito, not Viverito burrito. Can you imagine if one day she showed up and she had poison ivy and she had to tell the whole office she had poison ivy? Like, obviously, we're going to guess why. We are going to guess why. Peter loved this here. Why Turner says, Fani, nor the state should be able to say RICO. Just take it out of their vocabulary. Thank you so much, Why Turner. Esquire had said, yeah, Esquire was ready. Hello, chat. I'm here for the recross. He's like, let's move on from the redirect here. I just want to get right back to recross. Got my popcorn ready. Great to see you, Esquire. David Newth says, oh, okay, so we have a video. All right, I got to find it. This muzzle flash question. Or you can't see muzzle flashes at night. Sorry, my notifications are like not great for this right now. Let me find your profile. I mean, I just thought that was such a disingenuous answer as somebody that doesn't really know the difference, right? And you've done great explanations throughout the day here, which aren't great for the state. But really, like, we were able to pull up, let's see. All right, here it is. Okay, let's switch over here. All right, so the muzzle flashes at night. Okay, wait, let me open this video. So it's a Glock 22 full-size 40 caliber, Smith & Wesson. Was that me lagging? Yeah, hold on, let me pause it and let it get going. And I love that it's like muzzle flash with the happy face. Like, yes, we know there's going to be a muzzle flash. Why is it doing this? All right, I don't know why. StreamYard has not liked any time I've pulled up an additional video window at all today. Maybe we can just get to the frame. Okay, I might have to link it for you guys. So I'm going to link this to you guys here because this is a struggle bus. So my bad on that. Maybe we'll just let it sit for a minute here. I don't know. But thank you for that, David. My bad that StreamYard's doing a StreamYard thing. My YouTube, when I look at my YouTube stream health, it says excellent connection. So I swear it's just StreamYard interacting with YouTube funny. So let me pull this down. Yeah, so just be me with Marissa in the bushes here. And right, it's like better now. I don't know. StreamYard is StreamYard sometimes, guys. I don't know. My bad, David. That link is in the chat if you want to check it out, but it's not cooperating to play. And I don't think it's my internet because it says my speed is good. Chill Panda says, you should have posted the state scrambling and scraping. They're still doing it. I really think they're scrambling to head out to closing. I don't think they're going to have all their ducks in a row. So who's surprised though? Who is surprised? Michelle says, with all the social media posts, I wonder if she, quote, worked from home during COVID. Oh, good point. Right, just sitting there waiting for a notification to pop up on the people she selectively decided to follow. And piss poor investigation skills. Yep, I agree. Good to see you, Michelle. William Fagan says, consider this is their closer. Down, bad, bad. Yep, you know it's bad if you say it twice. So 100% agree here. And I mean, even I think the things that they tried to save, they didn't really do a great job. I think the number one thing they tried to save was this mention on the wiretap call of, you know, they're not going to find gunshot residue on the thing. And they got up there on redirect and tried to say, well, it was unsolicited. Why would he just think to volunteer that over the phone? Right? But then you have Schardt get up and make a great point. He makes a really great point that, well, Garlington's not the first person he's speaking to. He's spoken to officers. You guys, when you guys suspect, and he really did a beautiful job not cueing her into where he was going with the point. He is like, when you arrest people, you know, buffering her up, bolstering her up, right? You inform them that what you're looking at. You tell them why they're being arrested. You tell them these things. So Shannon Stillwell had already gone through all the motions, knew what you were looking at, may have already seen more specific things because you sat, don't forget these defendants, we didn't get to see it in trial because it's confrontation and Bruton issues, but they sat and were interrogated by police, right? So in that whole time period, Viverito could have been saying, you know, we know that you were in the white Audi. We're going to test it for gunshot residue. So Schardt did a great job of pointing out that all of that would have happened before this call with Garlington, that Hylton's theory was, why would he think of ever mentioning that? That, well, I don't know what they're looking for. It's going to come back clean because they're not going to find gunshot residue. She's trying to make it seem like the only option is that, wink, wink, they're not going to find gunshot residue, and read between the lines that I got the car cleaned from top to bottom. And Schardt did a great job of making that look even dumber. So I agree, William Fagan, this is their closer. It was down bad. They tried to fix it, and I really don't think they succeeded. So KC Dog right here says, that was so lame, Hylton. So there you go. That's a lot of the sentiment here in the chat. Diamond Dave says, Kat, he needs to harp on her analogy. Medical examiner said bullet came from behind diagonally on drinks. Yep. I think this is going to be a closing argument, though. So I think this is going to be a closing point. And I really don't think it matters if the car was slightly misaligned, right? If we don't know how long... What did he say? Now you're an expert on 3-dimensional spacing or something like that. Like, yeah, another list of things that you are an expert on, Viverito. You're so good. You're so good. But just because a car could be offset and the car Drinks was driving was older, right? You could see when they took the pictures of the scene, it looked like an older model, like the crank arm on the door. I feel like cars used to just be a little bit shorter unless, you know, certain classic styles. I feel like his car was shorter anyway. So just because one car might be, I wish I had two things the same size. But if like you're insisting that the back of the car is, let me use these fingers. If you're insisting that one car is like here, this is the back of one car and this is the back of the other, it doesn't mean that the front windows aren't aligning. The length of the car could be different so that the front windows are actually aligned even if the back isn't, which makes more sense logically if people pull up to the line at the stoplight, right? You would expect the front of the cars to be aligned, and then whatever extra length one car has would extend further in the back. So this was a whole stupid argument that she was trying to point out and get ahead of. Like, it's like she got up there and knew. She wanted to make sure no one would think that it could be that extra car that pulled up. And this was her reason why. I'm not sold on it. Absolutely not sold on it. And there you go. Okay, Liquid Zero. Yeah, this is in a Charger's a longer car. Right, so if that was a Charger, I mean, there you go. That's that longer body of a car. So, right, I think, Joanna, this is better than I can say it. The examiner said it came from behind, and Burrito kept making it known that the third car was behind that. So, you know, kind of actually helps Schardt embrace the medical examiner's theory. He's not trying to dispute it. And Viverito, by saying that, kind of makes it seem like it makes more sense. So, yeah, and now I need a pronunciation. Would the N be silent here? Is it like Defor Divine? So, are you really trying to understand Hylton's theories? Right, what am I doing when yesterday she told us that she couldn't be sure? And Young Dro says, what's crazy is Kayla married Shannon. She is so-called friends with Woody, who snitched on everybody. Hey, man, you gotta ask yourself some questions if you follow those dots there. So, there's a layer there, and I don't have answers there. I don't have answers. But what's coming to mind for me is Doug Weinstein's cross of Kenneth Copeland. So, and you guys are totally free to have your thoughts and views and conversations and everything, but that's what came to mind for me personally, thinking about this myself, is the Doug Weinstein cross-examination of Kenneth Copeland. Let's see. Positive Q. In my page voice, is this a joke? Right, like, is this for real? She did a lean when she said it too, right? Didn't she lean? She gave a good old lean. There was one point in the trial today where Doug, I don't know if it was cross or recross, but Schardt was questioning, and Doug was sitting at like a 40-degree angle. Like, he was almost behind Kokomo. So, oh, I love the leans. It adds a whole new layer to the flavor there. Positive Q, love this moment. Let's see. Sonia says she wants them in jail by any means necessary. I really think so, and I think that's sad. She's in the position to put people there, and she's got this mad scientist obsession that that's her goal. It's not good. Violet says, I find myself doing the Cadnut Williams side during the day just like you. My bad, my bad. I don't even know. I know my brother does it. I don't think my mom does it, so I don't know where we got it from. But, like, ever since you guys pointed out that I do it, I noticed that my brother does it. So, I don't know. I guess it might be a family thing that we picked up. But definitely, you guys are absolutely right. I do a sigh. It is like a tick for me. Michael Billups says, did anyone point out that the state wrongly described the left lane that drinks as a turn lane? It isn't. It's a one-way street with traffic coming. Drinks got stuck when the car came speeding behind them. Hold on. I know Bama Rose did a breakdown on this. Let me... Might have to pull the screen back up real quick. Okay, so let me share this, present the screen. And I'm going to link to it because I know definitely not the best to try to look at something on a screen of a screen. So let me link to this and retweet it for visibility. And I actually saw this going back for David's share of that video with the muzzle flash. So thank you for having that happen, because that's how I also just saw this, and it's really relevant to Michael's comment here. So here's Court Drama's post, or Bama Rose here in the chat. But let's see. So this is a top-level view of the intersection with the King's Liquor Store here. And this is like where the intersection would be that we're about to look at. This is the FedEx building, so camera angle somewhere over here. And zoomed in on a closer view of this here, the red is obviously, you know, Shamel Drink's car was located here. So this can kind of give you a better picture of the road. It's splotchy because that's how sometimes the satellite imagery is. But definitely advise taking a look at this. We got Viverito in the bushes where she was canvassing. Hold on, wait. Let's get her like really in the bushes for real. She's like all the way in there. She is now the bush. Good times all around. But this is a great diagram if you guys want to get a closer look at this I-20 Windsor Road and the off-ramp leading up to it. And I really think it's bizarre that the state wants to argue it's so weird that people were here, but it's a huge gas station with a ton of pumps that sells the type of wraps people want to buy. They have tons of peach rings in stock. It's not weird that there's a certain gas station that gets a ton of traffic. There could be multiple reasons for it. So I get that it's circumstantial, but how convincing is it that multiple people are at the same gas station and then leaving the gas station to go to this route, this I-20, right? It's not weird. It doesn't necessarily mean that this car was being followed, that another car that's leaving a gas station right off the exit also comes back here where the ramps are to get off. And I'm assuming the on-ramp is over here off screen somewhere, right? It's not weird. So great questions there. Yeah, Asiatic, I think like everybody goes there, right? Like places just have a certain area. Thank you again, Michael Billups. Yeah, so I don't know. I don't know if Schardt like pushed back on that. I don't know. And it could have also been possibly that he was waiting to make a U-turn. I don't know. Some people do weird things in traffic. I don't think that was really touched on though. Chip Ewing says, is Viverito black law student? Is it because of the V in the name? I don't think the voices match up. The voice matches Viverito's voice. So I don't think so. I don't think so. Oh, but this is hilarious. And good to see you, Chip. Chip, you have, you know, this is humorous, but you have great insight on the information in this trial. So let's see. Jimmy Barton, thanks for becoming a member. STS, okay, I think I got this. So I was taking a second here to, it's a tie to me, and I think this was the Adrian Love or Marissa Viverito, who's kind of like the worst of the two. So I think that's what this was about. And STS says it's a tie to me. Yep. A lot of comparisons, right? A lot of different people in the chat are making that comparison between the two today. So I think that's what this was about. Correct me if I'm wrong here. Peter Ortiz says, she believes she's superior and important. Yeah, I think that's clear as day. I don't really think that there's someone left in this chat, at least at this point of the night, that would say otherwise about Viverito. Amy Doublehead Jarvis says, retired 911 dispatcher here. That's cool. How embarrassing to be associated with APD and their faces had to be shown. Right. Right, they're showing like Latner's face. They've got to be shown. When they're just, quite frankly, they're here to bring in the CAD reports. But this liar gets to hide while she testifies. Right. And was it Cheeseborough? Kenneth Cheeseborough? Didn't he ask not to be shown on camera? He's the Samaritan, and I think he was shown, right? He asked not to be shown, but then he was shown. He's the good Samaritan that ended up making the 911 call when there was just this car stopped here at the light with Shamel Drinks deceased in it. So, I mean, what's the need for him to be shown compared to others? Right? You know, it just seems a little bit imbalanced. So this is a really great point here, Amy, and great insights. Appreciate that you're a retired dispatcher and have that insight, right? You're just there to bring in the CAD reports. But we get to put you on blast, and for Latners, we get to call you in like a million times. Oh, Miss Latners finally gets to retire. Thank you again, Amy. Love the dog picture. Jennifer Devine says, Cowboy Cop Al Hogan had tunnel vision on direct, but on cross, when confronted, he told the truth and backed down. This girl, just crazy. Yep, she will not concede anything, and that is really not a good look. I think her testimony, this cross-examination, even halfway through the cross-examination, is something that you could show someone as an example of why this type of demeanor is bad on cross-examination. And you don't need to see the rest of the trial to see why, right? Just in isolation. Her testimony, you look at it in isolation, you knew nothing about this case, I think you'd still get the impression why it's not good. You don't even need to know that the state has hinged their bookend of the case with her grand finale. So. Oh no, am I getting the name wrong? No, who was the guy, the Good Samaritan that called? His name was like Cheese something. Cheese Bro. Maybe I have the first name wrong, but I saw his last name was Cheeseborough because the closed captions kept calling him Cheeseburger. So, my bad if I'm like confusing names, but I am talking about whatever witness it was that called in that there's this car here at Windsor Road on March 14th. Antonia, thank you so much for the 2. Ike says, Miss Viverito, I knew you were going to be dying to say that. Oh, that was so good. That was such a good moment today. So many moments. But I will let you explain how you knew people were going to die or be uninjured later, okay? I love that call out. Okay, good. It's the same name. Yep. Yep. Absolutely here talking about the Good Samaritan here. Kelly G says super passive aggressive and argumentative. She also told lies to be honest, like the value of the watch thing. Yeah, and like she didn't need some of that was like in her run on answers. Some of the stuff that she got caught up on wasn't because a specific question was asked and she had to answer it. Some of the stuff she got caught up on was just like, all right, you're just going on and on here. Now we get to probe at that and show that you're going to be inconsistent the next time you have to talk about it. This lady Viverito. And I'm so backwards here. I had talked about this earlier in shared innocent bystander channels thing, and then it went away. But I do want to shout out innocent bystander channel again. I didn't see it in StreamYard to pull it back up at the beginning of the stream, and now it's here. That had also happened with the more recent comment with Mel S. So, and I don't think it's StreamYard because, I don't think it's YouTube because I can see it in the back end of YouTube here. But for whatever reason, I couldn't pull it up and now it's here. But the very beginning of the stream, so if you guys haven't been watching all day, I had shared a link here. And you guys you might be familiar with Innocent Bystander. We talked about how he did like a 16-minute how we got here, summing up the pathway to this gang RICO prosecution. But he also did a video on Kohberger. And I don't know, it just did the thing again. StreamYard's not liking something today. So let me close. I had the YouTube window open to pull this channel link. Let me close it. StreamYard's going crazy. But I know a lot of people are interested in following the Idaho 4 trial, Kohberger, and Innocent Bystander just happened to look and see that he did if you haven't been following and want to get into it and get a rundown of what it is, how we got here, or if you just want a refresher because you've been following this for so long, I know a lot of people are interested in that trial. So make sure you check out Innocent Bystander channel, especially if you missed the link share earlier this morning. But yeah. I don't know what's going on with StreamYard here, so sorry about that. I think on your end, it just makes me go like this and freeze. So it's every time I open a tab today. Thank you again, Innocent Bystander channel. A sponsor here with the gifted memberships in the banner, but I'm really late to being able to pull this up on StreamYard. And then this one too, I think was gone because this is from 1051. Good morning, Cat, Slat, and Chat, and Benevolent Mlat. Did everyone take their blood pressure meds or their CBD this morning? Oh, it has been a day, a blood pressure rising day. So very sorry here. I'm getting to this one late. Curious Coco. Thank you so much for sending the positive thoughts this morning. Struggling a little bit with these chats in StreamYard, but this is really kind of you and also hilarious. Very hilarious here. And then let's see. This is the time. Thank you for the love here. Violet showing love here to Innocent Bystander. And then, yeah, I think it's really nice, especially we're overloaded watching these full days of trial, to go and have a clip somewhere where it's like 15, 16 minutes broken down, summarized all in one place. And with YSL, I know like Cuff Boys and I'm Not a Lawyer and sometimes Seti Nash will do these like recaps of moments from the day as well. Like all that stuff is extremely helpful. So if you're looking for something like that with other cases, Innocent Bystander is the channel to go to. Am I going to do the Kohberger case? I don't think I'm going to like stream it or watch it. I think that's something I'd really enjoy watching in somebody else's chat, being the viewer, being the audience member, probably over with Andrea Burkhart. I'm just guessing she's going to stream because she's been doing very detailed coverage and analysis on the case so far. So I will probably be a lurker, not necessarily a lurker, but in the chat there. So and then Michelle, thank you so much here. Some make one hatchback and sedan. It's different. Like, right. Like, I don't know. It's like she just was looking for any reason to cast doubt that it could have been the car that pulled up after. And her explanation doesn't eliminate the possibility whatsoever. Right? Like, you sound dumb implying that all cars are the same length. Like, in what world? In what world? Especially when you didn't even look at the car. So, but yeah. And no, I just want to be clear here, Black Unity. I'm not really giving props in the way that you think I'm giving props. I'm just pointing out that there are actual sunshine laws in Florida state, right? So there's actually statute that protects access to trials that don't exist in every state, right? So doesn't really have any bearing on the demographic makeup of a case or what someone does to try to prevent something from coming to light against a co-defendant, a defendant in a trial. But there are just statutes in Florida that don't exist in other states. And then also, this is the time of day where we are rerouting here. Sapphire Ridge News is going to be live. It's going to do that blocky, choppy thing. Give me 1 second to pull the link. Because I can set up the redirect. Let's see. Customization. And we will take a trip over. We'll take a trip together. All right, well, hold on. Let me pull a link. I told you, redirects on YouTube, they don't always populate everything, so... Oh, you don't have it scheduled. Okay, so I can't redirect. I can't redirect if something's not actually scheduled. But here is a link over there. What do we have actually live here? Oh, so Dolly Talk is... Are you guys following the Craig Lewis? Oh, and then Nick is live. If you guys want to go, we can do a Nick redirect. Because Nick is live now. So we'll do that. That's YSL content. Dolly Talk is also live, you guys, but it's a different trial. So we'll do that. We'll see 9 a.m. tomorrow. I don't know if it'll be a full day, but it seems like it might be. So we'll do that. Yeah, let's do 9 a.m. tomorrow, guys. See you then. It's going to be a non-jury day with this directed verdict stuff. So interesting stuff to watch. And I guess a little bit more on the jury charges. So we'll see what plays out tomorrow, but it's a non-jury day. And seeing here Sherelle saying, wait a minute, is that an appropriate left turn or am I tripping? It looks like the crosswalk is facing oncoming traffic. Yeah, so this is an off-ramp with it's one direction only, right? Where these two lanes, let me get my mouse on the screen. These lanes over here would be like a left turn over to go under the underpass, maybe. Like you see the lines follow this way. Maybe this is a left or straight and it could go this way. And then this would presumably be like a right turn only, this like curved one, but it's all one direction. You're not supposed to turn down and go on this ramp. So for this to be a turning lane wouldn't make sense because there's no way that you're supposed to be able to turn down this way. So there we go there. So you're not, I think you're seeing that there's an issue here, and there is a little bit of an issue here if the state's trying to characterize that he was sitting in a turning lane, right? So, but there we go, you guys. Nick Star is going to be the next destination, so hope to catch you over there. And thank you, mods, for holding it down, especially with the links today, as you guys always do, but my stuff was freezing up real bad today. Appreciate everybody, and see you tomorrow. Bye!